And we are live. What is up, everybody? Welcome back to the stream. We are here doing day 2 of the Cardi B trial, and there's a lot more to get to today. So hopefully y'all are here for the ride, ready to enjoy the show. Let me go ahead and get my my camera squared away. Gotta give it a second, of course. Y'all know the drill. We gotta give it a second, let people get in here. Let me go ahead and take the link and wait, no, that's not the link I need. Hold up. Dismiss. I'm getting it. But anyway, hopefully everyone's having a good day, a good Sunday. Everyone got some good Jesus in this morning. And yeah, it's here ready for a great stream. We're still getting caught up for day 2. Get shareable link. There we go. Let's do this. Boom. Here, I'll show you what we're working with. We're live now. Tap in. If you're watching this back on the replay, you're probably just like, get to the video already. But no. Boom. Coolio. But yeah, hopefully everyone's having a great Sunday. Like I said, get your Jesus on. What's up? Glad to see you making vids again. I never comment, but you covering of the Tory Lane stuff is A-tier stuff. Boneless chicken nugget bone. That's why you my guy. You my dog. Comment or no comment, it is A-okay. The fact that you're here, you're supporting, that's what matters. And yeah, the Tory Lane stuff. It's funny, even watching the Cardi B trial. It's like so much of what we're seeing in this is like come out first through the Tory Lanez trial, just like similarities. And so it seems like Tory Lanez was just a good example for so many different issues happening that we get to see happen in all these different trials now. But yeah, so boneless chicken nugget bone. When fill us in, what was the first Tory Lanez video you saw that I did? Because I know I did a lot of them and definitely stayed up to date with that. We're just waiting on the appeal to come back now. We'll see how the appeals court rules on whether or not to either overturn the conviction or probably order a new trial. That'd probably be my guess, honestly. What's going to happen with the Tory Lanez case is the appeals court's going to order a new trial specifically based on the confrontation clause being violated by the fact that the judge let in Kelsey's entire pre-trial interview, let the jury hear the entire interview when she decided she didn't want to testify at trial. I thought that was just a huge violation of the confrontation clause, which is a constitutional clause that you have to be able to confront the witnesses against you and cross-examine them. And Tory's team was not able to do that because they were not present for the pre-trial interview that she did. So the fact that that came in and was played in its entirety was very not good. So I can definitely see the appeals court throwing out Tory Lanez's conviction based on that. Let's see. Abba Preach, when you absolutely cooked them with facts in the case, was the first video I watched on your channel. I've been tuning in ever since. Yeah. Oh yeah. Abba Preach, man. Can we even say Abba and Preach? It really feels like it's just Abba, because Abba's the one that actually did all the reading and, well, quote unquote research, and he's the one who said everything, and then Preach just kind of was sat there like, yeah, It's like, man, I wish I could do that. I wish I could get a gig like that. Just sit back and let my co-host do all the talking, do all the research, do all the work, and I just sit and say, oh yeah, or oh no, but. Yeah. Now, we cooked quite a few people on that case. Charlemagne the God, Needle Drop Fantano, Abba Preach, of course. Yeah, all these people with these Delulu takes on the Tory Lanez case. Just had no idea what they're talking about. Yeah, we cooked them pretty good. But anyway, well, yeah. So, okay. Well, I think without further ado, we're just going to jump in for the day. And we'll keep chatting as we're going, but as y'all can see, 7 hours, 31 minutes. We're going to have it sped up, and they take breaks throughout. like there, boom, so we're gonna have definite chunks that we'll be able to get through really fast. So it's not gonna take anywhere near that long, but yeah, no reason delaying any further. So if y'all are here, go ahead, drop a like down below. Let's get it going in there. If you'd be so inclined, you want to share it out, tweet it out, let people know what we're doing, where we are, and yeah, let's just have some fun. So, okay, let's get it on.
Okay. I had a chance to look at the...
Did you see my opposition now?
I have not. Did you file one?
Yes, I did. I gave it to the clerk this morning. Filed it this morning.
Yeah, just some back and forth with the lawyers right now. Not going to be anything too important, but man, day one, though, it was only a 3-hour stream, but the entire third hour was blacked out. So we missed the whole ending of day one on this trial, which can't control it. It is what it is. But hopefully day two, we are better with the technical difficulties.
Until September 30th of 2022, Card Counsel asked me for extensions several times so they could get the information that I wanted. And they finally responded on January 17th of 2023. As the court goes to Exhibit 2 on page...
Honeybook makes it look like I'm a team of 10 when it's really just me in the background. I get to live my...
21 of the responses, it says there's responding party incorporates by reference preliminary statement and general objections set forth above, subject to and without waiving the foregoing objections. Responding party responds as follows. Responding party may be contacted through the...
Honestly, all the quibbling back and forth between the lawyers, it really feels like that. It's just quibbles of, oh, well, we asked for this on this date and we didn't get this, and that's bad, and trying to just lay out the timeline. Not as interested in that. Yeah.
In my opinion, either grossly negligent on the part of counsel for the defendant, or, as I've argued in my brief, an intentional way of hiding who these witnesses are. I can't see how the defendant would go to a doctor and not know the doctor's name, or at least do whatever it takes to get the doctor's name. It's really not that hard. When she went to this doctor, she could have found out his name and disclosed it in discovery.
Okay, so your point's taken on the defendant likely knowing the name of her own doctor. What about the receptionist?
All right, so the receptionist, also the issue with the receptionist would be that either her attorney or herself would call and say that, doctor, who's the receptionist that was there that day? Again, she's the patient, they would have to tell her. And I would like to also add, Your Honor, I did Exhibit 3, question number 15. Again, same thing. They refused to produce the witness information, and I was not able to take the deposition of these people. I don't know what they're going to say. It's highly prejudicial. It goes against the Discovery Act, and it should not be allowed. And they're arguing that I shouldn't be able to bring my witnesses. They're making the same argument that I'm making. So it would only seem fair that if the court's...
That's right. Share a live stream chat and comment so they can hit the algorithm. Absolutely.
In the defendant's brief, and I'm acknowledging that it's hearsay, but they contend that the witnesses both testified or both said that they had been contacted by you, and you're saying that that's not true.
Yeah, that's not true. I never contacted them. Not in 28. I never went to the building. He goes across the street from my office. I did not go there until a few days ago to take 22 pictures. I took it on a Friday night, maybe around 6 or 7 p.m. Went back one more time to take a couple more pictures.
I never testified she took the pictures.
No, I took the pictures with her together. We were together.
Okay.
I did not go back. I did not know about the doctor. I did take a...
And see, this is just what's annoying about all this is basically, and I won't even turn all the way down, just do that.
This is not the way to do...
What's annoying is like all these issues that they're arguing back and forth, like all this should have been handled pre-trial. It should have been resolved, so we're not wasting court time. Oh yeah, go court reporter, go get it. But yeah, we're wasting valuable time in court trying to hash out discovery issues, and it's just this is stuff that's supposed to be resolved before you actually go to trial. So the fact that it's not is just not good for anybody.
This person's name was yesterday. When we were that defendant's memorandum, they brought this person, Tiara Malcolm. It's not even on the witness list. I don't even know who she is. So in the middle of the trial, when I'm not able to depose this person and do nothing with her, they're just going to randomly throw out this person. Well, let's bring this person into trial. It's not fair, Your Honor.
All right, from the defense?
Yes, Your Honor. Thank you. First of all, regarding Cedar Sinai.
I mean, regarding that, as far as if he's saying, hey, Cardi B's team, because this is the plaintiff right here, that's her lawyer, and this is the plaintiff sitting here, saying they just dropped a surprise witness on us in the middle of the trial. That is actually a valid concern. Look, the main thing we're trying to avoid is trial by ambush. That's like the number one thing. Any trial, it's like the main thing that the court wants to avoid is anyone feeling like they got ambushed at trial. And certainly, the name it sounded like he said, I think that's the receptionist that physically inserted herself between Cardi B and the plaintiff here. Now, granted, why he would first. Why would he not call her himself if what his client is saying is true? Why he wouldn't call the receptionist who can basically back it up that Cardi B stuck her finger and scratched his client in the face? The person who would know that probably better than anybody is this receptionist. So he's feigning this surprise at like, well, we had no idea. And he's like, well, the fact that you weren't going to call her yourself, that's sus. But now you're all surprised that Cardi's team is going to call her. So the point is taken as far as being a surprise witness, but also like, is it really that much of a surprise?
Dr. Finke was associated and affiliated with Cedars-Sinai. The building is the Medical Center of Beverly Hills, and that's the reason for the reference to Cedars-Sinai. Second, I'm going to start with the prejudice argument, which is that they didn't know who these people were. Actually, Plaintiff testified yesterday that within a few weeks of this February 2018 incident, she called Ms. Malcolm. She worked in the building. She knew Ms. Malcolm. She knew Dr. Finke, who came out, and they didn't identify them. They knew them, and they didn't identify them. So to say that, well, he's been prejudiced because he didn't take their depositions, she's known since 2018 who the doctor was and who Tiara was.
You said there was testimony yesterday or in her deposition?
Yesterday. Okay. Yesterday, I specifically asked her, did you contact Tiara Malcolm? And she said yes. I disagree with that.
Run the transcript back. Run back the receipts.
To me, the prejudice argument makes no sense. They know she worked in the building. She knew Tiara. They did not disclose those names in discovery. Now, on the other hand, they say that this doctor was Cardi's treating physician. That's absolutely wrong. Her treating physicians are in the East Coast. She was here on work, and she was pregnant. She asked to speak to someone. Someone made arrangements for her to go in. She met with Dr. Finke that day, 15 minutes, and left. 3 years later, they asked who this person was. No one knew. We asked who it was. Previous counsel asked. The only way, because they didn't disclose these names, the only way we found out was through Mrs. Moore's diligent work, which resulted, for example, in 2024, we identified Dr. Finke because she had actually literally tried to contact every doctor in that office, finally pulled a photograph of the doctors from the website, showed them to Cardi, and she said, yeah, it's that one. And then we promptly identified him. Tiara, we had no clue. Cardi had gone to that office that day. She didn't go around and memorize the names of the receptionist or anyone else. The only one who knew Tiara's name until July 28th of this year is Plaintiff, who contacted her and worked in the same building. So, I mean, this idea that we should have, or prior counsel should have identified them, the problem is based on the assumption that Dr. Finke is Cardi's, and that's exactly what they say. Dr. Finke was her treating physician. That's absolutely false. She was traveling. She went in to see him. She saw him one day, and that was the end of it. And then 3 years later, someone asked, well, what was his name? And she says, I don't know his name. Now,
so Dr. Is it Finke?
Finke.
Yeah, why was this not settled before trial? Honestly, that is a good question. Most of these things do settle before trial. But honestly, my feeling, the reason why this did not settle is Cardi feels confident that no, I didn't do what she said I did, and I'm gonna have the evidence to back it up, the witnesses to back it up, and so basically tried to call the plaintiff on her bluff and be like, yeah, let's do it, let's try this case, and point out all the inconsistencies in your story. So yeah, that'd be my guess would be because ultimately it's basically gonna be up to the defendant whether or not they want to settle, and now they have to agree on the terms of the settlement, of course, but. Usually it's the defense that has to be the final answer of like, okay, yeah, we find these terms acceptable, we will settle the case. So the fact that this was not settled speaks more to, I think, Cardi's confidence that she is not liable or they're not going to be able to prove she did what she's accused of doing, yeah.
I was served in 2024. By then, Ms. Moore had tracked him down.
So, Mr. John Fauci, can you respond to that? According to the Moore declaration, that they identified Dr. Finke in early May?
I will look at that, Your Honor, right now, but to paint the picture that plaintiff knew Tiara Malcolm's name is false. To paint a picture that you go to a doctor's office and you're not their patient is also false. It would be an impossibility for that to occur. And I'm sure Dr. Finke will testify that Cardi B is his patient, Your Honor.
Dr. Finke, I can make an offer of proof, will testify that he met her that day, saw her that day. They had minimal contact, 15 minutes, and had never heard from her again until we contacted him and added him to the witness list. I also, Dr. Finke will testify that counsel went into his office multiple times, including by not only going through the reception area, but going through the back door, asking everyone there, do you know anything about this incident? Do you know anything about this incident? Repeatedly tried to contact Dr. Finke over the last 4 or 5 years. That's what Dr. Finke will testify if he's called upon to do so.
Okay, so let me do this. We got the jury's getting checked in. Do you have a rough from yesterday regarding that testimony?
I think we have a actually final, I believe. And so, I'm not sure we have it with us, but we will submit it.
Okay, I want to see the testimony And so we'll resume the argument on this issue because we won't plan on calling them today, correct?
Depends on what. Yeah, that's fine.
Because we're here now, I want to add a sentence.
Okay.
Okay, because it's about me. Okay. I'm declaring under penalty of perjury. I did not go into his doctor's office.
Okay.
That is an absolute lie and false.
Okay.
And I don't think that's right.
Okay, one last thing.
Sure.
Okay. This whole case is about, even by her own testimony, an altercation, an argument when two people came out of the doctor's office. When that was all that prior counsel knew and that the party knew, that's what she stated in the interrogatory response in January of 2022. That that witnesses included two people who came out and separated them. The only person who knew that was Plaintiff, and she failed to disclose.
Okay. All right. I think we're still checking in our witnesses.
Yeah, a lot of it is just kind of quibbling over details, but cases are won and lost on the details. So the stuff that, and especially, lawyers generally have large egos and want to be proven right about everything. So every little thing that gets pointed out that like a lawyer did that was wrong, they're going to feel obligated to, I need to defend myself. I need to defend my honor and my integrity. So that's why they get to that end point, but they're both like, oh, can I just say one more thing? Can I just say one more thing? Yeah.
CV and rate sheet, and it is, I'm going to ask him about it, I'll lay a foundation, but I believe that it should be seen by the jury because it has all of his credentials, and the court limited my time to 1 hour. If that's the case, then I have to go through 22 pages of CV. That takes 2 hours, Your Honor. I can't do it in 1 hour unless he's going to stipulate.
I don't understand this. We wouldn't plan on reacting to a CV other than, I guess it's Tuesday, but if he wants to offer it, he can offer it. I mean,
I'll just say, my practice is if the parties stipulate to admit CVs, I'll admit them. If the parties don't, then usually it's hearsay, and I'm not going to admit it. I will tell you that, to me, it doesn't really matter. Most of the time when I've seen it, it's been
I'm with the judge.
In other cases, the doctor can explain what his training education experience is. So it's up to you.
I'm with the judge. Like, to me, this stuff doesn't really matter.
Can have their doctors' CVs admitted into evidence. It'd be Rosenberg for them and Malkin for me. I'm willing to do that, so we don't have to waste jury's time on this.
Like, they're arguing over doctor CVs right now, like the doctor's resume, and they're fighting over that. It's like, this seems like one of the easiest things that we can agree on. It's like, this doctor is they're as qualified as they say they are. Here's their resume. Like, why are we fighting over the contents of a doctor's resume? Yeah, civil lawyers, man.
Chief, and this plaintiff have another witness. We're still on the record in the Ellis matter. We are now joined by our jury and alternates. We're still in the plaintiff's case in chief, and this plaintiff have another witness to call.
Yes, Your Honor. Plaintiff will be calling Brett Malkin, MD.
All right, so we're calling
Can I get him real quick?
Sure.
a doctor, but who is this doctor, and what is his relation to the case?
Dr. Malkin, if I can please stand right next to the court. Please raise your right hand. Do you solemnly state that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. May I please have you state and spell your first and last name for the record?
Certainly. Brent, B-R-E-N-T, Malkin, M-O-E-L-L-E-K-E-N, M-D-F-A-C-S.
Great. Thank you. You may take a seat. Please watch this stuff.
Oh, Kent Peterson, my guy. Great streamer. Hey, I appreciate it. Hope you're doing well. Good to hear from you. Are they fighting in front of the jury? Yeah, but they're fighting over a doctor's resume, which is like,
Thank you, Your Honor.
bro.
Good morning. Thank you all for coming back. Good morning, Dr. Malkin.
Good morning.
Were you the treating doctor for Emani Ellis, who's sitting to my right here today?
Yes.
And what did you treat her for?
She had
Okay, so plaintiff's case in chief, they're still going. This is the doctor that apparently treated the plaintiff's injuries. So his testimony is going to be really important because if we're establishing here not only that an assault happened, but there's the actual damages stemming from the assault, then his testimony is going to be really important in establishing the extent of those damages and proving that A, they're real damages, and B, that they have a real dollar amount attached to them. So definitely going to pay close attention to his testimony. Yeah, it's going to be really important for us.
a scar on her left cheek.
Okay, and what is your current occupation?
I'm a plastic and reconstructive surgeon.
Are you board certified?
Yes.
For how many years have you been a plastic and reconstructive surgeon?
Since 1995.
It's about 30 years?
Yes.
And early on in your, I'll strike that. Where did you go to undergraduate school?
To Purdue University for 2 years.
And where did you go to medical school?
At Yale Medical School.
And you did some work at Harvard as well?
Yes.
Can you tell us a little bit about that?
Yeah, so I finished undergraduate in 2 years, and then I took a a position at Harvard University. It was a graduate position in literature, German and English literature. So that was for 1 year. And then I went off to medical school at Yale.
And you're also a clinical associate professor at UCLA?
Yes.
Can you tell us a little bit about what that is?
Yes. So I've been, since 1995, I've been affiliated with UCLA. That means I'm a clinical professor there. So you teach the residents who are learning plastic surgery, and you teach the medical students at UCLA.
Okay. And we asked you to be here as an expert witness, correct?
Yes.
And a treating doctor?
Yes.
And in cases where you serve as a treating doctor, in cases that are litigated, you then can serve also as an expert witness?
Yes.
And what does an expert witness do exactly?
Well, that's a good question. I'm not 100% sure at the different designations. There's a treating doctor, an expert, a retained expert, a non-retained expert, so that's way above my pay grade.
Understood.
Yeah, so all we're doing right now is we're establishing the foundation for this witness to be tendered as an expert witness. Basically, expert witnesses are a level above. They're allowed to give expert opinions on a given issue. And so, but to do that, you have to lay a proper foundation, get them admitted and accepted by the court as an expert witness. So that's why we're really just going through his background right now and his qualifications. It sounds like he is quite qualified.
Irrelevant, thanks.
So I would estimate 20 to 30,000 in the procedures we would have performed, the patients we would have seen and scheduled.
And the reason you did that is because you want to help your patient, correct?
Yes.
And in order to be able to offset some of the loss, you're charging $2,000 an hour to be here as an expert witness?
That's correct.
Dang. $2,000 an hour for this testimony.
Tend to serve as an expert more for the plaintiff, more for the defense, or is there some percentage that you could tell us?
It's roughly 50-50, so I'm retained by defense firms and by plaintiff firms equally.
Is it your understanding that in this case, the defense chose not to designate an expert? Is that your understanding?
Objection, Mr. Hearsay, last foundation.
Do you know of any other plastic surgeon that's rendered any opinion in this case besides
Objection, last
yourself?
foundation.
Yeah, that's not, we can't get into that.
Have you seen any medical reports or any type of documentation from a different plastic surgeon?
No.
Plastic surgeon, I believe he's a con artist as well, charging $17,000 for microneedling on invisible scars. Is that a reference to this case, or is that just like his general practice that he does this microneedling on other people's invisible scars? Because, yeah, man, I guess he really wields that Ivy League pedigree with a lot of power, and it's like, oh, people must listen to me because I went to Harvard and Yale.
Related to this case?
No.
When you serve as an expert witness, isn't it true that usually there's an opposing expert on the other side who would then argue with your opinion?
Objection, last foundation, irrelevant. 332.
Much more.
Yeah, I don't know what we're doing here. Not good question.
Did you review 85 pages of medical records of Emani Ellis prior to testifying today?
Yes.
And if you were to look at your exhibit book that's in front of you, the one on your right, if you can go to exhibit 1-004.
Yes.
At the bottom corner, you say exhibit 1-001, and then 2, 3, and 4.
I think the exhibits are over here.
Approach around. Come in.
Yeah, I don't know why you got two binders up there.
Okay. I'm sorry about that.
Do you see a list of Emani Ellis' medical records and bills?
Yes.
And you reviewed all the records and bills?
Briefly, yes.
And for your treatment in your office, did you charge Ms. Emani Ellis $6,500?
Yes.
And surgery center, $11,000?
Yes.
Why do you charge these amounts for the treatment that you gave for Emani Ellis?
Well, her procedures were performed in an operating room. So we have the operating room staff and sterility, and it's done in a JCO, meaning Joint Commission, approved surgery center.
Could you have done this outside of the surgery center?
You could have done it, but it wouldn't have been as sterile.
And would you follow that type of practice?
I don't do that sort of practice.
All right. And in your review of the medical records, did you also see that Emani Ellis treated with 2 psychologists?
Yes.
And you reviewed all those records and bills?
Briefly, yes.
He's not going to be able to say much about that, though.
If we can just go to Exhibit 9, which is your CV. I just wanted to go over your CV a little bit.
So why we're not starting with this, though? This is the same problem yesterday with the plaintiff's case in chief, asking questions to the plaintiff. He was just bouncing all over the place, didn't lay a good foundation to begin with, and then went back later to be like, oh, now let's get to know you, talk a little bit about who you are. Like, CV should be the first thing you're asking your expert witness about, so they can give their full list of qualifications. You want the jury to almost start getting bored with how many different qualifications that your expert is listing off, because when they start getting bored, it's because they get the idea that, okay, this guy, he knows what he's talking about, I'm just going to accept it. But like, why are we not doing that first thing?
Your CV is 22 pages long, including your rate sheet. Is that correct?
Yes.
Your Honor, I would ask that Exhibit 9 be admitted into evidence.
No objection, Your Honor. Go ahead. All right, so admit.
All right, so with the exhibit admitted into evidence, now it can be shown to the jury. Yeah, I'm timing these ads perfectly. Look at that. But yeah, once it's admitted, now the jury's allowed to see it.
This is the first page of your CD, correct?
Yes.
Okay, and this explains all of your. You have 2 different offices.
I do.
Why do you have 2 offices?
Just one in Beverly Hills and one in Santa Barbara. So. Yeah.
Although I don't know quite why we're showing the CV to the jury. Like, I don't know that I've ever seen a resume actually be published. Usually you just go through it and then you get tendered as an expert, and that's that. But to actually put up the resume for the jury to look at themselves is a bit odd.
Before doing my training in plastic surgery, so I then became board certified in plastic and reconstructive surgery, and I've done 2 additional fellowships, one in aesthetic surgery and one in microsurgery. So that's 10 years of residency after 4 years of medical school.
Okay. And on page 4, you have hospital affiliations. Can you tell us your affiliations with these 2 hospitals?
Yes, so I'm currently an attending at UCLA Medical Center, and previously I was an attending at Cedars-Sinai Hospital, but I gave up those privileges, and now I'm exclusively at UCLA.
Then on page 5, you have some other information, such as being a super doctor. What is a super doctor?
Super doctor.
Well, a super doctor is 5% of the doctors in a community are chosen by their peers. So I've been a super doctor for 15 years, and on various committees, like the Blue Ribbon Committee. So I'm proud of those awards.
Do you do any charity work?
I do.
Can you tell us a little bit about your charity work?
Yeah, that seems irrelevant. Yep, objection sustained.
Is there anything else about your education that you would like to add?
Well, I'm in clinical practice, so I'm a practicing plastic and reconstructive surgeon, but I teach at UCLA. So I'm a clinical professor at UCLA. So that means just a teaching position.
Okay. You teach other medical residents?
Yes, medical residents, medical students, and usually plastic surgery residents. So they've completed their training in their last few years of training. So those are the doctors that I spend most time with.
Okay. Now I want to go to this case and ask you some more information about this case. Do you remember seeing this patient, Emani Ellis, in your practice?
Yes.
Okay. And when she came to your office for medical treatment, did she provide a history to you?
Yes.
Did you use the history in your treatment and diagnosis of the patient?
Yes.
And what was the history that she gave you?
Well, she mentioned that she had been the left side of her face had been injured by fingernail scratches.
Okay.
So that was the basic salient history. And then I looked at her wound, and so in order to determine what I need to do to help her out, I had to diagnose her problem. So I wanted to see if there was hypersensitivity in the wound. Hypersensitivity means, for example, if you have a splinter underneath your skin, it may not show much, but you can feel the splinter under your skin because it's hypersensitive. So I noticed that she had a focus of hypersensitivity on her face. Now when I examined for that,
I got a picture?
I touch many areas and see if the patient's pain symptoms are always the same. In other words, if they always come from the same area. So that's how I made my diagnosis of her scar, the visible aspects of it and the hypersensitivity aspects of it.
Right, if you can go to Exhibit 4, the grade, I mean the one you have in your hand.
Okay.
Also, timeline. When did she come?
What number? Sorry?
4.
Oh, 4.
What's the timeline of this? When did she come see you? And was it a week after, a month after, a year after?
Your medical evaluation of the patient, you saw her for the first time on November 4th, 2022?
Yes.
Were you advised by Emani Ellis?
November 4th, 2022. So we're talking 4 years after the alleged assault happened. So could there be a scar yet there? Sure. But, and certainly not saying he's not being truthful. He can be completely truthful in his testimony about that. But 4 years is a lot of time. And how are we establishing, how are we proving here that that scar was a result of Cardi B's actions and this alleged assault that took place back in 2018? And especially considering plaintiff's testimony yesterday, or in day one, stating that she'd been in 2 car accidents since 2018. So, I don't know, man.
Ellis or anyone else that Miss Ellis was seen by a different plastic surgeon before you?
Objection calls for hearsay. Black's foundation.
Sustained.
If you go to Exhibit 4-009, at the bottom, can you read for us what it says in handwriting?
Yes.
Sustained.
Okay. Are you aware that Miss Emani Ellis saw a Dr. Scher before you?
Objection. Hearsay.
Sustained.
Is it important to you when treating a patient if they've seen any prior doctors?
Objection. Relevant Black's foundation.
No, it's very important if they've done treatment. If they've done treatment, then I need to know what treatment they did.
Good objection.
So in
Good
order to
ruling
do
for the
your
judge.
work with this patient, Emani Ellis, you would need to know if any other doctor, such as a plastic surgeon, did any other work on Emani Ellis, correct?
Yes.
And when you asked Miss Emani Ellis if she got treatment, did she tell you she saw a different doctor, Dr. John Scher?
Objection. Hearsay.
Sustained.
Yeah.
Do you know the Dr. Scher? Do you know him?
No.
Are you aware that Dr. Scher has passed away?
Objection. Black's foundation. Calls for speculation.
Overruled.
That's what I.
So all these objections for hearsay is basically trying to ask him what his client or what the plaintiff may have told him, but it's like it's hearsay because it's coming from the plaintiff, not from him. And you had the plaintiff testify yesterday, so if you want to get this information out, you want to get out what the plaintiff has said to people, get that out while the plaintiff is testifying. You don't have another guy testify to what he heard the plaintiff say. Yeah, no, that's hearsay all day.
I've been told I didn't verify it.
Hearsay.
Denied.
For a patient such as Emani Ellis, the kind of injury that she sustained, is it true that if Emani Ellis had came to you within a couple of months after the incident, that you would advise Emani Ellis to wait 1 to 2 years to determine
Objection.
if this cut would become
Probably
a
objection to
scar?
this.
Black's
Is that,
foundation. Oh, sorry.
is that the proper course?
Okay.
Sustained.
Yep, objection sustained.
For a patient like Emani Ellis who sustained a cut, how long should she wait before getting plastic
Still
surgery?
cancel.
Objection.
Want you to establish that there are different treatments. What type of cut it was, how deep the cut was, whether it was likely the scar, what he knows about the scar. Establish some foundation before you ask him opinions.
Okay, thank you. Can you describe for us the scar that Emani Ellis had when you examined her?
Ooh, you got the judge directly admonishing the plaintiff's lawyer, saying, literally telling him the questions he needs to ask first. Ooh, that is not a good look at all. To your client, the client's looking at you like, bro, do you know what you're doing? Like, the judge just had to reprimand you. Also, the jury is now looking at you like, wow, the judge had to tell you to literally feed you what you're supposed to be asking here. Ooh, big oof for the plaintiff's lawyer.
Her on November 4th of 2022 for the first time.
Yes, she had vertically oriented, in other words, up and down scars. There were actually 2 of them, but one was more prominent, and it was hyperpigmented, and it was hypersensitive.
And isn't it true that it would take at least 1 year before the scar formed?
Objection. Black's foundation. Calls for speculation.
Yeah. Okay.
No, scars can form quickly. Sometimes it takes a long time for them to form.
Do you believe it was correct for Emani Ellis to wait before obtaining the medical treatment that she
Objection.
received in your office?
Objection. Black's foundation. Calls for speculation.
Sustained.
Yep.
And the type of medical treatment that you performed, isn't it true that during the pandemic, which started in April of 2022, for at least several months and years, there was limited availability for patients to receive plastic surgery?
That's very true.
And your office was shut down for several months at least?
Well, I perform a lot of reconstructive surgery and emergency surgery, so my office was never shut down.
But if a patient needed to receive the type of treatment like Emani Ellis received, and they contacted you in May of 2020 during the pandemic, you would not be able to work on them, or you probably would tell them to wait, correct?
Objection. Compound. Calls for speculation. Black's foundation.
Sustained.
Isn't it true that a scar...
Even then, just all these questions leading off with the phrase, isn't it true? Like, these are not questions you ask on direct examination. Direct exam is supposed to be an open-ended examination to let your witness kind of say their story and share the facts as they know them. Isn't it true is what you usually would do on a cross-exam, where you're trying to narrow it down. You're asking leading questions, like, isn't it true you did this, that, and the third? Like, you're trying to narrow them in and basically narrow it down to a yes or no question. So even the fact that he's leading all of these direct exam questions with, isn't it true? That's also just not good. Big oof.
Such as Emani Ellis's, when she came to you in 2022, the scar would basically never have gone away unless you performed some type of medical treatment, correct?
Objection. Leading. Calls for speculation. Black's foundation.
Sustained.
Look at that. Objection for leading. I just paused it to explain how these questions are all leading. Boom. Objection, leading, sustained.
Can you tell us in your, on 4-001 in the HPI, can you read the four lines there, please, for your report?
In the which line, I'm sorry?
It's hearsay. How much you want?
When you treated Miss Emani Ellis, did she tell you that she was assaulted and battered by Cardi B?
Objection. Hearsay.
Yeah,
Yes.
no, you can.
Did she explain?
So even though that's hearsay, technically it's what the plaintiff told him. It's statements made for purposes of a medical diagnosis, which is an express exception to the hearsay. I look it up. There's like 25 exceptions. So, but yeah, that's one of the explicit exceptions to the hearsay rule. You can share as a doctor. You can share statements made for purposes of medical diagnosis.
To you that Cardi B placed her long fingernails with sharp objects in her face?
That's what you told me, yes.
Did she state to you that her face was red and hot after the incident?
Yes.
And can you tell us, when you personally examined Emani Ellis, did you see 3 lines on her face on the left side of her cheek? Objection, leading.
Yes.
What is the significance of the 3 lines?
Well, it's typical for a fingernail injury when you have parallel lines going from the top to the bottom. So that's vertically oriented, so up and down rather than horizontally. So typically that's how fingernail injuries manifest.
Is it your expert opinion that Emani Ellis sustained an injury to her left cheek from fingernails? Objection, leading.
It's the same.
I'm sorry.
Yeah.
It's the same. It's the same.
Oh.
All right, can you tell us, please, how many times you saw Emani Ellis for medical treatment?
I believe 3 total.
Can you just please go through the treatment that you gave her from the beginning to the end?
Yes. So there was an initial examination, and then I performed 2 procedures on her. So those were done in the operating room, and I did what's called medical microneedling, which is a procedure where you place local anesthesia underneath the skin to numb the skin, and then you do deep microneedling at a depth of approximately 2 millimeters. It does cause the patient to bleed, but the bleeding is very small because the needles are very small. So then we apply various creams to prevent infection, and then we see the patient back in approximately 4 to 6 weeks. So after that period of time, she returned. We had noticed some improvement in the hypersensitivity and some improvement in the hyperpigmentation. So I basically performed an identical procedure, also under local anesthesia. And after that, I believe I did not see her again.
It sounds like the what you said, Carla. The 17 grand for microneedling on invisible scars.
The medical treatment she received from you?
Yes.
Party's original bag is back.
Yeah, but also too, it's like, why are we not? If he took a picture, which I have to assume he did take a picture of the injuries, why has that not been published to the jury? Like, literally just have the picture sitting up there on the presentation screen, just sitting there, and you can do the whole testimony, and you're talking, you're explaining what happened, but that way the jury, they can look at you and watch you as you're going, but they can also look up and see this is the injury. Like, literally just have it plastered there I'd say for the entire testimony. Like, why not? Yeah, just have this constant reminder for the jury of the injuries that we're talking about here.
And you're familiar with the billing procedures and charges from your office and other medical providers, such as plastic surgeons and surgery centers and the like?
Yes.
Is it part of your practice to review the medical bills for your office and other types of medical providers?
Well, it's a part of my...
Objection, compound, and hearsay. That's the one part.
So it's my function as a medical director of a surgery center, which I've been for 25 years, to know the fees that are charged at the various institutions like UCLA or Cedar or in similar institutions in the community.
And when you examined Emani Ellis on November 4th of 2022, you performed an examination, you wrote a 4-page report, you reviewed medical records and medical bills, you spoke with the patient for how long approximately?
Well, we maybe spent 45 minutes total with her, but that includes the assistant going in, asking the questions, and then she transcribes it to an iPad, and then I go in the room, I do the examination, I record the results of my examination, and then correct anything on the iPad that I want to add to.
And to write the report of 4 pages, review all the medical records, review all the documents, see the patient, everything. That one day on November 4th of 22, you charged $1,500, is that correct?
That's correct.
And if you were to make that same examination, go through all those steps today, you would actually be charging $2,500, correct? You can.
That's correct.
The fee has gone up because of inflation and the cost of medical care?
Just
You can.
Yeah, that's what it costs. So you have to.
All right. And the medical procedures that you did on February 20th of 23 and March 20th of 23, the 2 procedures, each one you charge $2,500, is that correct?
That's correct.
Okay. And the same procedures today, what would you charge?
Well, it would be approximately $6,500. If you noticed in my initial report, that's the amount I quoted, but for some reason it was billed at $2,500. So that was an error, but it is what it is.
So then, in fact, the $2,500 charge should have been $6,500?
Correct.
Twice.
That's what it costs to perform surgery, in a surgery center.
So 6,500 times 2 times $13,000 plus her $1,500 consult, so 14,500 to do some microneedling, and and done in 2023 after this lawsuit's already begun. So if we're talking about this was done before any lawsuit was even contemplated, then that's one thing. But we're talking about we're in the active litigation now, and now you're going to getting 15 grand worth of plastic surgery done. It's just, it's not going good. It is not going good for the plaintiff. And credit to Cardi B's lawyers. I mean, figures she got really good lawyers, but they're doing a really good job reining in plaintiff's testimony.
And approximately how long does it take from the time the patient comes into the office, gets prepared for surgery, and is sent home for each of the 2 surgical procedures you did?
Well, approximately 2 to 3 hours.
And the surgery center has to be booked for a certain period of time?
Yes.
And you got to prepare it, do the procedure, clean it, make sure it's good. How long does all that take? How much time do you book the surgery center for Ms. Emani Ellis on this?
Well, the 2 to 3 hours would not include the technicians, the surgical tech preparing the equipment for the cleanup. That was just the 2 or 3 hours would be the time from the time the patient arrives, fills out the paperwork, the consents are given. We again talk about the risks and benefits of the procedure. We put on topical anesthesia. We let that work. We take them to the operating room. We put on, we induce local anesthesia with Objections. We do the procedure. We watch her postoperatively to make sure she doesn't have any allergic reactions or trouble with her skin. And then we make sure she's dressed properly, has postoperative instructions, and then she's discharged.
And there's obviously different types of skin that you deal with in your practice, correct?
Yes.
There's lighter skin, darker skin, rough skin, soft skin. Can you just tell us a little bit of the difference in procedures that you would do to the different types of skin?
Yes, so there's a grading scheme from 1 to 5, and 1 would be
this doesn't seem relevant to me.
Very delicate skin. For example, a redhead who might have very delicate skin and would not tan at all, it would just burn. So that would be Fitzpatrick 1. And then Fitzpatrick 3 might be Asian patients, Hispanic patients, patients of mixed race, and then up to Fitzpatrick 5, which would be black skin. So depending on the coloration of the skin, that determines what lasers you can use, what procedures you can use in a safe manner.
Okay, and what on that scale, what is Emani Ellis?
5.
Okay. Is there a difference, for example, if you take photographs of a patient with 5 on the Fitzpatrick scale, if you take photographs of their skin versus someone with a 1?
Yes, in general, in black patients, the lesions are less visible just because of the coloration.
And when you examined Emani Ellis for the first time on November 4th of 22.
So we're laying the foundation here to say that on black patients, the scarring is less visible. So it sounds like we're going to get to a photo, but the photo is probably not going to be very good. But here we have our medical scientific explanation saying, well, that's just because of her skin color. The scar is definitely there. Trust me, bro, it's there. But you just don't trust your lying eyes. I know you can't see it in the photo.
Did you, with your own eyes and your equipment, you saw the scars, correct?
Yes.
And how many scars did you see?
Well, I saw one main one. That's the one I recorded. But I saw other things that were, differences in the skin, differences in the pores, an adjacent scrape mark. I saw those things as well. But the main thing was that there was one main scar. That was the hypersensitive one.
Okay. Is it your expert opinion that Emani Ellis sustained injuries to her left cheek from fingernails?
Objection.
Speculation.
Yep. I could have done
What is
this.
your opinion as to where Emani Ellis obtained the scar in her left
Objection.
Well, the most likely.
Yep. Look, I'm quick with it.
What was the size of the scar? Did you measure it?
Yes. It was approximately 2 centimeters that I noted. That was the main scar.
Can you tell us approximately how long is 2 centimeters in inches?
Yes, so an inch is 2.5 centimeters, so it's a little less than an inch.
An inch wide or an inch long?
2 centimeters is approximately 1 inch, or a little less?
2.5.
2.5 centimeters is 1
Is
inch.
about an inch. Yeah.
Why was it? Why was hypersensitivity important in this case?
Well, hypersensitivity is a very unpleasant sensation, and it's often associated with scars. So my job is not just to make the scar look better, but it is to reduce the hypersensitivity. That's, in some respects, the most important thing, is to reduce the hypersensitivity in a scar.
And when you examined the scar earlier, you testified that you're of the opinion that the scar came about from from fingernails, is that correct?
Objection leading. Ms. Kirk goes into that.
Yeah, he keeps trying to get it in. It's not coming in.
What is your expert opinion as to where the scar came from on Emani Ellis' left cheek?
Objection.
Well, based on the direction of the scars, based on the fact that there were 2 to 3 scars that were parallel and they were vertically oriented, in other words, up to down, based on the fact that the central scar was the deepest, based on the fact that the central scar started the highest. This is a pattern that is most closely associated with fingernails because the middle finger is longer than the index finger and the ring finger. So when the fingers are drawn down, the middle finger causes the deepest scrape, and the other scars cause a lesser deep scar. And they also begin later than the middle finger, because the middle finger being longest, it grips the skin first, so it's the highest. The central scar is the highest. And the fact that they're parallel is highly suggestive of a fingernail injury.
Is that to a degree of medical certainty?
Yes.
And what does it mean for the jury, if you could explain, what does medical certainty mean when an expert makes that type of
51% or more. It's the most likely explanation. There are other explanations. But
Yeah, every plastic surgeon always takes pictures before and after surgery. Where are before and after pics here?
reviews?
Great question.
well, I did. That wasn't as important as the
Now,
physical.
of course, I was going to go through a laundry list of what we did, but why don't you just tell me, what did you do to formulate your expert opinion?
The number one thing I did was examine the patient. That's the number one. So I noticed where the scar was. I noticed what symptoms she was having. And that alone, sure, the medical records are helpful. You always review them just in case there's something that might be important if you're doing surgery on somebody later. But the physical exam is the most important thing. That tells you what you need to do with the patient.
What is your opinion based on? I looked at her. Okay.
How many patients have you treated for assault and battery type of incident?
Many hundreds.
And
Okay, if there's one AI site.
You good? Sorry.
is there an emotional component that goes along with this type of injury?
Objection. Outside the scope of this designation, Class Foundation, cultural speculation.
Yep, sustained.
In your medical report under social history, you state post-traumatic stress, anxiety, depression, headaches. Is there any reason why you wrote that?
Well, that's information that the patient gave us. It's not a diagnosis I made. It's the information that the patient gave us.
And future prognosis, it says I would anticipate a 50% improvement in the scar. Was that, did the treatment you provide produce a 50% or more improvement?
I believe it did.
Was your patient happy with the medical treatment that she received?
Objection, cultural speculation, vaccination.
Yeah, that comes in.
Oh, I can answer. Fine. Well, she expressed satisfaction with the procedure to me. I'd been very upfront with her that her likely outcome was that the scar would be better, but not gone.
And I just want to ask you a few more questions about the medical bills. Your medical evaluation charge of $1,500
Why?
on November 4th of 2022.
I don't know why we keep going down the medical bills route. Like he already stated what it was. Yeah, I don't know why we just have to keep going back to it.
On November 4th of 2022 in your office were reasonable and medically necessary.
Yes.
Do you believe that the medical treatments in your office on November 4th of 2022 were related to this incident of February 24th of 2018?
I see.
Objection, cultural speculation, lacks foundation, outside the scope of this designation.
Now, aside from your $1,500 charge and your $2,500 charge times 2 for a total of $5,000, there was also a surgery center charge from Neo Surgery Center. Is that correct?
Yes.
And you reviewed those bills from Neo Surgery Center?
Yes.
Okay. And you told us a little bit about your background. Are the charges of $5,500 for each time you treated Emani Ellis in the surgery center, are those reasonable
Yes.
and medically necessary?
Yes.
Is that to a degree of medical certainty?
Yes.
And are the treatments
So all these words, these are in the law. We call these terms of art. Words like, were those medically necessary? Were those expenses reasonable? Medically necessary to a degree of medical certainty. These are all terms of art that he's throwing out because they fulfill specific requirements for proving things in a court of law. So when you're proving medical expenses, you have to prove to the jury that the expenses were reasonable and medically necessary. That's why he's using those specific words, and he keeps using them over and over again. And then asking him, is that your opinion to a degree of medical certainty? That's asking him as an expert, because now you're allowed to give your opinion as an expert.
at Neo Surgery Center related to this incident of 2/24/18?
Yes.
Objection. Again, outside the scope of this designation. Thank you.
And just so there's clarity on the other three bills, the $1,500 one and the $5,000 for 2 procedures, you testified that those were reasonable and medically necessary, correct?
Yes.
Is that to the degree of medical certainty?
Yes.
Do you believe Ms. Emani Ellis could benefit from any future type of plastic surgery?
Objection called for speculation. Argument as well.
Yeah, based on
Do you have
what?
an opinion as to whether Ms. Emani Ellis needs any future medical care in your office?
Objection by foundation.
In reviewing all the records and bills from the past that you've seen and diagnosing the patient and seeing the patient, do you have any opinion as to whether Ms. Emani Ellis needs future medical care?
Objection by foundation.
Yeah, sustained.
Do you plan to provide Ms. Emani Ellis any future medical treatment?
Objection speculation by foundation.
Open. You can answer.
Not currently, but I'd be happy to do it if she asked me to.
And what would you be happy to do if she asked you?
Probably more medical microneedling.
I'll sustain the objection. Please don't credit with the
Yeah,
conflict.
speculation.
Can you tell us a little bit about what future medical care you would want to provide to this patient?
Objection by
Objection.
foundation.
The established foundation that there's any basis for him to form an opinion that she needs any future care.
Is there any basis for you to form an opinion that you need future medical care?
Objection by foundation. Called for speculation.
Like, again, the judge literally just, again, told the plaintiff's lawyer, here's the question you need to ask. Listen to it.
Basis for you to form an opinion
That there's any
about what future medical care you would want to provide to this patient?
Because he keeps saying all these ifs, like, if she came to you, what care would you provide? And it's like, okay, that's all speculation. None of that's concrete, especially after he just testified and said, I don't know. There is nothing further to do. I'll do something if she comes to me and asks me. But yeah, listen to the judge literally telling the plaintiff's lawyer, here's the question you need to ask here.
Foundation.
the established foundation that there's any basis for him to form an opinion that she needs any future care.
Is there any basis for you to form an opinion that you need future medical care?
Objection by foundation.
And so then the defense objects, and then he overrules it because he's like, I just gave him that question. I'm not going to sustain the objection when he asks it.
Speculation.
Yes.
Like, she's even smiling.
Can you tell us about that, please?
I like
Still
this.
has scarring.
I like this judge.
And what could she get? What could she benefit from?
She could
Objection called for speculation by foundation.
she could benefit from some more medical microneedling.
How many more treatments?
Objection called for speculation by foundation.
Yeah.
If she received
all
one more
speculation.
procedure, what would the cost be for the entire process, which would include your charges and the surgery center charges?
Objection.
Objection by foundation.
So it would be approximately $6,500 for the professional fee and then $9,500 for the surgery center fee.
So does that mean that the surgery center cost has also gone up recently?
Yes,
So is that approximately $15,000?
approximately.
And how much better do you believe the scar would be if she received that treatment you just told us about?
Objection by foundation. Called for speculation.
Do you have an opinion as to what benefit the treatment would give Ms. Emani Ellis if she had one more microneedling procedure in your office?
Objection by foundation.
I would estimate she would have an additional 15 to 20% improvement.
Is there any way to get to as close as you can to 100%?
Objection called for speculation by foundation.
Do you have an
Yeah.
opinion of how Ms. Emani Ellis can make her scar better than just 15 to 20%?
Well, she will never.
Getting destroyed. We call this the objection buzzsaw. You just keep running into it. They're just holding up this buzzsaw, and you got to try and get through it, but he keeps running into it over and over and over again.
Do you have an opinion as to what type of, well, strike that. Do you have an opinion as to the percentage of improvement that Ms. Emani Ellis can have if she has more than just one procedure in your office?
Objection by foundation.
I can't say. It would take another treatment to determine that. If she had no further benefit, then that would be the end of the treatment. If she had further benefit, then that would justify more treatment.
And then I want to ask you a little bit more about medical treatment on a lean basis. Can you tell us what percentage of your practice do you treat patients on a lean basis?
A very small percentage.
Is it less than 10%?
Probably, yes. I don't know the exact number, but probably, yes.
Most of your patients pay out of pocket themselves, either they pay cash or credit card. Objection.
Yes, they pay, cash, or I have charity, so they pay nothing.
When you treat a patient on a lean basis, does that mean, I'll strike that. When a patient treats on a lean basis, isn't it true that the lien is created simply for your added protection?
Objection. Lien.
Yeah.
Does Ms. Emani Ellis owe you in your medical practice $17,500?
Yes,
And no matter what the outcome is of this case, she still owes you that money.
Objection. Lien.
that's correct.
That's a good question.
And you've agreed to wait until this case is resolved before pursuing your medical bill?
Objection. Lien.
Yes.
Is that common practice when you treat patients on a lean basis?
Yes.
And medical, isn't it true that all types of different medical providers treat patients on a lean basis?
Objection, leading legislation.
Have you
Yeah.
seen other types of medical doctors treat patients on a lean basis?
Yes.
And you've seen surgery centers?
Even Cardi's in shock at the prices. She's a millionaire. Yeah, I mean, gosh, yeah, 15 grand to get some micro needling done. But he's talking about, oh well, it's a surgery center. And asked about like why is that the price? He just said it just is. So I think he knows. But I mean, it's about the value. I guess it's about the value you're getting out of it. If you really place a high premium on your face not having a scar on it, people pay good money to get that done.
Do that?
Yes.
Pain management doctors?
Yes.
Chiropractors?
Yes.
Dentists?
I've seen all types of doctors perform surgeries on a lean. Yes.
If you can go to exhibit number 5, please, in your report.
Are we finally? Is Exhibit 5 a picture?
Are you there now?
I am, yes.
Do you see a report from a
Nope.
Dr. Norman for treatment on July 23 of 25?
Objection.
Yes.
Did you review this report, Bill?
I did.
No, never mind. If it's just that he reviewed it, there's no objection. But if he starts going into the contents of like, okay, what was in this report? That's all hearsay. That's all objectionable.
Is this the most recent medical visit that Emani Ellis received to your knowledge?
I'm sorry?
Is this treatment at Dr. Norman's office the most recent medical treatment that you're aware of?
Objection, Your Honor, this is excluded.
It
Document
has not been excluded.
and lacks foundation.
So you're asking him if he knows whether she saw another doctor after this visit?
In reviewing,
How do you know that?
in reviewing the medical records in those 85 pages, I want to establish that this is the last medical visit that the plaintiff has received.
How does he know that?
By reviewing medical records, Your Honor.
That's the thing.
Yeah. This plaintiff's lawyer is getting absolutely toasted out here.
Isn't it true that after July of 23 of 25, there are no further medical records that you've reviewed?
I don't know.
Oh.
Now we got to go help people
And he's chilling big time. He's been testifying almost an hour now. Boom. $2,000 richer just to sit there and talk a little bit. It's great.
Did you take photographs of the patient when she first came in on November 4th of 22?
Well, I don't take the photographs, but my staff does.
In reviewing your medical records and bills and reports, did you confirm that Ms. Emani Ellis had photographs taken in your office when she came in on November 4th of 22?
Yes.
And each time she came back, for example, on February 20th of 23 and March 20th of 23, you also took photographs, correct?
Yes.
And because
Finally getting the
she's a grade
photographs.
5 as far as the coloration of her skin, the photographs don't do much justice, meaning they don't really show much, correct?
Objection.
Lacks foundation.
Yep.
Isn't it true that
Get me in,
when
coach.
you saw Emani Ellis on those 3 occasions, you could see the scar a lot better than in photographs?
Actually, if in a detailed photograph, you see it very well. So I remember during the deposition,
But the fact we keep asking about a photograph without actually seeing the perfect adage in the law: show, don't tell. Show, don't tell. If you've got photographs, show them. Don't just tell people about the photographs. Oops. Don't just tell people about the photographs. Tell the jury. Show the jury. They want to see it. If I'm there sitting in the jury, it's like, why do you keep telling me about this photograph and not just showing it to me? I hear what you're saying. It may not be as good as what he saw in person, but like, let's see it first, and then we can talk about it.
the defense attorney showed me a very detailed picture, and you could see everything.
If you can go to Exhibit 6 in your exhibit book.
Okay.
Exhibit 6? Are we there?
There's a total of 12 photographs, correct?
Yes.
And these are the photographs that you took in your medical office?
Well, these are so low-resolution copies of the photographs. Yes.
And it's hard to see the scar in these photographs, correct?
Well, you can still see it, but you don't see detail.
Low resolution. This is your day in court. Why do you not have the most HD printout of the photographs you can possibly get? This is what you're showing to the jury, and it's not HD. Oh my
Is it common
god.
practice to take photographs of your patients when they come in before they do procedures?
Yes.
Why is that important?
Well, to document what their current status is, and also to document any improvement. And because memory is fallible, so if you have a photograph, I don't always operate on patients right away. Sometimes it's months later, and then I like to have an accurate photograph.
Your Honor, if I may show the doctor some of these photographs in Exhibit 6 on the Elmo.
Well, I don't know that there's any foundation to those are the photographs.
I can ask you, Your Honor.
Yeah. Once again, the judge just told him again what he needs to do, that you need to lay the foundation for these. Because, yeah, he needs to ask, what are these? What are we looking at? How do we know what they are, that they are what they are? Who took these photographs? How did they take them? Was it on a phone? Was it on a digital camera? How did you get them printed out? Like, these are all foundational questions. The biggest one here, more terms of art for y'all. And this is a great source of knowledge. Just I hope y'all are getting good information out of this. Another terms of art, the magic words you have to say before you can get photos in. Do these photos fairly and accurately, those two words, fairly and accurately, do they fairly and accurately represent what you saw on the day these photographs were taken? Those are the magic words to lay your foundation down. And he's done none of that. This is like law school, like first year law student type stuff that gets taught. And this plaintiff's lawyer, who supposedly does, this is all he does, is cases like this, and he doesn't even know this stuff. It's crazy.
Will counsel stipulate to the photographs?
Why don't we not propose stipulation on the jury? Sorry.
And now he doesn't want to lay the foundation. That's why I asked, will counsel stipulate to the photographs? Because you can stipulate. As long as both sides agree and stipulate to something happening, then really anything can happen in court if everyone stipulates to it. But that's another thing you settle before you go to court, before you go to trial. You get all of your stipulations out of the way of what you're going to agree on. And the fact that he's on the fly trying to get defense counsel to stipulate to these photographs, it's just, it's rough.
Can you look at the blue exhibit book in front of you? Yes.
Sorry for my language. What do you mean? You good? I ain't seen nothing bad.
Okay. Request to publish, Your Honor.
I don't know that he's identified. Do you know what
If you look at this photograph, the color.
Are they admitted?
Photograph of Emani Ellis' mark.
Yes.
And this is a photograph that was taken in your office on November 4th.
He keeps trying to publish these photographs without getting them admitted as an exhibit. Like, you have to get, the judge has to admit them as evidence, as an exhibit, and then you're allowed to publish them.
22 by your office staff, correct?
Yes.
And you maintain your photographs in your office as part of your business records?
Yes.
Okay, here's some good foundation happening
Your Honor, I'm
finally.
requesting to show the witness exhibit 228 on the Elmo so he can confirm details about this photograph.
No, Your Honor. Go ahead.
Finally got there. Alright, moment of truth, y'all.
I'm going to use a pen, and if you can tell me where on her face you see the scar.
Counsel, there's a pointer there. If you would just want him to get down, you can show it on the screen.
There's a pointer there behind you, and if you could just show us where the scar is located.
Yeah, where are we looking? Is it this we're looking at?
So this is a terrible picture. So there you go. That's better. No, it's not good. Okay, there's the main scar here, and this entire area here shows differences in the skin, sort of the general area that's very different from the rest of the skin. And there's a little linear mark here, and there's another one over here. So those are the three marks that I was talking about. This is the main scar down the center, and this is another mark to the side. Here's another mark on this side. So those are the scars, and this is the whole area that's affected. So it has a little bit different. The pores are of different size, and they're a little washed out and a little. They've lost some of the normal undulations of skin, which are concrete pegs. Like that happens often with scar.
But even then, how are we saying this is from her own testimony? Was that Cardi B was in her face with her finger, pointing it in her face, and her finger kind of got her on the nose and then got her like that. So if we're going like that, how are we getting to that? Would make a scar going like this way. So boom, hit the nose, and then kind of like that line. But we're talking about scars that are perpendicular, not going this way. They're going up and down like that. That'd be like a scratch up and down. So yeah, how in the world are we saying that from someone sticking their finger in your face, even with long nails, that resulted in three claw marks, 3 scratches going vertical from your eye down? I don't buy that at all.
And if we look at this this photograph, can you tell that in the photograph Emani Ellis was wearing some makeup?
It appears she is, yes. She has lipstick, and it appears she's wearing something.
Thank you.
But also, yeah, we can barely see we can barely see these three lines. This one actually looks the most prominent, but he said the middle one here was the most prominent from looking at it. But also too, you're talking about someone wearing makeup. How do we know the makeup's not affecting how this is looking visually? Like, this is so. Now I understand why the plaintiff did not want to have the pictures posted and up for the jury to see as they were talking about the injuries, because I'm looking at this as a juror and I'm like, nah, y'all tripping, y'all crazy for this.
If on the Fitzpatrick scale she was a 1, would the scar be much more visible than it is in this photograph?
Objection, cultural speculation, not foundation.
In your medical opinion, did this type of injury cause Ms. Ellis to suffer pain or discomfort?
Objection, lack foundation, not justification.
Did Ms. Emani Ellis advise you in your examination of the patient that she suffered pain from this injury?
Objection, hearsay.
Yes.
And if you could just tell us again a little bit about the hypersensitivity. Is that associated with any pain?
Yes. It's a dysesthesia, meaning an abnormal sensation that's unpleasant. The dysesthesia.
The procedure that you did it take the hypersensitivity away, to your knowledge?
It reduced it. It did not take it away.
Do you know approximately by what percentage?
Objection, lack foundation, cultural speculation. Hearsay.
When you say reduced it, that's your expert opinion, correct?
Objection, legal, lack foundation, cultural speculation, and it's hearsay.
And then I just want to ask you a little bit more about whether the type of injury from fingernails would cause a break in the skin or cause there to be blood. Do you have an opinion about that?
Objection, lack foundation, cultural speculation.
Would you have expected Emani Ellis, to the type of injury that you see here, to have
Feel another objection coming.
suffered any blood loss?
Objection, cultural speculation, lack foundation.
Period. Put me in, coach.
And patients in Fitzpatrick 5, do they have more of a tendency to do their scars become keloids?
Objection, lack foundation.
Why don't you tell us foundation?
Do you have experience with keloids?
Yes.
What is a keloid?
The keloid is an overgrowth of scar tissue from the original scar.
Do patients in Fitzpatrick 5 have more tendency to have their scars turn into keloids?
Yes.
And why is that?
We don't know.
Do you believe that Emani Ellis' scar was a keloid when you examined her on November 4th?
Objection, lack foundation.
No.
Yeah, Cardi. I don't know what you're saying, but yeah.
Are there any future appointments for Ms. Emani Ellis to see you in the future?
I don't believe so.
Thank you. No further questions at this time.
All right, folks, why don't we take our morning break?
Oh, boy.
15-minute break. We'll be back at 10:45. In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 10:45.
That was rough. Oh, man. That was rough from and that was just direct exam. Direct exam is supposed to be the easy part, where you just ask real simple, basic questions about, just about what you did, your experience with the case. And he was just getting, the objection buzzsaw was in full effect, full speed. Oh, did he say, he said till 45. Oh, we're almost there. And when you've got the judge instructing you and feeding you the questions, like, hey, here's what you need to say, here's how you need to ask this question. Oh my gosh. So far, we've had the plaintiff testify. We're about to get cross-exam, which is where the real meat, the real good stuff comes out. But so far, my feeling on this case is, I think if Cardi gets off, which I have a decently solid feeling that there's a good chance that she gets held not liable for any of this. It's not going to be because of whether or not she did it. I happen to believe, I think there was a confrontation. I think she probably did get up in her face and probably did put her finger in her face with the long nails. To me, that seems likely. But also, I think the security guard, the plaintiff, instigated the incident herself, which she testified to herself, that she was in the elevator, the doors were closing, about to take her away. She heard Cardi say something. She stopped it, opened the door again to go out, and in her own words, she said she went out to clarify. It's like, we know what that means. What'd you say? You want to say that to my face? and yeah, just got up in her face. And so I believe the girlies were fighting. Like I said, Tory Lane's case is what everything always relates back to, because that case started with Meg and Kelsey were fighting. The girlies were fighting, and here we have it again. The girlies are fighting again, and but yeah, I think Cardi if she gets off on this, it's going to be in large part just because the plaintiff's doing a terrible job putting on their case, like horrible job.
Secondly, local rules are also pretty specific on brief legal grounds for objections. I don't want back and forth on arguing objections. If there's going to be a request for a sidebar, we can address it that way. I don't generally grant sidebars, but I don't want arguments regarding objections in front of the jury.
Sorry, Your Honor, the error on my part. I didn't
That's right.
know that.
But you do want the grounds?
Yes,
Okay.
brief legal grounds.
Like, here's, yeah, so.
Your Honor, may I ask a quick question about our witness?
Sure.
So my client's mother is here, and she's her only day off.
Okay.
I want to swap her for the grandmother, or add her in as a witness.
Is she on the witness list?
Yes.
Oh, any issue with that?
It would be nice to have 24 hours notice. We haven't been getting that, but
I don't have an issue with that.
I don't know. We don't either, Your Honor.
Okay.
But it would be nice.
All right. You got 20 or 30 minutes across here?
I would say 30.
Okay.
And it's going to be Mr. Matt.
Okay. All right.
Oh yeah. Cross-exam. I think the jury's coming back in now. Maybe?
Examination of Dr. Mullock, and sir, you're reminded you're still under oath?
Yes.
All right.
All right, remember, cross-exam. It's all about impeachment, impeaching credibility, and leading questions. Now you actually can lead them and ask these types of questions of, oh, isn't it true, XYZ? Or would you agree with me, XYZ? Doing that. And also, so that's just the nature of the questions we're asking. Also, impeachment. And remember the two-step framework for impeachment, as I said in the last stream. It's all about setup and takedown. You set them up with something, a fact that they've already established that you know is incorrect or inconsistent with a different fact. You set them up, get them to recommit to that fact as being true, and then say, well, actually, how about this other thing that you said previously? You said something totally different before. Isn't that true? And boom, now you've just caught them in an inconsistency. Hit them with the, so were you lying then or are you lying now? Yeah, set up, takedown. That's what we're looking for here, as well as the leading questions. But also, too, one more thing. We're talking about expert testimony. The one thing you want to avoid as a lawyer examining an expert witness is to not get into the weeds, into the details with the expert, because they are an expert for a reason. They know their stuff. They know their subject matter. If you get caught trying to get in a little back and forth on something that they are an expert on, it'd be like them trying to get in a back and forth with you as a lawyer about some fine point of law where you can just walk circles around them on the law. Well, guess what? They're going to be able to run circles around you on whatever they're an expert in, which in this case would be plastic surgery, reconstructive surgery. So you don't want to get into the weeds on details like that.
Did plaintiff come to you for evaluation or treatment in 2018?
No.
The first time you saw plaintiff was not until 4 years later in November 2022.
Your voice is very soft and very sorry.
No problem. The first time that you saw the plaintiff was not until 4 years.
And look, we got the baby going. Cardi's got 3 lawyers. She's got the older white guy, the lady, and now this young guy. Curious. It seems to me they're not too worried about the cross-exam of this doctor. If they're putting up their young guy to do it, it's going to be not very long. Just pointing out stuff that the jury probably already intuitively understands, like he just started off with. It's like, it's true you didn't see her in 2018, right? Yeah. Well, and you saw her not until 2022, right? 4 years later. Yeah. So it's going to be some pretty simple basic stuff.
4 years later in November 2022. Is that correct?
Correct.
And the photo that we looked at, trial exhibit 228, that was taken in your office before any treatment. Is that correct?
Yes.
It was taken the first time that you saw yourselves.
Correct.
So that photo, that's going to be the worst photo or like as far as showing the scar. And I guess in that sense, it's the best photo for showing it, because that's where it's going to be the most prominent before any treatment was done. But yeah, the fact that the plaintiff, you only put in one single photo of these injuries, like you didn't think to document. Let's do the before and after. Let's show that. So that way, at least as the jury, you can see, okay, here's what it looks like when it's actually normal, and then compare that to the original photo. Maybe they can start to see some difference there. But yeah, if you're only putting in one singular photo, I don't understand what the plaintiffs are doing.
Could you please open the white binder to Exhibit 4? And looking at the first page.
Yes.
Thank you. This is your medical evaluation document, is that correct?
That's correct.
Everything on the first page of this document was reported to you or your staff by Ms. Ellis, is that correct?
Yes.
So, for example, you're not diagnosing Ms. Ellis with headaches or depression?
Correct.
This is good. Point that out. Anywhere the report says emotional distress or sleep problems, like, yeah, that's not anything he diagnosed. That's what she reported. It's good to highlight that.
According to this medical evaluation document, plaintiff told you or your staff that the scar was caused by another individual who placed their long fingernails with sharp objects in her face. Is that correct?
Yes.
Did you ask Ms. Ellis about other possible causes of the scar?
No.
At the time of your evaluation, were you aware that Ms. Ellis had been in a car accident and hit her head in 2021?
I'm not sure if I knew then.
Good
I don't
question.
think I knew then.
All right. Way ahead of it over here. I already brought
At
that
the
up.
time of your evaluation, did you know what Ms. Ellis was doing for a living after she was terminated from her job as a security guard?
No.
Do you recall answering my questions in your deposition in this case?
Yes.
You were under an oath to tell the truth in that deposition, is that correct?
Correct.
Uh-oh. Y'all feel what's happening, right? You feel the setup happening?
You recall testifying at your deposition that, based on your examination, the most plausible explanation for plaintiff's scar is that a right-handed person struck downward on plaintiff's left cheek with both the index finger and the middle finger.
Objection to state's testimony.
Yes, roughly. I still believe that to be true.
And here's the kicker, though. Even if we're to grant that these are scars caused by fingernails from a scratch from someone with long fingernails that broke the skin, the burden's on the plaintiff to prove that Cardi B, it was her fingernails that did that. And at no point in the intervening 4 years from 2018 until he saw her in 2022, that it was any other incident of her getting in a fight or altercation with anybody else during those 4 years that may have caused that. And I got a story about this from my prosecutor days of clear damage that happened, and it was in the form of some windshield that got smashed out, and trying to blame it on somebody, and just it being completely a lie that the victims made up to try and just get the windows paid for, and it became so obvious that it was a lie. And I just stopped the trial in the middle of it because when I realized that my victim, who told me the story, was just completely full of it, and the defendants were completely innocent, and they just were trying to get their window paid for by somebody they didn't like, so they basically framed them. I was like, that was bad. That was bad for them. So I bring that up to say, how do we know that she wasn't scratched by somebody else, but now she is trying to use Cardi B as basically the scapegoat because Cardi B's got way deeper pockets than some random lady who scratched her in a fight at some other point.
Sorry. Sorry.
In your previous answer, you testified that was roughly what your testimony was in your deposition. But that was your exact testimony, wasn't it?
Oh, I don't know. I don't have the transcript here. I can't remember exactly what I said.
Allow me to refresh your recollection then with the exact transcript.
Could we please look at the deposition transcript from page 76, line 9, page 77, line 3?
Do I have that anywhere? No.
It'll appear on the document.
I don't have the transcript. This one I don't have. It was trying to get it from their court order, but they didn't get it.
I haven't seen the objections in the deposition, so go ahead.
Thank you. In this action, are you offering an opinion as to whether or not the scar that you diagnosed was caused by the defendant in this action?
Well, I can't say it was caused by any one person. If you ask me the most logical explanation, it looks like fingernails to me, striking in a downward direction. That's the most plausible example, or the most plausible explanation for the position of the start of the scars, or the higher position of the right scar, well, it would be by a right-handed person to the patient's left side of their face, which is the right side that we're observing. Starting at the top, they both start at the right level for one being an index finger, one being a middle finger. The middle finger one is a little deeper and wider, as it would be on a middle finger. And then the index finger continues on down, further than the middle finger stretch. So that would be the most plausible explanation for me, given the appearance of the scars and the finding of the scars. That's my opinion.
Yep, and I'm not even really in a position to dispute that. It looks like if what he's saying is true, that there was a clearer picture and it looked like 3 clear lines like that, yeah, that probably is a scratch marks from fingernails, but that still doesn't line up with how you're saying you were pointed. She was pointing in your face and hitting your nose and then hitting you like that, because the pointing motion is going to create this sideways line. It's not going to create an up-down line. Yeah, I don't see at all how we're proving that Cardi B is the one who did this.
The only treatment that you provided to Ms. Ellis was 2 sessions of microneedling, is that correct?
Yes.
And that was in 2023?
I'd have to check about the dates, but I believe so.
Microneedling involves the use of a device that looks a little bit like an oversized pen, is that correct?
Well, pens don't look that way. It has a head on it that reciprocates. It has a motor in it, so it's not really like a pen.
It's something that you hold, cylindrically shaped?
Yeah, you hold it in your hand, yeah.
And during each of those microneedling sessions, you moved that device 5 times across the 2 centimeter area that you're describing as a scar, is that correct?
Well, I also did areas to the periphery of that as well. So there was as I explained to you in the deposition, there was, and showed on the photograph, there's a larger area of changes of the skin, which I would characterize as scarring. So I did those areas as well. So it wasn't just on the main scar, it was also on the area to the periphery of that scar.
It was not, the microneedling procedure was not done on the plaintiff's entire face, is that correct?
No.
We have a couple negatives there.
Triple.
You said it. Triple negative.
Thank you, Your Honor.
Did you do it over?
Yeah, thank you. Did you use the microneedling device on the plaintiff's entire face?
No.
And the actual process of moving the microneedling device across the plaintiff's scar took you no more than 2 or 3 minutes, is that correct?
Yeah, it's probably a little more, but roughly that.
And 2 or 3 minutes to get paid $6,500. Oh my gosh, that is efficient use of time. And he's only making $2,000 for the hour. Man, if he was making that rate for the hour, what would that be, like 150 grand? Whew.
Neo Surgery Center is your business, is that correct?
That's correct.
You're the sole owner?
The sole owner, yes.
And looking back, this is White Binder Exhibit 1. Turn to page 1.
Yeah, so far so good on the cross. There's really not much you're going to trip him up on as an expert. Yeah, so it's probably going to be not much longer on this cross exam.
And what are we looking at? I'm sorry.
This is page 1.
I'm sorry?
Page 1, Exhibit 1-001. Do you see that?
Oh, yes, I see that.
Did you create this document?
No.
Is it correct that the total amount of charges in this case between you and your Neo Surgery Center is $17,500?
Yes.
And I believe you testified earlier that $1,500 of that amount was for your initial evaluation. Is that correct?
That's correct.
That leaves a combined total of $16,000 for the 2 microneedling sessions. Is that correct?
Yes.
And that's $8,000 per microneedling session?
Well, it was surgery, done in a surgery center with surgery staff, so it wasn't really a microneedling session. It was a surgery.
I'll move to start this non-responsive.
Please disregard the past response.
Your fee was $8,000. Scratch that. The combined total was $8,000 per microneedling session. Is that correct?
Do you mean just for the microneedling or for the preparation of the patient and the post-operative care of the patient? I just don't understand your question.
He's running into part of the risk now of getting too in the weeds on an expert topic. I think the jury gets the point that yes, surgery is expensive, but also this surgery here was very short. So I think the jury kind of sees where the truth is here. As a lawyer, the more and more he's going to double down on this topic, the more and more he's stepping into the territory of appearing unreasonable in front of the jury.
Are you required to be a board certified plastic surgeon for microneedling?
What kind of micro?
And look at that. He moved on. Well, actually, wait. Did he move on?
Do you recall testifying in your deposition that a nurse practitioner or physician's assistant can perform medical microneedling, the type of procedure that you performed in this instance?
Under certain circumstances and under the supervision of a physician, they would be allowed to perform that. But however, they would not be allowed to perform a surgery independently. So I don't want to conflate the two.
You also testified at your deposition that there's no particular formula that you used to calculate this $16,000 fee. Is that correct?
Yep.
Well, it's based on my experience as a medical director for 25 years.
And the value.
What the usual and customary fees are for these procedures. So it's not just randomly chosen.
And yeah, it's what the market will support. If people will pay you the price to do that, then yeah, why not charge it at the price people are willing to pay? Because if you start going too low in your price, then you're going to get flooded with too much work and not enough value. So yeah, that's just classic free market principles, supply and demand. If demand is high, then you're allowed to set your price high.
And is your testimony that the fee you charge is usual and customary in this community? Is that
Yes.
correct? You also testified earlier that the plaintiff was charged for your services on a lien basis. Is that correct?
That's correct.
And by lien basis, do you agree that means that if the plaintiff wins this case and is awarded money, you have a right to collect your fees from the award?
Objection misstates the testimony of the witness.
Well, I don't believe that's what happens. I believe the patient owes the money for the services rendered, regardless of the outcome of the case. So it's not just if the patient wins, it's regardless of the outcome of the case.
Has Ms. Ellis paid you for your services today?
No.
Objection, that's an answer.
Yeah, that wasn't asked.
If Ms. Ellis had come to your office as a patient who didn't have a pending lawsuit and had the exact same procedure done and paid for it then, would you have charged less money than you charged in this case?
Well, there were many aspects of her presentation that would not be found in a typical cash-paying patient. For example, the hypersensitivity of her injury and the nature of her scarring. Those wouldn't be typically found in a cash-paying patient.
What does that mean?
So how can I equate the fees between someone who has injuries versus someone who comes in for cosmetic purposes?
So basically, he just said in a lot of words without trying to say it, but he said it, that, yeah, it is a different fee between someone who pays me up front versus someone who's got a pending lawsuit, which that's pretty sus. What do you mean? Are you inflating your price for people in a lawsuit? So that way you can make more money based off of their victory in the lawsuit? Ooh, it sounded like kind of that's what he was saying without really saying it, which that's sketch.
Can't. Discussion. Are you saying that there's no possible hypothetical in which the plaintiff could have come in and presented the same injury and not have been involved in a lawsuit and just paid you cash for your services?
Do you mean pay cash or pay cash 3 years later?
Paid cash.
On the spot?
Yeah.
Yes, they would probably have a discount of approximately 20%.
So in other words, you charged 20% more because this was on a lien basis?
Yes.
So yeah, that's something for the jury to consider. Are you going to hold the full amount liable if you are to assume that the damages are correct and the injury was correct and that Cardi B is liable? Are you really going to hold the full damages over her, or are you going to do a 20% discount based on what the actual price of the services were if there was no lawsuit? But the fact that there was a lawsuit, basically, it sounds like, yeah, there's a 20% premium on what he's charging. So maybe that's, even if Cardi were to be found liable, boom, maybe right there, that's the basis for a 20% discount on the actual damages that she would owe, at least based on the medical damages. And I see, yeah, Carla Pelli, exactly. You were bringing up, yeah, his con artist charging $17 grand for microneedling on invisible scars. That this surgeon, he's it's a little bit sketchy so far.
How to find the right
Very curious. Very curious indeed.
Ciao.
Oh, sorry. No further.
All right, redirect.
Yes, sir. Thank you.
All right, cross-exam over. Not much to get through.
All right.
Let's see if plaintiff's lawyer, if he does any better on the redirect than the original direct.
Dr. Mulligan, you testified about the injury being caused by a right-hand person or a left-handed person.
Objection, this here present testimony.
Assisting.
Does it? Well, strike. Could this injury have been caused by a left-handed person?
Objection,
I withdraw the question. In this case, the defendant is a left-handed person. Does that mean that she cannot have caused this injury?
Objection,
Objection.
Assisting.
Yep.
Counsel asked you whether this injury was caused by a right-handed person. Do you remember the question he asked you?
Yes.
I think he was asking what his testimony was.
Did counsel ask you about your testimony in the deposition that you gave on March 27th of 25?
Yes.
And during that testimony, counsel asked you and showed you a small segment of your deposition where you said that this injury was caused by a right-handed person. Do you remember saying that in your deposition?
I said most likely.
The fact that the person is, well, strike that. For example, I'm left-handed. If I take my right hand and I scratch something, is that possible?
Objection.
Assisting.
The objection buzzsaw. It's revving up again.
When you said right-handed person, did you mean that the injury, in your opinion, as an expert, was caused by the right hand?
Objection.
No, he can ask. Yeah, he can answer
What
that.
did you mean?
Well, if it's on the left side of the face, the most likely explanation is that it was done by the right hand of the perpetrator, for want of a better word.
And
Just based on the positioning of one person, assuming one person was in front of the other.
And if you look at the perpetrator there,
Objection, Your Honor.
or I'm sorry, I withdraw that. If you look at the defendant, Cardi B sitting there, she has two hands, right?
Objection, Your Honor.
Take a look, doesn't she?
Objection, Your Honor.
Does the defendant
What do
have
we-
two hands?
You need to wait for the court to rule on the objection. The objection's a rule.
You can look. Please stop.
Yes, she has two hands.
Cardi B, I will represent you as left-handed. In your testimony at the deposition, if you were to take that the way that they want you to take that, it would be impossible for a Cardi B to have caused this injury. However, there's no question. The question is this: isn't it true that Cardi B, who's left-handed, could have used her right hand
The lawyer's trying not to laugh because what is he saying? It's not even a question mark.
to scratch Emani Ellis on the date of the incident?
Objection, my foundation outside the scope.
It's beyond the scope, counsel.
What's that, I'm sorry?
Is that objection assisting?
When you testified that it happened by a
Bro.
right-handed person, did you mean that the person actually writes with their right
Counsel,
hand?
he said it was most likely caused by. That was his most likely explanation. He didn't say who caused it or how.
When you said most likely caused, did you mean it was caused by someone using their right hand, or the fact that they write with their right hand?
Objection, compound.
That's my question.
My apologies. Objection, compound. My foundation outside the scope.
Oh,
Yeah, he can answer that. Yeah.
It doesn't matter. I mean, in my opinion, it doesn't matter. It's just the left side of the face was scratched.
With the right hand.
Typically, if people are facing each other, it would be the right hand. It's hard to reach across with the left hand unless the person was standing to the side, which may or may not have happened. I don't know.
And in
And just the plaintiff's lawyer, it's like, we get the point you're trying to make here. I think the jury gets it right now. But continuing to try, once again, what did I say earlier? Lawyers tend to have pretty large egos, especially trial lawyers who like to be in court and stand in front of people and be the center of attention, asking questions and arguing and trying to persuade. So, and I said that from personal experience, plenty that I deal with, lots of big egos. And look, the plaintiff's lawyer here, he cannot let it go. He can't let go that he keeps getting objected to. So he keeps trying to wiggle and find other ways around. At some point, you have to recognize you just got to cut your losses and just move on to the next topic.
this case, the defendant.
Yeah, it's you. The objection buzzsaw is in full effect. Exactly right. You keep running into the buzzsaw. At some point, you need to start saying, "I'm sick of running into this buzzsaw. Let me actually try. Let me face a different direction and try running in a different direction instead of running into the same buzzsaw over and over and over again."
And could have used both of her hands to scratch Emani Ellis if she wanted to. Is that true?
objection assisting. He's not a causation expert, I don't think, right?
No. It's,
Okay, so stop talking about causation.
okay, sorry.
The judge directly saying, "Stop talking about causation." Bro, this is so bad for plaintiff. And here's the thing. Here's the worst part of it. So I keep pausing, but geez, the worst part of it is this is his witness. Like he's running in. It's one thing to run into an objection buzzsaw when it's on cross-exam. It's for a witness that you did not call. But if this is a witness that you are calling to support your case, one would think that you would have a pretty solid plan together of how you're going to ask them questions and elicit their testimony. Like either he had a plan, but it was a terrible plan, or he had no plan, which is also a terrible plan. Because how are you going into court for such a big case like this with no plan?
When counsel asked you about microneedling, the fact that it takes 3 minutes or 5 minutes or 1 minute, that is the actual time that you're working on the patient's face when you're doing that procedure, correct?
Well, not really.
That's good.
Not really at all, because you can't just walk up to somebody and stick a needle in their face. You have to prep them. You have to make sure you're working on the right side of the face. You have to make sure your equipment is there. You have to make sure that the person is calm, that they're numb, that they've been numbed by topical agent, that they've been numbed by a needle with lidocaine in it, and the patient is comfortable. They're adequately protected against lumps and bumps on the exam room chair. So you can't just walk up to somebody and cut their face. You have to do all this preparation. That's part of the surgery, and it's part of the surgery after the surgery to make sure they don't have an allergic reaction or they don't have welts resulting or a burn injury that is incurred. All those are part of the surgery. It's not just walking up and cutting someone in the face. Yes, the actual pressing of the button might take 3 minutes, but without the proper preparation or the proper follow-up, it's not a surgery.
Mm-hmm. And in this case,
fair.
When you saw the patient on the 2 times on February 20th, 23 and March 20th of 23, you performed surgery on this patient, correct?
Yes.
This was not a outpatient medical. Was this an outpatient? Oh, sorry, I don't draw it. This was an outpatient surgery, correct? Outside the scope.
So a surgery means that you're in an operating room with a certain level of accreditation, and you have a scrum technician, and you have a registered nurse, and you have a doctor. So those are necessary for the procedure to be performed as it is. And that's very different from doing a cosmetic microneedling where the depth is 1/2 of a millimeter, not 2 millimeters. So 1/2 of a millimeter doesn't break the skin. It doesn't draw blood. But when it's 2 millimeters, that's as deep as the microneedling goes. That goes through the dermis and causes blood. So that's very different than a cosmetic microneedling. It's totally different. And it's done in a different setting. So you can't confuse the two. They may be called microneedling, but they're very different. One is a surgery, one is an outpatient procedure done for cosmetic purposes.
Yeah, fair enough.
And for the 2, if you can look at your exhibit book number 4, look in the white binder.
Yes.
4-005 or 4-006. That's a 2-page document which says operative note.
Yes.
And we go to the one before it. Well, straight. When you wrote the operative note, is that the same type of operative note you would write for other types of surgery, such as breast augmentation or nose surgery?
Objections, irrelevant, outside the scope.
Yeah.
And back to the 3-minute question that you were asked earlier. From the 3 minutes, if we were to subtract the 3 minutes out of the whole procedure from the start to finish, how much time elapsed when Emani Ellis came to your office and left, if you understand the question?
Estimated at 2 to 3 hours.
2 to 3 hours?
Yes.
And you were required to use your operating room during those 2 to 3 hours?
Yes, the operating room or the recovery area.
And you used local anesthesia?
Use topical anesthesia first and then local anesthesia.
Okay. And the reason you charge 20% more for patients that are treated on a lean basis, is that because of the fact that you're required to wait for payment? Objection leading.
Yes, 3 years. You have to wait 3 years.
Okay. And in this case, not only have you had to wait for 3 years, you also have to suffer the consequences of the fact that the bill was billed $4,000 less, according to your earlier testimony, times 2, correct?
Objection.
Earlier, you testified that your bills of $2,500 should have been billed at $6,500. Is that correct?
That's correct. That's my fault, but that's mine.
And if the procedure is going to be done again, or at this time the same procedure was done, it wouldn't be $6,500. It would be $9,500.
Objection outside the scope.
Yeah. So outside the
this point,
scope,
Mr.
we've heard that objection a few times. Basically, when you're cross-examining or redirecting, you can only cross-examine or redirect on what's already been testified to, because you think of it like a funnel, a narrowing down. And so you're on redirect now. Your initial direct exam, you can ask whatever you want that's relevant. And then cross-exam will kind of go over what was testified to and narrow that down. Now redirect, you can only redirect about what was cross-examined about. So right, it's this narrowing effect. And so anytime he starts going into a new topic that was not subject of cross-exam, that's outside the scope of cross-exam, and therefore doesn't come in not relevant. So we've heard that objection quite a few times, and it's true. Yeah, he keeps trying to go into more and more stuff. But if you want to go into that stuff, you do it on your direct exam. If you don't do it on direct, you're giving it up. You don't get to bring it up unless the defense brings it up on their cross-exam.
Emani Ellis owes you $17,500 for the 2 surgeries and the office visit that she had with you and all the paperwork and reports that you've created related to this case?
I believe so, yes.
Thank you.
All right, recross. All right, any questions from the jury? You want to write those out?
All right. Doctor's done. Well, actually, it sounds like they do. Sounds like they let the jury ask questions directly during the trial, but it looks like it's done in the form of a written question that looks like they're doing it right now. So my guess, I actually never seen this done before. It's interesting. My guess is they're going to have the jury write the question down. That question goes to the judge. If the judge considers it a good question, meaning it's relevant, it would call for admissible testimony, and not hearsay, proper foundation, stuff like that. If the judge finds the question is legally relevant and admissible, then he would pose the question to the witness himself, and then the witness will give his answer. Which I actually like this. I like this as an idea because it saves when your jury goes back to deliberate. Sometimes they have questions in deliberations. They got to send the question out to the court, and the judge will have to do the same thing, basically, and answer the question in court. Basically, trying to get ahead of that. Like, hey, if you got questions, now's your chance. Ask them, jury. Although it seems it's a little time-consuming.
Card Advantage members are our favorite.
Trying to get to the actual question part of it. It's a fine, delicate balance. Oh.
I think these questions are fine to ask.
Sorry, can I add them?
Sure.
Sorry about that.
No problem.
All right, let's see.
In the nose. Did you see any evidence of a scratch on the nose?
No.
Can you tell whether the scar that you examined was caused by jewelry?
It could have been. The most likely explanation, given the trajectory, is fingernails, but it could have been jewelry.
All right, can you offer an opinion as to the approximate age on the scar on her left cheek?
It's impossible to know because after roughly a year, the scar is mature, so it really wouldn't change very much, so you can't tell the age of the scar.
You used the term medical necessity, or I think it was asked during a question. What is your definition of medical necessity?
If the patient is likely to derive a benefit from a procedure, then you could say there's medical necessity, if they're likely to derive a benefit from it.
Generally, can a scar form without breaking the skin?
Yes, a scar can form by scrapes or by breaking the skin, either one, but it definitely can occur in superficial scratches.
So the court's going to ask its own follow-up with regard to that. So can you describe how a scar can, or what the difference is between an abrasion and actually breaking the skin?
So the skin has basically the epidermis, which is the recycling layer, and then the dermis, which is the thick layer. Most of the blood supply is in the subdermal plexus, just below the dermis. That's where the main blood supply is. So the bleeding typically happens most when that dermis is completely breached. So a laceration that went all the way through the epidermis, the dermis, and down to the subdermal plexus, that would cause a lot of bleeding. But for example, when we harvest a skin graft, for example, in a burn patient, we go through the dermis. So we take a thin piece of the dermis, and it's a bloodless plane, meaning there's not a lot of bleeding when you go through the superficial dermis. But yet, we know that people who donate have a donor area for burns. That area can scar considerably, even though the dermis is never perforated. Okay. So yes, a minimal dermal injury may not bleed, but can produce scarring.
I think you identified a scratch and then some additional scratches on the cheek. Is that correct?
Yes.
And is it your opinion that all of the scratches came from fingernails?
Well, that's the most likely scenario given the patient's history. Could it have been a dwarf with sharp toes who jumped up? Possible, not likely. But it could have been most likely fingernails. But there are many other things that would leave 3 linear marks. But just given the patient's history, that's the most likely scenario.
Well, what do you mean? But what do you mean patient's history? Are you talking about her self-report that she was assaulted by Cardi B? Or, well, yeah, what do you mean patient's history there? That seems very outside the scope of his knowledge here.
And I'm going to just rephrase this question. Is it fair to say that when you agree to treat on a lien, you're deferring payment until the resolution of the pending litigation?
Yes. So we defer the patient paying the bill until the case is settled.
But it's fair to say that, at least according to the terms of the lien, that the patient is responsible regardless of the outcome of the litigation?
Yes, the patient is responsible for the bill.
All right, thank you. Plaintiff counsel, do you have any follow-ups based on those questions?
Just one. I may run.
Go ahead.
Do you have any evidence that this scar could be caused by a car accident? Any medical record, anything at all?
Objection.
A car accident.
Okay, sorry, let's go for the necessity.
I agree, but I'll allow the question.
I don't have any evidence, one way or the other.
Thank you.
All right, anything from the defendant?
No, no questions. Don't take it.
All right, can this witness be excused?
Yes, Your Honor.
All right, thank you, doctor.
Thank you.
All right, Ms. Plaintiff, I have another witness to call.
All right.
Another witness?
Yes. Your Honor, plaintiff is calling Emani Ellis' mother as the next witness.
Does she have a name?
That's right. Ms. Schmidt, what's the first name? Leanne Schmidt.
All right.
Thank you.
Curious to see how much she's going to have to offer here. My feeling is not too much other than maybe some corroboration about timelines of like, yes, my daughter called me on this day back in 2018 and was saying, oh my gosh, Cardi B just assaulted me. And then maybe that she saw it herself, but yeah.
Schmidt. I'll go ahead and raise your right hand, please. Do you solemnly state that the testimony you may give in the cause not pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. May I please have you state and spell your first and last name for the record?
Leanne Schmidt, Leanne, last name Shmidt.
Great, thank you. You may take this seat. Please watch your...
All right.
All right, go ahead, counsel.
Thank you, Your Honor. Good morning, Ms. Schmidt.
Good morning.
You are Emani Ellis' mother?
Yes, I am.
You gave birth to her, correct?
I did.
She's not adopted, is she?
No, she's not.
Okay. And how many kids do you have?
I have a total of 5 kids.
She's the first?
Emani is the eldest.
Did she live with you up until a certain period of time?
She lived with me from the time she was born until she was age 19.
Okay. Did Emani Ellis during her time with you from 0 to 19 ever have one fight in her life?
Never.
Did she ever assault and batter anybody?
Never.
Did she ever hit anybody?
Never.
Scratch anybody?
Never.
Did anyone hit Emani Ellis in those 19 years?
Never.
I just want to know a little bit more about you. What do you do for a living?
I'm a licensed phlebotomist, currently working for Keck Medicine of USC.
And what is a phlebotomist, for those that don't know what it is?
The phlebotomist is a Greek word meaning a person who extracts blood from a vein via tube to vein.
And do you work in a medical center or hospital?
I work at Keck USC School of Medicine. It's an outpatient laboratory.
Okay. You work for the university?
Yes.
As far as, are you aware of the facts of this case?
Yes, I am.
And what is your understanding of it? Why are we here today?
Objection, yeah.
Do you have any information about an assault and battery that occurred to Emani Ellis?
Objection, hearsay, last time. Unless she was there.
Were you there?
I was not.
Were you there in spirit?
Of course.
Okay. What is your understanding about your daughter's profession in 2018? What was her profession, to your understanding?
Objection, hearsay, last time. I'm not sure what this is going on. Move on.
Was Emani Ellis a security guard from 2014 to
Objection,
2018?
leading.
Yes, she was.
How do you know that?
Objection.
You may answer.
Can you repeat the question, please?
Was Emani Ellis a security guard from 2014 to 2018?
Yes, she was.
And how do you know that?
I was there when she went on her interview, not physically there, but she did notify me of the interview, and she notified me of her hire date.
And was her plan to continue in security and law enforcement?
Objection. Why don't we move on to what she knows, not what she was told?
Do you know if Emani Ellis was interested in being a police officer in the future?
That's the same.
Yep.
Did you notice some changes in Emani Ellis after this incident of February 24th, 2018?
Yes, I did.
What were the changes that you noticed?
I noticed changes in terms of a lot of anxiety, a lot of depression, and just her general well-being has changed dramatically.
Were you advised, did you notice after the incident that Emani Ellis had a scar to her face?
I did.
And where was the scar?
The scar was located on the left side of her face.
And after she left her home when she was 19, when the incident occurred, she was approximately 25 years old, correct?
She was, yes, correct.
So in those 6 years where she didn't live with you full time, how far away was she, and did you see her on a regular basis?
Objection compound.
I would see her probably maybe 2 to 3 times a week. We would visit frequently, yes.
And in those 25 years, did Miss Emani Ellis ever, to your knowledge, sustain a scar on her left or anywhere on her face?
Yes, she did sustain that scar. I visibly saw it myself.
No, I understand, but my question is, aside from the incident, I guess the question what I want to know is, do you have knowledge if Miss Emani Ellis, your daughter, sustained this scar from somewhere else?
Objection.
Yeah,
Something
objection
else
to that.
outside of this incident?
No.
Do you have any information about that?
If there's an objection, please let me rule on it. The objection's over.
Build a website you love with Wix.
Yeah, I mean, the judge. Yeah, once again, the judge is really jumping in again, just trying to narrow down testimony of like testimony for a witness based on personal knowledge. What do you personally know, not what you were told or heard from somebody else. So that's what we really need to get into the meat of that. And the judge even said it like, I don't know where we're going with this, but just focus it in.
So your understanding is that the scar to her face was caused from this incident?
Objection. Next foundation. Call speculation.
Assistant.
How do you know that the scar was to your daughter's face was caused by this incident?
Objection.
Reading and statement of the
Over.
You can answer.
She did notify me and called me right after the incident, telling me that she had been scratched in the face and spit on.
Okay. How long after the incident did you go and see your daughter?
She
Did she come to you?
She actually came to visit me, I believe, later that day.
Okay. Did she look upset? Was she crying? What happened?
She was hysterical, upset, crying, just upset throughout the whole situation.
And
How about later that day she was hysterical? Like, I could get being hysterical in the moment, but like over time, just emotions calm down, things quell. You're saying for the entire day she was acting hysterical?
Was your daughter a fan of Cardi B before this incident?
Absolutely.
Were you a fan of Cardi B before this incident?
Yes, I was.
Are you a fan of Cardi B?
Objection. Irrelevant.
The objection buzzsaw.
You said
Non-stop.
that, your daughter was spit on. Did your daughter tell you that? Did you see that? How did you know
Your
that?
daughter mischaracterizes the testimony and false good state. And this is next foundation.
Rough.
Aside from, are you aware if your daughter had any car accidents?
Objection. Constitution.
I withdraw the question. Were you advised that your daughter had a car accident in 2021 and 2023?
Objection.
Hearsay. Next foundation.
Do you know if your daughter sustained injuries in any car accidents?
Objection.
Objection.
Earlier, you testified that your daughter had contacted you after the incident. Did she call you over the telephone?
She did.
Like, yeah, this is the extent of her testimony should really be a little bit about what Emani Ellis was like before the incident, what her knowledge of the incident was, specifically her getting a phone call. So the contemporaneous account, which is good. That's good evidence to use. And then what she noticed, her observations of her daughter after the incident, just trying to corroborate some of this emotional trauma and distress that she's alleging has happened to her. Like, that's really it. That's about the extent of what testimony she should be getting into. Not whether she's a fan of Cardi B or not a fan anymore, or whether she had knowledge or was advised of a car accident or anything like that. It's like her role in testifying here really should be very limited, especially if you're talking about trying to convince the jury. If you're going to parade the whole family through, you've got the daughter's mother, the daughter's grandmother. It's like you're making it look like this is basically a family affair trying to shake down Cardi B. And it's not a good look at all, especially when the objection buzzsaw is in full effect and you're just getting mowed down with question after question. It looks like you're trying to do way too much. And the jury, if I'm on the jury, I'm not appreciating that at all.
If the incident occurred around 1:30 p.m., how long after the incident do you believe she called you?
I would say about 30 minutes after she called.
Could it have been a shorter time?
Objection. False speculation.
Could it have been a longer time?
Objection.
How did you come up with 30 minutes?
Based on around the time that she called, it was like a little bit right away after the incident. And so my speculation is 30 minutes.
And when she called you, was she crying? Was she yelling? What was she doing?
She was hysterically crying, upset, just overall just could barely get it out. She was so upset over the ordeal.
And what did she tell you?
Objection. Hearsay.
Just so we're clear, your daughter is now 32?
Correct.
Arguably, so he's getting objected to for hearsay. Arguably, I would say that this actually comes in what she heard her daughter say over the phone, because even though, yes, it is hearsay, A, the daughter's present and able to testify. So if need be, she can be recalled to cross-examine. A. B, you can talk about not for the truth of the matter asserted, but for the effect on the listener, for effect on her as a mother, how she responded, how she felt about it. That's 2. And 3, there's an exception to hearsay for present sense impression. So what her daughter is saying to her over the phone is like, oh my gosh, Mom, here's what just happened. That's that's her daughter stating something that she presently feels, her impression of the present situation, which is, yeah, you're allowed to say that. That's allowed to come in as an exception to hearsay. So there's 3 avenues where these statements actually should come in, but the plaintiff's lawyer isn't bringing up any of them. That would be the way to do it here. He asked the question, what'd your daughter say to you over the phone? Defense, objection, hearsay. Judge says sustain it. I'd say, Judge, this could come in as a present sense impression. It's not offered for the truth of the matter asserted. She's here to testify. Like, he can give these reasons and see if the judge won't reconsider his ruling. So the fact he's not doing that means he either doesn't know about these exceptions, which seems likely considering the presentation of all the evidence, or he's just making a deliberate choice to try and not piss off the judge. But if that were the case, that doesn't make sense for all the other things he's doing that are just pissing off the judge. So, so this lawyer, is just not impressive at all.
In these 32 years, have you seen your daughter fight physically with anybody?
Not one fight, not even in school.
Okay. Would you consider her a peacemaker?
Objection. Character evidence.
Oh, you can.
Absolutely.
And why is that?
Emani is a very compassionate person. I believe that she has very good. She has very good.
This seems completely improper to me. You're bolstering the character of your witness. Yeah. Plaintiff's attorney using wise tactics at any point in this trial would be a surprise. Macrograms, I completely agree. We're on our 3rd witness, and the objection buzzsaw has just been in full effect on all 3 witnesses, and it's rough. But yeah, to me, this testimony is completely improper because you're bolstering the character, which typically we try and keep character out of court because we don't want the jury to be influenced or biased by anything that's not the straight up facts of the case, like character. So yeah, to me, this is completely objectionable. It should not be coming in, but the judge overruled it. So and at the end of the day, the judge is the referee. They decide what comes in, what stays out. So it's his call to make. But yeah, to me, the prior hearsay should come in, and this character evidence should stay out. But judge has gone the other way on both of those.
Character in terms of having a sense of sensitivity to others and how they feel.
Do you know what Emani Ellis does with her time now as far as work?
Objections, explanation, hearsay.
Do you ever speak with Emani Ellis about her current profession?
No, not really.
And she's currently somewhere in the medical field, is that correct?
Objection, explanation, speculation, and something.
Earlier, you testified that Emani Ellis was spit on. Where did you learn that information?
Objections.
Yeah, hearsay.
Sorry. Have you ever seen Cardi B before today?
On television.
How many times?
Too many to count.
More than 5?
Yes.
More than 50?
Objection, relevance, yeah.
When you saw her in television, isn't it true that her nails are always very long?
Objection, explanation, speculation, and relevance.
Does if you look at the defendant now, do you see her fingernails?
Yes.
Would you consider those short, long, or medium fingernails?
Objection.
Short.
Did you, when you saw Cardi B, did she ever have fingernails that size?
No, they're always very long.
How long?
2 to 3 inches long.
So what you see now is not normal, correct?
Correct.
No further questions. All right, Carlos.
Thank you, Your Honor.
Oh boy. But now it's like, what even is there to cross-examine her about as far as she really doesn't know much? I mean, some of her observations about her daughter, but it's like, I don't know. But of course, they've got the deposition. They're always going to be able to refer back to that. And remember, like I always say, cross-examination. It's all about pointing out inconsistencies and impeachment. So what do you do to impeach? Set up, take down. So let's see if we get any of that here.
Just a few questions. You love your daughter, right?
Absolutely.
And you're here to help her, right?
Yes.
And you believe her?
Yeah, the batting average, like if we put it in baseball terms, Yeah, he's probably hitting about 25% on these objections as far as asking questions that are not objectionable. It feels like 3/4 of the questions he asks are getting objected to and objections sustained. It's just, oh man, yeah, not a good batting average.
Yes.
And you believe her even if you don't need evidence to believe her, do you?
I believe her.
Okay. Were you aware that when she was, when this happened 2 days after the alleged incident, that your daughter wrote her boss and admitted yelling and cursing, well, yelling at Cardi?
Can you repeat the question, please?
Objection, hearsay.
Are you aware that?
No, this is completely relevant. Because yeah, and also too, you opened the door as a plaintiff. Here's the big thing about being in trial: a lot of stuff stays out, but if someone brings something up, it's called opening the door, and the plaintiff completely just opened the door to the lawyer just completely opened the door to the plaintiff's character by asking her mother about, oh, she's a peacemaker, right? Well, yeah, now you can completely impeach that with the report that she submitted, stating basically her involvement in the incident and that she was an active participant in this altercation. And yeah, you've just completely opened yourself up to get blindsided by that. Yeah, I don't even know why you would go down that path as a plaintiff.
That your daughter, in an incident report to her boss 2 days after the alleged incident, admitted to her boss, to her supervisor, that she had gotten into a screaming match with Cardi and had yelled at Cardi.
Objection, which states the document.
Are you aware that your daughter apologized to Ally for her misconduct that day?
Objection, which states the document.
Are you aware of that, ma'am?
I was not involved in that conversation, so no, I was not aware of that.
And were you aware that in her report to her boss 2 days after the incident, she instead claimed that Cardi had scratched your daughter's nose?
Again, I was not a part of that conversation, nor email or text, so I do not know.
Okay. All the questions I have for you. Thank you.
Thank you.
Yes, sir.
Yeah. So I said there's really not much to get at on the recross or on the cross exam, just because she really didn't have much she's able to testify to. But that's a great one. There is the yeah, you want to open the door, and that's why you got to be paying close attention in court, because when someone opens the door like that, the cross exam here was probably going to be very limited. It would be my guess, limited than what we just heard, even more limited. But the fact that they were listening closely and they heard her open the door to the plaintiff's character, then yeah, just completely opened her up to them bringing up the incident report and asking her like, hey, did you know that your daughter said this and your daughter admitted to doing this? And all she can do is say, well, I wasn't involved in that, so I don't know. It's like, either way, you're still reminding the jury once again of this incident report that the plaintiff wrote herself, where she admits she was an active participant in this altercation.
Actually, I don't have any questions.
All right, any questions from the jury? All right, can this witness be excused?
Yes, Your Honor.
All right, thanks for coming down, man.
Thank you.
All right, cool.
All right,
That
we
was
have another witness call.
Yes, Your Honor. Plaintiff calls Diane Schmidt. Can this witness stay here now that she's testified?
If she's not going to be recalled.
She might be recalled.
What's that?
She might be recalled, yes.
Then no.
Thank you, Your Honor. I will get her.
That's it for the mother. Let's see who's next. I think there's a Diane Schmidt. I think this is the grandmother.
H-M-I-D-T. Great, thank you. You may take a seat.
Yep.
Please watch your step.
Grandma. Once again, though, what is she really going to be able to testify to here?
Thank you, Your Honor. Good morning, Mr. Schmidt. You're Emani Ellis' grandmother? You live in Las Vegas?
I do.
And what did you do for a living before you retired?
I work for City National Bank
For how many
here
years?
in LA.
How many years?
Probably 12 years, 13 years. I retired from there.
Did you, you are, no, sorry.
Like, really, yeah, really all you're going to be able to get grandma to testify to that's admissible is, once again, kind of the before and after of the plaintiff, of like her demeanor and maybe some of the emotional effects on her. But gosh, that's really it. And so maybe they're going to try and do a little bit more of the credibility or the character stuff of like, oh, she's a peacemaker. But now you're just going to open the door again to the incident report being thrown in your face of like, well, what do you think about this? So, but yeah, I really don't expect much they can get out of grandma. And what this is showing the jury is like, yeah, this looks like it's a family affair, which I think is a terrible look if you're trying to prove this case and just say, oh, yeah, I have a victim here who's been horribly, deeply victimized. But now you're going to parade every member of her family through the court to talk about how sweet their innocent, sweet little angel is, and yeah, it looks like a shakedown by a family. That's just what it looks like.
On how many, what type of basis would you see Emani Ellis over the last 8 years?
She tries to come see me every month. Unless business takes her elsewhere. She's there almost every month.
What if we go a little further? When she was born in 1992 up until the present, you saw her regularly?
I saw her every week. Every week. In fact, when she came home from the hospital, she came to me. Her mother was sick. She was sick for a while, but she came to me every week, and her sister.
And you were involved in her day-to-day activities? The weekly activities?
Sometimes when she asked or whatever.
Did you ever get in any fights, to your knowledge?
Never. She was always the mediator. She always tried to keep things calm. She has 5 brothers and sisters. She's tried always to keep it. She's the eldest, so.
Do you consider her a peacemaker?
Oh, definitely.
All right, well, he's opened the door again.
How she got the scar to her face?
The objection.
Do you know how Emani Ellis got the scar to her face?
Objection. Yep. The buzzsaw.
Are you aware that Emani Ellis was assaulted and battered in 2018?
Objection.
Focus on what she knows.
Do you know if Emani Ellis was ever assaulted?
Yes, I think she called me almost after it.
Yeah, did they fly in grandma so she could say her interaction with Cardi B made her sad? Yeah, pretty much. It seems like it. It's a family affair, man. And once again, like if the definition of Einstein said this, that the definition of insanity is to do the same thing over and over again and expect a different result. And I don't know how many times you have to get sawed in half by the objection buzzsaw before you realize, maybe I should try something different. But it's happening. It's happening again.
What are some of the changes? Well, start that. Did you notice a change in Emani Ellis in some point in her life?
Well, after this incident, she was depressed. She was really disappointed.
These are good
I think
questions
she liked
here now.
Cardi before the incident, and she was shocked that she was reacted that way, and she just was depressed. And every time she relived it, listening to her music on the radio, and it was kind of she couldn't really avoid it. So it affected her because she couldn't make it right.
And the incident you were just telling us about, when approximately did it happen to your knowledge?
It was right after my birthday, but it was I don't know what the year was, but it was a long time ago.
When is your birthday?
February 16th.
If I told you the incident happened on February 24th of 2018, would that refresh your recollection?
Yeah, that sounds pretty clear. I don't know. Is it 2018?
Yes.
Yeah, that's about right.
And you noticed a change in your granddaughter after 2018?
Yeah.
Right after your birthday?
Yeah.
Did you see the scar to Emani Ellis' face after February 24th of 2018?
Objection, my foundation leading.
Oh yeah, that's a good question.
I can't. Yeah, I did. She was she's a pretty girl. She wants to maintain her face, and it was like she felt it damaged her face.
But here's the other thing: mom or grandma could have been used to maybe get in pictures that they had taken of themselves, especially if you're talking about a scar that persisted for years. According to the doctor, he treated her for a scar 4 years after this happened. So you've got 4 years of interactions with her saying, apparently going to see mom 3 times a week and going to see grandma once a month. It's like, you're seeing them all the time. What do you mean you have got 0 photographs of yourself during this time period that can show, oh my gosh, look, there's a scar on her face. Like, nothing. You've really got nothing to prove this. You've just got mom and grandma saying, yeah, I saw it. It's insane.
She was trying to make that right.
All right. Now, let's take it from birth, 1992 up until February 24th of 2018.
Okay.
In that time period, did Emani Ellis, to your knowledge, ever sustain a scar to anywhere on her face?
Not that I know of.
Did you ever see a scar during that
Never.
time period? And after this incident on February 24th of 2018, you with your own eyes saw the scar to her face?
Oh, yeah, I saw it.
Okay. And when she got plastic surgery from Dr. Mulligan, did it improve?
Oh.
You can answer.
Yeah, he was actually a very good surgeon. He covered it very well.
And it is still present now a little bit, correct?
Very slightly, but she's lucky.
No further questions. Thank you.
Thank you.
All right, we're gonna get back into the incident report. Calling it now.
Hello, Ms. Bishop Schmidt.
Hello.
My name is Peter Anderson. I just have a few questions for you. Thank you for coming in.
Now,
I take it you love your...
I will say this. Another pro tip: cross-exam, knowing the optics of the situation. Could this attorney go in hardcore on her right now? Sure. How is that going to look to a jury that you're going in hard on this little old lady who just loves her granddaughter? Got to be careful about this stuff. Same thing as a prosecutor back when I worked on cases, some of these child sex crime cases, where it's the victim here is a child, like a 12-year-old kid, as I was on the prosecutor's side, so no, we were representing her, we were advocating for her, but the defense attorneys, it was always a battle for them to figure out, okay, because you need to impeach the kid's credibility on their story of the assault that, stepdad did or whoever. And so you need to try and poke holes in their story, but you've got to be so delicate about it because you don't want the jury to look like you're bullying this 12-year-old who's clearly traumatized in retelling the story and had to relive it in front of a bunch of strangers. So it's like, you got to be real careful on your cross-exam about the optics of the situation. So got a nice, sweet little old lady. Seems like a nice lady. Yeah, you just got to be careful going in too hard on her, but I think he'll do fine here.
Your granddaughter, correct?
Yeah.
And you're here to help her, right?
Well, if I can.
Thank you. And I apologize for objecting. It's one of the things that I have to do in order to be a lawyer.
I understand.
But thank you. I appreciate that. And you don't need evidence to believe her. She's your granddaughter, right?
She either has it or she doesn't. I mean, you either see it or you don't.
Okay. You know she was employed as a security guard, right?
Mm-hmm.
And
Yes, what?
That's a yes.
Yes.
Yeah, sometimes it's hard for the court reporter if someone says,
Okay.
So, you knew she was employed as a security guard, and you know that she was fired after the alleged incident with Cardi B.
Objection, misstates the testimony.
Yeah, that's a misstatement.
Well, let me go back. You knew that she was employed as a security guard, right?
Yes.
And were you aware she was fired?
Objection calls for speculation.
But
you can answer the question. Were you aware that she was fired as a security guard?
it was my understanding she was told that she was going to be fired.
Okay.
By Cardi.
Were you aware that at the time, 2 days after the incident, she apologized to the security guard company for her own misconduct that day of the alleged incident?
I told you she's a person that tries to make sure everything is straightened out, so she apologized for what she saw as a disturbance, I think.
Were you aware that she apologized to the security company that employed her for her own misconduct?
Objection calls for speculation.
Did she ever tell you?
No, I didn't discuss that with her.
Did she ever tell you that she told the company that employed her that Cardi scratched her on her nose, not her cheek?
Objection, misstates the document.
No, it's...
She didn't tell you that, did she?
What?
She didn't
She
tell you
just that she was like, her finger was all over her face. So I mean, it could be land anywhere.
Okay, but you only saw a scar, you say,
On her cheek.
On her cheek. You never saw any scar on her nose, did you?
No, I don't know. They didn't.
Did you notice a scar on her nose, ma'am?
No.
Okay, thank you. I'm sorry, I couldn't hear you.
Oh.
And I think that's all the questions that I have for you. Thank you.
All right, you ready?
Yep. Are you aware that in the incident report that counsel asked you about, your granddaughter expressed that the defendant pointed her 3-inch acrylic fingernail into her face?
Objection. Outside the scope.
Yeah. Outside the scope.
Are you aware in the incident report, which counsel represented that your granddaughter apologized, are you aware that she apologized for being belittled?
Objection.
Outside the scope.
Objection. That is fair presence of time outside the scope.
Yep.
Are you aware that she apologized for being called?
I'm trying to establish that she knows anything about this statement.
Do you know things about the statement, like the different words that were used against your granddaughter?
Objection.
Objection.
Hearsay.
Outside the scope.
Are you aware that your granddaughter was called the N-word?
Objection.
Objection.
Can I have anything further?
I'm sorry, Your Honor?
Do you have anything further?
If your granddaughter apologized, could she have been apologizing for her part
Objection.
of the incident?
Speculation.
Isn't it true that in every incident there's two parts?
Objection.
And people are responsible for their
This is
side
the
of the
fact witness. Do you have any questions about facts?
Bro. Get it together. If you're ever beginning a question of a fact witness saying if, you're already setting yourself up to get objected to. Like, because you're already setting it up basically as a hypothetical. Like, if this happened, then if A, then B. Or then if A, then what would be B? Or if X, then what would Y be? And, bro, he's just walking right into it. I guess he loves it. Maybe this turns him on. This is a fetish of his, getting buzzsawed in half by objections.
Sorry, one moment here. That's all, Your Honor. Thank you very much.
All right, can you cross?
No, you don't.
All right, questions from the jury? You want to write that out, please?
Oh, we got a jury question. Uh-oh, let's see. And yeah, I agree, macrograms, good cross, no bullying. Because there's just no need. There's just no need to bully a witness like this. Especially if she really doesn't have much to offer regarding the testimony. But yeah, so far between day 1 and so far going into day 2, if I'm Cardi's team, I'm feeling pretty good.
Ma'am, do you have an approximate time as to when Miss Ellis called you? Do you know the approximate time?
I really couldn't tell you.
Did she tell you how long ago on that phone call? Did she tell you how long prior to the call that it happened? Or in other words, should you say this just happened or it happened earlier?
Well, she called me right after.
Right after?
And she was humiliated, you know, so she was crying.
Okay. Any follow-up questions?
No. Did she during that call tell you that she was cut on her face like Cardi B?
Objection.
Yes.
Did she tell you on the call that...
Counsel, the question was about the time. It's not. We're not going to reopen a new area of testimony.
Okay, I understand. Did she call you the same day of the incident? Objection. Last Sunday, she calls for speculation. Hearsay.
Overruled.
Your answer?
Yes.
And that was February 24th of 2018?
Yes.
Thank you. No further questions.
Ma'am, could you please give us the last 4 digits of your phone number in 2018? The number that Ms. Ellis would have called?
I had a different phone then. 818.
Do you remember the previous?
Wow.
What was the area code?
Area 818.
Any of the other numbers?
Objection. Ask the answer.
I'm sorry, I really don't remember.
I probably couldn't remember mine, but thank you very much.
It took me a long time to remember the new one.
Yeah, I know how that is. Thank you, ma'am.
All right. Can we speak, please?
Yes, Your Honor.
No, Your Honor, we may have to recall.
Okay. All right, you can step down, ma'am.
Thank you.
All right, ladies and gentlemen, that brings us to our lunch break. We're going to resume promptly at 1:30.
All right.
As always, please do not discuss the case with anyone else, including other jurors. Don't form any opinions or do any research. We'll see you at 1:30.
Having a tough day out here, buddy. A tough day. All right, lunch break. Let's fast forward. Oh, yeah. Oh, yeah. Big chunk.
Yes, Your Honor. Plaintiff will call Nicole McKinsey to the stand.
Okay, Nicole McKinsey. Who is this?
Please raise your hands. Please raise your right hand. Do you solemnly state that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. May I please have you state your first and last name and spell for the record?
Nicole McKenzie, NICHOLD, MCKENCI.
Perfect. Thank you. You may take a seat. Please watch your step.
Hey, though. Everyone doing good? Everyone hanging in there? Good. We're getting a lot of good stuff out of this.
All right, go ahead.
Thank you, Your Honor. Thank you all for coming back. Good afternoon, Dr. McKinsey. Thank you for coming here today.
Dr. McKinsey.
Are you under subpoena to be here today?
Yes.
And you were served a subpoena from both sides?
Yes.
Doctor for what?
Do you remember seeing the person on my right, Emani Ellis, in your office, medical office?
Yes.
Do you remember why she came in?
For a workers' comp injury.
And just if you just tell us a little bit about your education and background, please.
What exactly is it you would like to know?
Yes. You're a psychologist, correct?
Yes.
You deal with emotional injuries?
Oh, psychologist.
Yes.
Okay.
What else do you deal with as a psychologist?
Primarily emotional injury.
Do you ever deal with physical injuries?
No.
If a patient were to tell you about their physical injuries, is that something that you would want to know for the reason of coming up with a diagnosis, or is that just something general that you may or may not want to know?
Objection. Compound.
Free to answer?
No. So when the judge will say sustain, then we will not answer.
Okay.
So yeah, that's a good example. Objection of compound. You can only ask, when you're asking a question, it's just got to be a question. It can't be 2 questions, 3 questions, all wrapped up in one. That's a compound question. Just ask your one question, get straight to the point, let them answer, and then go on to your next question.
All right. Approximately how long after... do you remember the date of when you saw Miss Ellis?
Not the exact date. I believe it was 2018 just because of the year listed either on the subpoena, but it's been a while.
Okay, there's a notebook in front of you, the one on your right. If you could open it to Exhibit 4, I will just show you your own medical records that ask you if they are your medical records.
You said 4?
I'm sorry, number 2, I apologize.
Yes.
And if you look at the bottom right corner, in our exhibit book 2-001 through 2-023, all those pages, if you have a moment just to quickly look through and just confirm that those are in fact your medical records, correct? And you can take your time to read.
Actually, I think this is her medical records.
Yes.
He's just asking her to look at this right now.
Yes.
At the time of the incident, did Miss Ellis advise you she was making $13.50 an hour?
Yes, according to the report.
Okay, is that something relevant? I mean, why would you put that in the report? Does it have to do with the lost wages, or why would that be in the report?
Like I said, it's been a while, and so from what I can remember, that information is usually included in all reports for clients who come in for workers' comp injuries.
And at that time, in 2018, you worked for Management Inc.?
Yes.
And what is Management Inc.?
It is a psychological corporation that typically provides psychological treatment and evaluations for people who have sustained industrial injuries.
Have you always maintained a license of PsyD, or was it PhD at one point? Did it change, or it's always been the PsyD?
It has always been PsyD.
So you never went into like family, LA MFT, or you don't have any of the other licenses? You went straight for this?
Yes.
And how long does it take to get this license after undergraduate degree?
After undergraduate degree?
Yeah, I don't know why we're not leading with this. Like, why spend time talking about diving into the report already when you haven't established her credibility as an expert witness yet? Like, just lead with that. Think of it. Remember, it's like a dating profile. You want your jury to get to know your eligible bachelorette here, and in the form of what are her qualifications? Why should we listen to her at all? So yeah, the same attorney said he did not have his client's medical records when questioning Cardi B on stand about his client's size. Now he does. Yeah, and especially it's medical records from a few different doctors, because we got a psychologist here. We had the plastic surgeon testified earlier today, and yeah, so there's been a couple rounds of medical records that have been produced in relation to this case. So absolutely, that should have been public knowledge for everybody involved with the case. But yeah.
Roughly 6 years.
So in order to become a psychologist after high school, you spent approximately 10 years, is that fair?
Yes.
And what is the distinction between a PsyD and a PhD? Is there a difference?
The main difference that I can report is PsyDs are more clinically focused on psychological treatment, versus PhDs can also provide clinical treatment, but they can also focus more on research.
Okay. And before today, it's probably been several years before you looked at your medical file, correct?
Yes.
And that's because you no longer work at Management Inc. You opened your own practice or work for a different practice, correct?
I work for a different employer.
And when you worked for Management, you were an employee for them?
Yes.
Now, if you look at the first page of your report, date of injury, it says 2/24/18. Do you know if that's accurate?
Objection, explanation, sustained. It's also vague.
I'll represent to you that the date of incident is February 24, 2018. That's the date of the injury. And that's the date it says in your report, correct?
Yes.
Okay, and then it says the date of your examination, April 26, 2018. Do you know if that date is accurate?
I believe so.
So, honestly, what it sounds like here, because she evaluated her in relation to a workers' comp claim, right? So, incident happens February 2018. She feels distressed, traumatized by it, and she wants to initially go recover through a workers' comp claim. My guess is the workers' comp route did not pan out in the way she was hoping, and the plaintiff decided that, well, I still want my money, I still want to get paid, so that's what then led to this lawsuit suing Cardi B directly. But the fact that the workers' comp claim was either denied or it wasn't getting her to the results that she was wanting, I think that says a lot too about what we're dealing with here and about the credibility of the incident. Especially too, at this time back in 2018, all the information that was out there was the incident itself, and then the plaintiff's report, the incident report that she wrote herself about what happened, where she admits to being an active participant in the situation. And so, talking about getting a workers' comp claim based on a situation that you helped create, no, that's not how that works. Workers' comp claims are for when you're injured on the job for stuff that's not your fault. So, yeah, I think it says a lot. The fact that we're not proceeding on this case through workers' comp says a lot about kind of the strength of the facts here.
If you go to Exhibit 2-5, the 5th page, there's another report which has a different exam date. Do you see that?
Yes.
And that was August 10th of 2018, correct?
Yes.
Okay. Without going into the expert reasons or the psychological reasons or anything like that, I just want to understand. You asked the patient to come back a second time, correct?
They were asked to come back several times after the first visit.
Okay. And if there was nothing wrong with them, would they come back for a second visit? If you know, do you know?
Objection. Yeah, objection to that.
When you see a patient, not this patient, one time for the first time, and there's nothing wrong with them, would you see them a second time, or you usually say, I'm sorry, there's nothing wrong with you, goodbye?
Objection. Compound, accidentation, false situation.
You can answer.
I would see them a second time.
And if you go back to the page 1, which is 2-001, in the first paragraph, you go through a job description of what the patient came to see you for. You basically have a job description of what your patient was doing at the time of the incident, correct?
Objection made.
Yes.
Okay. And what was her job title from what you see? What would it be?
Security guard.
And you did a comprehensive psychological evaluation of Emani Ellis, correct?
Objection. Outside the scope of her designated. Wasn't designated.
Yes.
How long did you spend with her on that day, if you know?
For the preliminary evaluation or the psychological evaluation?
The whole thing combined on February 26th of 2018. You may not have an exact time frame, but I want to know that based on your experience for this type of care, how many minutes did you spend with Emani Ellis on that day?
I cannot recall.
Was it more than an hour?
It may have been.
In general, when you see the patients to go over their emotional injuries, how long do you usually spend with them? Is it usually an hour, 30 minutes? I mean, there is a minimum, right?
Right. On the initial visit, typically an hour to an hour and a half.
So far, nothing too crazy from this testimony.
And then on page 2-002 on that exhibit, towards the bottom, you, in quotes, have some profanities that are in your report. Is there a reason why you would write profanities in your report?
Just to capture the current support in their own words.
Yeah.
And the patient told you that the celebrity made the profanities?
According to the report, yes.
And the profanities were, F you fat ass, sorry to say it, bitch. That's why you do security. That's why I'm going to get you fired. That's why I'm rich and you're poor. That's what you wrote there, correct? In quotes.
Yes.
Do you have a dictation machine where you record them saying these words?
I write it down, and there are times when I did use a dictation machine.
So this is helpful. This is actually quite helpful evidence for the plaintiff here, because once again we're rewinding the clock. We're going back to 2018. This is April 2018 that this report was made. So 2 months after the incident, and you've got some of the same quotes of what she's testifying now to in court. You're showing the consistency of the story, which if you all remember from the day one of testimony, there's a lot of inconsistencies in the story, and there still are plenty of inconsistencies, but as a plaintiff, you're trying to establish that, no, actually, there may be some inconsistencies, but there's also some really strong consistencies. In particular, what I remember hearing, what I was told being verbally berated with some of the specific quotes that were being said. So this is helpful for the plaintiff.
When the patient was telling you this information, did you use that information in your diagnosis and treatment of the patient?
This statement?
Yes.
I can't say that I did.
Why is it important to write down these profanities in your report for a psychologist? Why did you feel it was important to put that in your report? Why?
With regards to workers' comp injuries, we try to document clients' statements using their own words.
Right. Are you aware that in workers' compensation, the applicant is held to...
I feel an objection coming. He started the question off with, are you aware? Yeah, the buzzsaw, I hear it revving up.
Laws of perjury and must be honest and truthful in their reports of injuries. Is that your understanding as a doctor?
Yes.
And at the end of a lot of these reports, you yourself will declare under penalty of perjury that everything is accurate. Isn't that true?
Yes.
Okay, and in fact, if we go to 2-004, at the end of your report, you do in fact write that, and you sign that. Is that your signature there?
Yes.
Okay. And it says, I further declare under penalty of perjury that I have not violated the provisions of California Labor Code Section 139.3, 139.31, operative January 1st of 94, with regard to this evaluation of this patient and the preparation of this report. Why is this paragraph always written in these reports? Do you know?
Just to make a statement that the information we gather is true to our knowledge.
Do you ever, or have you ever treated a patient on a lien basis?
I want to say yes. The majority of clients that come in, workers' comp injuries, I believe they're treated on a lien basis.
Okay. So what that means is you see the patients, you submit a bill, and then you wait to get paid at a later time. Correct?
The corporation would submit a bill and wait to get paid at a later time.
And sometimes they're denied. Correct?
Correct.
Do you know if yours was granted or denied?
I cannot recall.
Now, I really want to understand one thing. As a psychologist, if I came to you and I said, I broke my middle finger I injured my left shoulder. I broke my knee. I broke my back.
Objection
I fell on
coming.
the ground and I hit my head and I've got a big bruise on my head and I have psychological issues. Would you really be focusing on the physical or would you be more focused on the psychological?
I would focus
He wrapped
on
it up okay.
the psychological injuries that were a result of the physical injuries.
Okay. So it would be nice to know those details, but you probably wouldn't write verbatim, word for word, the physical injuries, correct?
My focus would be the psychological injuries.
So if there were physical injuries here, for example, if there was a scar or a scratch or something physical and it's not perfectly mentioned here.
These questions, they're not bad, but to me they're more appropriate on a redirect where this has been called into question because I'm sure the cross-exam is going to point out like, hey, you wrote a report, you sat down with her, you had a lot of time with her face-to-face. Did you observe a scar on her face? Did you make a note of that in your report? And the answer is no, because it's not going to be in there. And then on redirect, now you rehabilitate that. You bolster the testimony again. Say, well, why didn't you notice it? Or is that something you would normally notice or put into your report? It's like, and her answer would be no. I focus on psychological. So there's nothing inherently wrong with these questions other than they're a bit leading and improperly characterized with the personalization by the lawyer of like, if I were to come in with a broken back, blah blah blah. Yeah. So it just seems it's not in the proper place, but yeah.
Does that mean it didn't occur?
I don't know how to answer that question. Usually, from what I can recall, if it's documented in one of the intake forms, I will address it or mention it, but I can't recall whether it was or was not.
Right. Are you aware that in this case, the defense has designated a Dr. James Rosenberg as a psychiatrist in this case? Are you aware of that?
No.
Okay. Are you aware that Dr. Rosenberg will not be testifying about any physical injury?
Objection, Your Honor.
If the patient that you see does tell you about their physical injuries, and you do want to know about it and put it in your report, would you then come up with a diagnosis as to the physical injury or not?
No.
You don't treat any physical injuries, correct?
No.
If Emani Ellis came to you that day on February 24th, 2018 with a cut in her face, would you do anything to treat the cut?
No.
What would you tell her? You tell her to leave and go to the hospital or go to a medical doctor, correct?
If a patient comes and they have a physical injury, typically they are referred to a physical doctor to address those injuries.
Aside from the cut to Miss Emani Ellis' face, did Miss Emani Ellis complain about any other physical injury to you?
Objection. Argumentative. Contrary to the evidence.
I can only report on the physical symptoms that were included in the report, and that states headaches and trouble sleeping.
But how about physical injury to the body, like her face, her neck, her back? Was there anything physical that was really documented by you as a psychologist?
I would have to read through the report, but I cannot recall.
And what is MMPI? What does that mean?
That's a psychological test.
And you did that test for this patient?
She completed the test, and it was interpreted.
And what does it entail to do the MMPI test? What does the patient have to do?
It is a questionnaire. I cannot recall if it's 500 and something odd questions, true and false, that ask about various symptoms.
Jeez, 500
and
questions?
You did the test. You had her do the test in your office?
I believe she completed the test, and it was stored by my office and interpreted.
Okay. And you were paid for that test? You billed for that test, correct?
I believe so.
And after that test, on Exhibit 2-017, if you can look at that page, date of exam, November 26, 2018. Do you see that?
Yes.
So after you did the test, you then decided to do a psychological reevaluation, correct?
Yes.
And on page 2 of that report, which is Exhibit 2-018, you have some diagnoses that you've written in your report.
Yes.
And you again declare under penalty of perjury that all of this is accurate, and that's your signature on Exhibit 2-19?
Yes.
And if you look at Exhibit 2-20, your office billed $600 for treatment on that date, April 26, 2018, correct?
Yes.
Okay. Do you know if you were paid for that or not?
I do not.
And then if you look at the following page, Exhibit 2-21, there's some additional dates, which I want to go over with you.
Yeah, you could tell she doesn't want to be here. She's just giving these short answers.
$300 for treatment, is that correct?
You said August 10th?
August 10th of 2018.
2018. There's several.
Yeah, the first two. 150 and 150, correct?
Yes.
So that's the second time she came to you, correct?
I believe so.
As far as the records say.
Yes.
And then on May 18th of 2018, again, $150 for individual psychotherapy, correct?
Yes.
In looking at your bill, which would be Exhibit 2-20, 2-21, and 2-22, I count approximately 7 different dates of service that you treated this patient. Is that accurate? Did you see her 7 times?
Yes.
Yeah, I think this comes in.
Is that true?
I can't say whether I saw her 7 different times.
Okay.
Typically, when clients would see me at the corporation, I would see them initially. They would then be referred to a psychological assistant for treatment. And then I would see them several times after just to sort of checking into the evaluations and the progress.
Okay, I understand. How about this then? Ms. Emani Ellis, according to this bill, came to Managed Med Inc. on 7 different occasions, 7 different dates between April 26, 2018 and January 15th of 2019. Just the number of visits. You agree with that, Doctor?
According to the bill, yes.
And if my math serves me correct, the combined billing that your office billed Ms. Ellis, or Ms. Ellis's work comp, was $5,087. Is that correct? If you were to add $600, $3,787. Actually, it's there for you on the last page. 2-23, total lien. You see the total lien?
Yes, $5,087.
Right. And so then, in fact, you did treat her on a lien basis, correct?
Correct.
And then you do that all the time then, when you work for Managed Med?
Yes.
It's a routine procedure?
Yes.
Nothing improper to do that, right?
No.
Okay. Are you familiar with CPT codes?
Billing codes?
Yes.
Not that familiar.
But you have to know them for your practice?
I don't, because I don't bill.
Is it reasonable for a psychologist to charge $600 for 2 hours of psychological treatment?
Objections. Foundation.
It depends.
Yeah, she's literally saying, I don't know what you're talking about because I don't have knowledge on it. And you're going to ask her a further question about the thing she just said she doesn't have knowledge about. Yeah, that's objection all day for lack of foundation. She literally said, I don't know.
And the MMPI exam that Ms. Ellis did, do you know approximately how many hours it took her to complete the 500 questions?
That's fine.
I don't know how long it took her. Typically, it will take the clients several hours to complete them, depending on the reading level.
You think it would be less than or more than 4 hours?
It might be less than 4 hours.
Okay, and then if I can go to Exhibit 2-13. In the discussion, it says that she was referred for psychological evaluation. Who referred her to you, you know? Sorry, 2-013 in the right-hand corner. And it's right under discussion in the second paragraph. Oh, sorry, first paragraph, in the middle of the page. Do you see that there?
213, the middle of the page?
Yeah, Miss Emani Ellis was referred for psychological evaluation. Does that mean she's referred to you or you're referring her to somebody else?
She was referred to the clinic.
Do you know how she was referred to the clinic?
Most clients are referred through their attorney.
Okay, and that's the workers' compensation attorney?
Yes.
Do you know who that attorney would be? It's not me.
According to the report, it's the employee legal advocates.
And then in the next paragraph, it talks about the fact that she was conducting regular patrols at the building, correct?
Correct.
Okay. And that she came into contact with a female music celebrity. Are you familiar? I wasn't asking a question. The question is this: are you familiar with the actress or celebrity, musician, rapper, Cardi B?
Yes.
You know her?
Yes.
How do you know her?
Through television.
Do you respect her work?
Objection. Relevant.
Are you a fan of Cardi B?
Objection.
Do you have any bias to testify in favor of the plaintiff or the defendant in this case?
No.
No? Either way, you're just here to tell the truth, correct?
Correct.
And further on, it talks about Well, let me ask you this. Why was it so important to document all of these details? Why are you documenting all of these details about the telephone and her listening to her voicemails? Is there a reason why it was there?
There's no particular reason. Usually it's just to capture the incident in the client's own words. And so we try to obtain as much detail as we can for the attorneys and those involved in the case.
Okay, and isn't it true that in your report you document that Emani Ellis was holding her cell phone, reportedly listening to her voicemails?
Objection. Mr. Document.
There's hearsay statements that are offered for treatment. That's one thing. This doesn't relate to treatment. So your questions are I'm going to start sustaining the court's own hearsay objections regarding anything that doesn't have to do with medical treatment.
Thank you.
Once again,
the next sentence.
judge bringing down the hammer on the plaintiff's lawyer.
Ms. Ellis reports that the person responded by saying, in quotes, "Don't be telling people you effing see me." Is that something that you use for medical treatment and diagnosis of your patients?
Overall.
What page is that?
That's on the same page. It's just the next sentence. Sentence number 4 and 5 on the second paragraph under discussion. You see where it says Ms. Ellison reports? Ms. Ellis reports.
And what was your question again?
So I want to see Cardi B back on the stand again so bad she's hilarious. Hey, that's coming up. It's, I believe we got this doctor and then Cardi's later. Yeah. Oh yeah, we're gonna get to it.
Just capturing the client's incident according to her report.
Okay, and
gosh, man, I don't know what more we're getting out of this.
did you put these statements, the other quote and this quote, in your report to measure the extent of the psychological damage?
No.
And then you say after that the individual then proceeded to put her finger in the applicant's face, almost touching her nose. Did you use that sentence for treatment of this patient?
No.
But why are all of these statements in your report?
Again, just capturing the client's report.
And when you say capturing, did you record it, or is it something that you heard and then later on went and made your report?
Are you asking if I wrote them in my own words or if the information was captured from me?
I guess time passes. So, for example, if your patient comes in and gives you the history of what happened to them, and you're not recording them, and you're not typing it out right there and then, things could be lost in time. Details. Some of them are, some of them are not. So the question is, are you taking down the history in real live time, like that camera with a 30-minute delay, or is it something where you hear the history, maybe take down some notes, and you come back a month later and write your report?
In real life time, the camera with a 30-minute delay.
What's that?
In real life time, like the camera.
You do it that way?
Yes.
You had her on video?
Not on video, but either it was used, I used a dictation machine, or I wrote it down myself.
Okay, so if you write it down yourself, do you write down every single word in this report?
Yes, I'm capturing quotes.
How about when you're not capturing quotes? Meaning some of the sentences.
Yeah, almost touching your nose. Yep.
Ones in quotes are verbatim what she said. That's fair?
Yes.
And the ones that are not in quotes are not verbatim, correct?
Correct.
And how long after you see the patient you make the report? How long does it take to generate this report?
Right after they leave the office, or leave my office.
Okay, but isn't it true that sometimes you'll see a patient and maybe a week, a few weeks, a month will go by before you prepare these long 4-page and 10-page reports? Isn't that true? Because they do take a lot of time to prepare, don't they? Your second report on August 10, 2018, it's 12 pages long. Who prepared this report? You'll have somebody outside, like a transcriber do it?
Yeah.
And between you and the dictation and the transcriber, isn't it true that sometimes the details could be lost, meaning there could be errors in the report? That's a possibility, correct?
It could be a possibility.
And you've had that in your practice. Isn't it true in your practice you've had that where there were mistakes and you have to correct them? For example, you make an amended report. Isn't that true? Sometimes you have to do that?
After the report is transcribed?
Yes.
It is reviewed for corrections.
And have you ever done an amended report?
Yes.
If the details of the injury, for example, as I explained you the story about me breaking my finger in my left shoulder and my left knee and my back, if that is not perfect, would you catch that to correct the report? Or is that something that's really physical that even if there's a mistake with that piece, you're not going to go back and correct it because your sole goal is to treat her for psychological treatment, correct?
Objection, argument, lack of foundation.
Oh, I feel like we're just circling the drain. I don't know. I feel like we've really got out the bulk of what this witness is going to testify to, but we just keep asking the same question in different ways.
I've done it for all that's included in the report, whether that's emotional symptoms, physical symptoms, or the dental testing results. Or the testing results. Sure.
And just so we're clear, Ms. Emani Ellis came to you for psychological injuries?
Yes.
Only?
Objection is characterized as the evidence and also lacks foundation.
Yes.
And that does not include physical injury, correct?
She was seen for psychological injury.
So if she
Like
also
we've already established.
broke her teeth, would that be important for your psychological treatment of the patient?
Not for the treatment.
We've already been over this.
So when someone has a physical injury, do you refer them out to a medical doctor if they don't have one?
If they don't have one, we refer them back to their attorney.
So the attorney is the one that refers them out?
Correct.
Are you aware that Ms. Ellis saw a plastic surgeon, Dr. Scher, in 2018, somewhere around the time when she saw you? Did you review any medical records from a Dr. John Scher in this case?
I cannot recall.
Did you review any medical records from Dr. Avila for any psychological treatment in this case?
Why don't you just ask her what records she did review?
What records did you review? Do you remember?
I do not.
And you don't have...
Again, the judge has to tell the plaintiff's attorney, tell him what question he needs to ask. It's just so bad.
Your medical file with you because you no longer work for that company, correct?
Correct.
And you have no way to get those medical records, correct?
Correct.
Why didn't you reach out to Manage Med Inc. to get your medical records for this patient when you knew you had to testify here? Is there a reason why you never got the medical records from Manage Med Inc.?
I don't have an issue with trial counsel.
All right, I just want to ask you what you did review, because I have the records. If you can look in your exhibit book, 1-004. You have that?
I do.
Have you ever seen that document before?
No.
Your Honor, objection. You're going to go through all the medical records?
There's only three, Your Honor. Just three.
Ma'am, do you remember reviewing any medical records?
I do not.
I want to remember reviewing any medical records.
Your Honor, I was going to see if I could refresh your recollection with you. One more. Just one more. I mean,
Your Honor, this is a table that counsel prepared. It's not an exhibit.
I'll withdraw this question. I'll go to the next one, Your Honor. Thank you. If you could go to Exhibit 3. Did you review any medical... Sorry, withdraw that. Did you review any psychological records from Premier Forensic Psychology from Dr. Alex Avila?
Objection, Your Honor. Motion eliminated. And the ruling on motion eliminated. Relevant by the foundations.
Did you review any records from... Well, sorry. Let's have you go to Exhibit 4. Do you see that?
Yes.
Did you review any of these records from plastic surgeon Brett Mulliken?
Objection, Your Honor. Black foundation.
Over.
I do not recall.
Okay.
Like, this is your witness. You called this witness to testify for you, and you're ping-ponging all over the place again.
Paragraph. If you read those 4 lines, does that help you refresh your recollection about anything Emani Ellis told you when she saw you in 2018 and 2019?
Hey, Jamie Zach. What's good, gang?
For the history of incident.
Yeah, don't read.
Hey, perfect timing, my dude, because after this witness, it's Cardi B on the stand, and it's gonna be fireworks. We've seen the clips, and we're ready to get to it. Who was that lady? That's the psychologist that evaluated the plaintiff 2 months after the incident. Evaluated her for emotional distress and related things, and for some reason, the lawyer keeps asking her questions about physical injuries, which keeps getting objected to, and it's just none of it's coming in. But he keeps circling the drain. Yeah, it's getting quite redundant. So
finally, I just ask you this question. I just want to know about the billing. Do you have any way to know if the bill of $5,087?
Yeah, and ask her questions about billing. It's like, can we actually get on your birthday? Hey, wait, like today's your birthday, or this happened on your birthday? Yeah, let us know. Let us know. But
Good afternoon, Doctor. Okay, so I'm going to try to not overlap with counsel's questions, but I do have questions about some of the exhibits that he showed you. And first of all,
I think we're in cross.
just to be clear, you saw try to.
Yep, cross-exam now, which is like, we didn't even really get into any of the details on the emotional distress or any of the emotional, like, yeah, the PTSD, the insomnia that she's alleging. Like, this would be your witness to get all that in of like, yes, I evaluated her on this date for these issues. It's my diagnosis that she suffers from these issues, and go into like, what's the basis for that? How do you justify that? What are the treatments for that? What are the types of damages that result from it? How does it affect your life? Those are all questions that you'd be asking to establish the scope of damages that you're not going to be looking to recover. But like, I feel like the entire direct exam there was about billing procedures and whether or not she reported any physical injuries. When she repeatedly said over and over again, I just treated her for psychological injuries. Yeah. Today on the 31st, I was even born on the last day. Was destined to be late. Oh, better late than never. You made it. You're here. And yeah, just in time for the epic finale of day 2.
Good afternoon, Doctor. Okay, so I'm going to try to not overlap with counsel's questions, but I do have questions about some of the exhibits that he showed you. And first of all, just to be clear, you saw the plaintiff in April of 2018 because she had made a workers' compensation claim, correct?
Objection. You state the testimony of the witness.
Correct.
Yeah, that's...
So I'm going to ask, I'm going to make it easier, I'm going to use our exhibits. And I should also say, counsel was right, we subpoenaed you too. We appreciate you showing up. The court has authorized us to ask our questions of you so you don't have to come back a second day. Thank you, court. I agree, though, but thank you, court. So I'll take it too. So I have some of the same documents, but with different exhibit numbers, and we can display them. And the first one is, I would ask counsel, we're going to use exhibit 206, which is...
I'm going to leave it playing for a second. I'm just going to run and go pee super fast, but if anything crazy happens, let me know when I get back.
The document because she doesn't have her medical file, and it's a hearsay document that was prepared by management, Inc., and I was not provided the opportunity to show it to her.
I don't remember you asking, but do you object to being published?
Yes.
Based on hearsay ground?
Yes, sir.
It's the same.
I'm sorry, based on...
Hearsay ground?
It's the... What I'm...
Can you take it off the almost service?
What I'm going to focus on...
Why don't you take the document down for now?
He's doing that now. What I'm going to focus on are her recording plaintiff's own statements, which are, of course, plaintiff party admissions.
Your Honor, I wasn't...
He's already touched on the same document.
We're not going to argue it back and forth. You can ask her questions if you want to put the document in front of her and ask her questions about it. That's fine, but we're not going to publish it at this point in time.
Okay. If you could look in the blue book for exhibit 206, it should be tabbed probably towards the end. You found it?
Yes.
Okay, thank you. Do you recognize this as the same document counsel was showing you?
Yes.
And it is also the preliminary psychological evaluation done on April 26, 2018?
Yes.
And let's look a little bit closer at the second page that he asked you questions about. Could you read out loud the bold caption on that page?
Okay, what I meant.
History of the incident as reported by the patient.
And so everything that is recorded there is what the plaintiff told you in April 2018, correct?
Correct.
And let's look a little bit closer at the verification at the end. So if we go to page, the fourth page, and there's a caption disclosure statement, correct?
Yes.
And can you read out loud the last sentence of the first paragraph?
As to that information, that sentence?
Yes, thank you.
As to that information, I declare under penalty or perjury that the information accurately describes the information provided to me, and accept as noted herein that I believe it to be true.
And is it correct that what you verified under perjury was that you had correctly recorded what plaintiff told you?
Correct.
Okay. Did you at any point, anywhere in this document, in this verification page or otherwise, verify that what she was telling you was true?
No.
Okay. Now if we go back to the second page, the first paragraph, after history of the incident as reported by the patient, could you read the first three words?
Your Honor, I would object because she's not an expert. And also hearsay.
I'm not sure. It's first three words of what?
Of exhibit 206, where she confirms that she is, the statements that counsel read are the statements of Thank you.
The applicant reports.
Right. And third paragraph, the first three words.
Ms. Ellis reports.
And could you
So
read...
yeah, just going through and basically saying, yes, the psychologist report contains all these statements about emotional distress and inability to sleep and post-traumatic stress and whatnot, and depression and trauma, et cetera, but she's saying what he's getting her to acknowledge here is that all of this is based on her own self-report, on the plaintiff's self-report of here's what I feel like I've been experiencing. I feel depressed. I feel like I'm not able to sleep. So it's purely based on basically what the plaintiff believes, which we've already heard through the plaintiff's testimony. So it's showing that we still haven't really established an objective scientific basis for some of these emotional distresses that this witness would be qualified to talk about, but it's just not, like the plaintiff didn't want her to go there for some reason.
The last sentence of that, after Ms. Ellis reports?
Yeah, objection. He's only picking and choosing words that he likes. You should read the whole thing as a whole.
Please open the speaking objections.
I apologize. Objection for completeness.
It's overruled then?
What paragraph again?
Yeah, the paragraph that begins Ms. Ellis reports. I'm only asking you to read the last sentence, full sentence, complete. Don't leave anything out.
Her nails were really long, almost touching the applicant's nose.
Right. Is there... let's go to the second...
Your Honor, for purposes of completeness, I would ask...
You can address it on redirect.
Let's go to the third page. Can you read the first full heading in bold on the third page?
Associated physical symptoms.
Right. Is there any mention... Well, first of all, is this a portion of the report where you record any physical symptoms that plaintiff reported?
Yes.
And even though this is a psychological report, you, in fact, as a matter of practice and in this document, documented would have mentioned any physical symptoms that she had, correct?
Objection calls for expert opinion.
Over.
Correct.
First off, she is an expert. Second off, so there is a part of the report that has to do with physical symptoms, and yeah, just completely left out. The plaintiff making it sound like, no, there's nothing to do. Like, he spent the entire, like, half of the direct, more than half of the direct, talking about the fact that this witness would not address physical symptoms at all. But now, actually, no, it turns out all you have to do is look through the report, and you can see there is a physical symptoms part. And this is just, I was ambivalent about this case. I had a feeling like, I would not be surprised if Cardi did what she is alleged to have done. But after watching, good chunk of this case, probably like over half of this case now, but gosh, it's just, no, the plaintiff's case is so shoddy. No, I don't think she deserves anything. She doesn't deserve to recover anything based on this.
Anywhere in that, well, actually, could you read for the jury, please, the complete associated physical symptoms that plaintiff reported to you 2 months after the alleged incident?
Objection. I would ask that counsel can read and not the witness.
Okay.
Ms. Ellis reports that she experiences headaches at least 4 to 5 times a week that last several hours. She is also sleeping more than she used to.
That's it. No mention of a scar?
Not in this statement.
No mention of any physical injury?
Not in this report.
And you took down this information that's in this report as plaintiff provided it to you, as you put it, at the time that she said it, correct?
Correct.
And you verified at the end, under penalty of perjury, that you had correctly recorded what she said, correct?
Correct.
If you look at the page 2 of this exhibit, 206, and let's go to the fourth paragraph. Do you see the language, it turned into a screaming match?
Same objection, Your Honor. He's over.
Correct.
And that's in quotes, isn't it?
Yes.
And that is what the plaintiff told you, right? She didn't mention any physical symptoms. She just said it turned into a screaming match. Is that correct?
According to the report.
Do you have any reason to doubt that the report is correct or inaccurate?
No.
And in fact, you verified at the time, under penalty of perjury, that it was correct.
According to what the applicant reported.
Right. And I apologize. That's an important distinction. That it correctly recorded what plaintiff said, right?
Correct.
You were not verifying that she was telling the truth, were you?
And this is the time, like, the plaintiff, she's got a lot of good reason back then when she was giving this report to report what are the extent of the damages. Because remember, she's filing for a workers' compensation claim. So she's got full incentive to list all the damages that she's suffering as a result of this. So to not mention any sort of physical injury, and to say affirmatively that it turned into a screaming match, and now she's distressed about it, and now she deserves to recover based on that. It's like, it's just so... It's aggravating because it's like, it's just so much incomplete, so much missing that you'd want to see out of a legit plaintiff's claim in a situation like this. But so yeah, if there's no proof though, if we're really not doing a good job establishing any sort of physical injury that is just purely emotional, psychological, well, I'm sorry, you don't get to go around shaking down celebrities for $24 million based on your feelings were hurt because you got in a yelling match that you actively participated in and you helped to instigate. Like, no, you don't get anything. You as Willy Wonka said in the old Willy Wonka movie, you get nothing. You lose.
No, we typically do not verify unless provided with other reports.
Okay, if I could ask you to go to Exhibit 207, which is the other document that counsel showed you. Do you see it?
Yes.
And do you recognize it? And feel free to thumb through it if you like, as the other portion of his exhibit that he showed you.
Correct.
And that is a initial comprehensive psychological evaluation with associated psychodiagnostic testing. Is that what the label is?
Yes.
And that examination was done on August 10th of 2018?
Yes.
So what, 4 or 5 months later?
Correct.
And if you look at the second page, it's got another history of the incident as reported in preliminary evaluations. You see that?
Correct.
That's the heading?
Yes.
And that's as reported by plaintiff in August of 2018?
Not on August of 2018. It's usually the information that was captured in the preliminary.
Okay, got it. And that also, in the third paragraph, states that Ms. Ellis reports that the celebrity's nails were really long, almost touching the applicant's nose. You see that?
Yes.
And then on the next page, associated physical symptoms, it still doesn't mention a scar or any physical symptoms, correct?
Correct. It's the same information from the previous report.
And you also, at page 12, verified under penalty of perjury that you had accurately set out what plaintiff told you, right?
Correct.
Okay, let's go with me for just a second. You actually met with the plaintiff in 2018, correct?
Correct.
And you remember your deposition was taken in this action? You were deposed, you asked questions. I can give you the date if you like.
I was deposed. I just cannot recall the date.
Yeah, I don't either. It's here somewhere. But you did have your deposition taken, correct?
Yes.
And you testified at your deposition that if you had seen any scars or bruising on the plaintiff's face when you met her, you would have noted it, correct?
If that's what I stated.
You said, would you like to see your testimony?
Yes.
You would like to see it?
Yes.
Could we?
I would object to it because it's not here to.
What's your legal objection?
The purpose of using it is not to impeach the witness. It's simply to reinforce what she's already said. She's already agreed to it.
I'm sorry? May I say one quick thing? This is our case in chief.
Why don't you just ask her the same question now?
Okay, fine. Doctor, if Miss Ellis had shown up for her examination and had a scar or scars or bruising on her face, would you have noted it in your report?
Objection calls for speculation.
Overruled.
If it was indicated on one of the intake forms.
I'm sorry?
If it was indicated on one of the intake forms.
If you saw her with bruises and a scar on her face, would you note it in the report?
Objection calls for speculation.
You brought it up on your direct, Mr. Plaintiff Lawyer. You brought up the prospect of her noticing and recording a physical injury. So yes, of course, on cross-exam, we get to ask about it now on the defense.
I believe I would on the mental status.
Okay, thank you. Okay, with you for a second. If we can turn please to Exhibit 222. What is Exhibit 222?
This is a back depression inventory.
I'm sorry?
A back depression inventory. It's a psychological test for emotional symptoms.
Right. And is this a form that is provided to the workers' compensation applicant for the applicant to circle the symptoms they claim?
Yes.
And is this the form that plaintiff filled out on April 26, 2018?
It looks so, yes.
Okay. And you identified it at your deposition as the form that she filled out, right?
Correct. I think.
And could you read?
I'm still waiting on the diagnosis. Like, once again, every form that we're getting is all plaintiff's self-reported symptoms. Like, I'm still waiting on the official professional diagnosis that, yes, she is being diagnosed with depressive disorder or PTSD or insomnia or whatever it is that she's claiming here as damages for this case. Like, we have yet to see any of it. All we're seeing is her self-reported, self-diagnosed issues.
At the end of the first column, 5, question 3. What did she circle there?
5, the guilty feelings?
3, line 3, the very last line. On the first page. So if you look under guilty feelings.
Correct.
And what did she circle?
I feel guilty all the time.
And if you can turn to Exhibit 225. Is this the same type of form?
Correct.
And is this the form that she filled out on January 15, 2019?
Correct.
And what did she circle about guilty feelings at that point?
I feel guilty over many things I have done or should have done.
Sorry, where was that?
I'm sorry, where are you reading? I couldn't find it. Under guilty feelings. If I may be wrong.
What? I don't know what exhibit you're on.
225. Okay. Stay with you just a second. I want to make sure. Okay, thank you very much. I think that's all the questions I have for you.
All right, right?
Yes, sir. Thank you very much.
All right. Oh, boy.
Isn't it true that Emani Ellis came to see you for psychological injuries only?
Correct.
Black Foundation, Foster.
Overruled.
Yeah, overruled.
Correct.
Did Miss Emani Ellis come to you for physical injuries?
No.
She did not.
Did Miss Emani Ellis come to you for plastic surgery?
No.
She did not.
Are you a plastic surgeon?
I am not.
Any reason for you to note that there was a scar there or was not there when you saw her in April of 2018?
I'm not sure how to answer that. Any reason for me to note it?
Yeah.
No particular reason.
And the question that counsel asked you about guilty is Exhibit 222, guilty feelings. I feel guilty all the time. Does that mean that she's guilty of something?
Objection. Black Foundation.
Okay.
And then in 225, I feel guilty over many things I have done or should have done. What does that mean?
Objection.
Yeah, she doesn't know that.
Sustained.
Yeah, objection
What is the
speculation.
purpose of guilty feelings? What is this all about? Why do you have this in here?
The overall measurement is to capture symptoms related to depression. And so it asks about different symptoms that would meet the criteria for depression, like sadness, loss of pleasure, guilty feelings.
Can someone have psychological problems and have guilty feelings at the same time?
Objection. Expert testimony.
Sustained.
Isn't it true that no matter which one of the four were circled, it wouldn't have mattered for the diagnosis of this patient, correct?
Sustained. We're going to stay with some expert testimony.
When you have number 5 here, guilty feelings, does that mean they're guilty of a crime or something? What does guilty feelings mean?
Objection.
Sustained.
Yeah, we've already been objected to.
Can you explain us what guilty is?
How do you need to move on?
One question about this guilty issue. When you have this here that says guilty feelings, does it mean that Emani Ellis is guilty of the incident, or is it guilty feelings about psychological issues?
Objection.
Sustained.
Yep.
Isn't it true that if a patient is coming to you for psychological injuries, they're not going to tell you about all of their physical injuries? For example, if she has a dental complaint, she's not going to tell you about her dental complaint, even if it's related to the incident.
Objection.
That's possible, correct?
Calls for speculation, lack of foundation, outside.
Overruled.
You can answer.
When the patients were referred for psychological treatment, they filled out a claim form. If the attorney on that claim form only put that we were to focus on the site, then that's what we focused on.
So it was the attorney, it was her attorney who decided what was going to be on the claim form. Is that your testimony?
I believe so.
And if the attorney put in physical complaints, do you think that an attorney would send that to you, or would an attorney send it to a medical doctor? If you know.
Calls for speculation, lack of foundation.
Sustained.
The buzzsaw. The
And then I
objection
want to go
buzzsaw.
back to what counsel was talking about in the report where you read from. Exhibit 206, do you remember that one? Exhibit 206, page 2 of 4. Do you see that, Doctor?
Yes.
So counsel asked you about paragraph 3, and he read you the last sentence, or you read it. Her nails were really long, almost touching the applicant's nose. Do you remember when he asked you about that sentence?
Yes.
Okay. The sentence before it, I want to focus on that for completeness. It states, individual then proceeded to put her finger in applicant's face. You see that?
Yes.
Does that mean there was contact, or you're not sure?
Objection.
Do you know, I'll withdraw the question, do you know if that sentence, the one I just read you, has any connection with physical contact?
Objection.
Objection.
Overruled.
Do I know if the sentence you asked me to read has any indication of physical contact?
Yes.
Not that sentence.
Is there other sentences that do? That you can remember? Right now?
No.
From all these 23 pages?
No.
And you didn't read all the 23 pages, did you?
I did not.
And you, as you sat there for the last hour, hour and a half, it would be impossible to do that. You'd want to spend at least an hour to review all pages, correct?
Your Honor, objection.
Sustained.
Oh boy.
Is spitting on someone considered an assault and battery for your treatment of the
Sustained.
patient?
Move on, counsel.
Oh my gosh. The judge sustained an objection before the objection was even made. Listen.
Assault and battery.
Like we don't even hear the defense object. The judge just immediately just says sustain, move on.
For your treatment of the
Sustained.
patient.
Move on, counsel.
Boom. Oh my gosh. And you've got the court. The judge is now objecting to your questions. And this is painful. This is painful.
And in the next sentence, it says, Miss Ellis states that she tried to explain that she was not speaking to anyone regarding seeing the celebrity, yet the individual then spat on her. Is there a reason why you wrote this in your report?
Objection, Your Honor.
Overruled.
Just capturing the incident as reported.
And when the patient told you that she was spit on, did you believe her?
Objection.
Objection.
Sustained.
Relevant.
Would you agree that spitting on a person is considered physical contact?
Objection.
Sustained.
And then if we can go to the 7th paragraph. Once in the lobby area, the celebrity's security guard approached. The applicant explained the situation, and the security guard reportedly apologized. Do you know why the security guard of the defendant apologized to Miss Emani Ellis?
Objection, argumentative.
Sustained. Counsel, let's focus on what she knows.
Did Emani Ellis tell you, after me reading that sentence to you and you reading it for yourself, did Emani Ellis tell you that the security guard for the defendant apologized?
According to the report, yes.
Yes? Do you know what she apologized? I'm sorry. Do you know why he apologized?
Objection.
How would, like, just think about that for a second. Do you know why this other person apologized to this person you were speaking to? Like, in what world is she going to know the answer to that? And if she does know the answer, it'd be because someone told her, which makes it hearsay. So there's just no world where this ever comes in. And this is like the 200th time he's tried to do this across, this is witness number 4 now, I think. Plaintiff. No, witness number 5. This is the 5th witness. And, this attorney, man. Oh, this is painful.
No further questions. Thank you.
All right, recross?
Yes, Your Honor. Briefly. Your Honor.
I'm going to take.
What's that? New pen for juror number 5, please.
Oh, jury question.
We're going to have to rewrite the budget for pens and papers.
He has shown up. Dr. Counsel had referring to if he had shown up with a broken finger, a broken back, broken other body parts. Let me ask you this. Plaintiff had shown up with physical injuries.
Objection, Your Honor. This exceeds the scope of my...
Overruled.
If plaintiff had shown up with scarring and bruises or broken back, even if she came for a psychological evaluation, would you have noted it?
If she reported it, yes.
Okay. And everything in the report, all the factual assertions, for example, page 2 of those 2 exhibits, those are what plaintiff told you, and you do not know whether in fact she was telling the truth, correct?
Objection calls for speculation.
Overruled, yeah.
I did not receive any depositions or other supporting documents to counter what she was reporting.
Yeah, no, I'm sorry. I should separate that. First of all, everything that we've been talking about on page 2, that's just what plaintiff told you, right?
Correct.
And you don't know if that's true, right? You don't know if what she told you is true.
Right, I don't know.
Okay,
I wasn't there.
All right. Any questions from the jury?
Yeah.
All right, Doctor, I'm going to ask you a couple questions. They're a little bit overlapping, but I'll go ahead and ask them.
There we go.
If a physical injury is not reported to you, is there any reason you would still take a note of it?
Do I just answer yes or no, or
You can explain.
From what I recall, when individuals were referred for treatment, they were asked to fill out paperwork. On that paperwork, they were asked to document if they had physical injuries or physical pain symptoms. In those situations, I would review it and include those in the report.
So the court's going to ask us some follow-up. So when the patient is coming in, they provide their responses to questions relating to their history and physical, correct?
Correct.
And so they would note any physical symptoms, whether or not they related to the reason for their visit?
Correct.
All right. And that's all part of the form?
Correct.
Was it your practice that if the psychological trauma was caused by a physical injury, that you would note that on your chart?
Yes.
There you go.
So
she's saying in her practice, because she's evaluating psychological trauma, remember that's her role in this whole situation. She just admitted if the psychological trauma that she's evaluating stems from a physical injury, that's something she would note. But when you look at her report, she does not note any sort of physical trauma, in particular and specifically in regards to any sort of injury or scar to the face. So, boom, that is a silver bullet right there if I've ever seen one.
Do you recall actually seeing any marks on plaintiff's nose or cheek?
I do not recall.
All right. Any follow-ups from counsel regarding those questions?
Yes, sir.
Go ahead.
You earlier testified about the attorney filling out this form, and it's the attorney who actually puts on what the patient is coming to see, correct?
Objection. They didn't as to what form?
The form we just spoke about.
Overruled.
Correct.
Do you have the form?
I do not.
Where is the form?
With the Psychological Corporation.
Right. So we really don't know what the form says at all, correct?
I do not.
So when the court asks you this question, you're not sure what relates to this case as a general response to the form as to any of the patients, correct?
Like I said, I cannot recall.
And the question about go straight back. I just want to ask you, the form that you're talking about that's filled out by the attorney.
The claim form is filled out by the attorney.
The claim form, this form that is at issue now. Would an attorney ever put physical injury so that you would then treat the patient for physical injury, or every time you get the form, it's really psychological?
Objection.
I would throw the question. I have no further questions.
All right. Anyone from the defense?
Yes, Your Honor, just one. One of the questions I believe you answered that if a claimant comes in and a report of physical injury, that's included in whatever documents that the company generates, and you noted in your psychological report. Is that correct?
Yes.
And so can we conclude from the fact that there is no reference to scars or other physical injury in your preliminary report that when plaintiff first claimed, plaintiff or her counsel at the time, first claimed, made a workers' compensation claim, they did not report any physical injury?
Objection calls for speculation.
Overruled.
Yeah.
I cannot recall.
Well, it's a matter of practice.
Well, matter of practice.
If they had claimed a physical injury, that would have been reported to you, and you would have included it in your preliminary report, correct?
Objection calls for speculation.
Overruled.
Did we get the answer?
No.
I would have noted it.
Okay, thank you. Thank you very
Your Honor,
much.
there's one follow-up I forgot to ask.
Briefly.
Yeah, briefly. Thank you very much, Your Honor. There was a question the court asked you. If Emani Ellis came in 2 months after, you saw her 2 months after, and you saw a 2-centimeter scar on her face, well, how do you know today if you really saw it or you didn't see it? Isn't it true that you didn't? You don't know. It might have been there and it might have not been there. Is that fair?
Objection, argument, there's public speculation.
Yeah. We've already been over that.
All right. Can this witness be released?
Yes, Your Honor.
Yes, sir.
All right. Thank you.
She's done. She's free.
15, as usual, do not discuss the case with anyone, including the jurors. Don't form any opinions or do any research. We'll see you at 3.
All right, they're going on break. You know what's left. Boom, our girl, Bella Calise.
And alternate, and does plaintiff have another witness to call?
Yes, plaintiff calls defendant Cardi B as a hostile witness.
Thank you.
Oh boy, as a hostile witness. Here we go. Hey, if y'all are here, y'all enjoying it, you haven't hit the like button yet,
Ma'am, may I please have you stand right next to the court recorder?
go ahead, hit
Please raise your right
that.
hand. Do you solemnly say that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. May I please have you state and spell your first and last name for the record?
My name is Delphine Morales Saunders.
May I please have you spell it?
The whole thing?
First, last name, second.
Okay. DELPHISALMANZA.
I'll put this out.
Thank you. You may take a seat, please. I'll watch this out.
Okay, thank you. Thank you all for coming back. Good afternoon, Ms. Almanzar. Do you prefer I call you Ms. Almanzar, Cardi B, or it doesn't matter?
I mean, you can call me Cardi B.
You feeling better today?
Maybe.
And I'll need you to speak up, man.
Yeah.
I'd like to hear you.
Yeah, a little better.
Your birthday is October 11, 1992.
Yes.
You're left-handed.
Yes.
Are you the firstborn child?
To my mom.
Did you take any medication, drugs, or alcohol that would affect your ability to testify today?
No.
On the date of the incident, did you have black hair, blonde hair, or different color hair?
I quite don't remember. I do know I had a hoodie on.
Okay. Yesterday you had black hair, short hair. Today it's blonde and long. Which one is your real hair? Are they both real?
They're wigs.
Okay, sorry, I didn't know that. It's a good week today then.
Oh boy.
Do you have any affiliation at this time with a gang?
Objection, Your Honor. Motion ruling that violates social limits.
Tara-isms in my mind. Hi everybody, what is up? Good to see you can make it. Just in time. Look at that. Perfect timing. Cardi B just took the stand, got called as a hostile witness. And actually that objection right there, that's a big one because what I understand, there was a pretrial motion to exclude pretty much all of Cardi B's song lyrics, her affiliations, shows she was on in the past, exclude all of it as just being irrelevant to this trial. We don't want to prejudice the jury or bias the jury against her with by showing clips of her getting in people's faces and screaming and fighting because it's improper character evidence. It can't come in. And so now he directly asked her, I think, what was it? Are you a part of the game?
Do you have any affiliation at this time with a gang?
Objection, Your Honor. Motion ruling that
Oh, any affiliation with a gang, which, ooh, the judge might crash out on this one because this is the explicit subject of the pretrial motion. And all of that got excluded by the judge. And now he's directly asking about something that was excluded. Ooh, if I were the judge here, I'd be excusing the jury, having them step to the back for just a few minutes, and then I'd be going in on this lawyer of like, look, I've already had to sustain 1 million objections against you because you keep asking terrible questions. I've had to feed you questions so you could ask them the right way, and now you're trying to bring up content that I explicitly excluded on a pretrial motion, bro. Like, ooh, let's see how the judge handles this. Oh, he handled it. Oh, he's chill. What did he say? Counsel, you know better? He just left it at that?
Your fingernails, can you show them to us for the trialist to see? How long are those fingernails? Just your best estimate. Not would you take a ruler to it, but if you were to give your estimate, is that half an inch, 1 inch, 2
I
inch?
think it has to be less than an inch. Way less than an inch.
Can you show them to us again? All right. Are they pointy?
These are not, to me, are not pointy. They're like circle, oval.
Okay. Are those your real nails or are they fake nails?
Fake nails.
If I wanted you to change them to 3-inch nails, how long would it take for you to do that right now?
Well, it really depends. Like these are like glued on, so they will be a little bit quicker. Sometimes I do acrylic, which could last me on for 2 weeks. I will literally have to take like 2 hours to melt them off if they're acrylically on.
On December 24th, 2018, do you remember going to 8920 Wilshire Boulevard in Beverly Hills?
December?
I'm sorry. February 24th of 2018. Do you remember going to 8920 Wilshire Boulevard?
Yes, sir. Both yes or no?
Yeah, yes.
Hey, our girl looks good. She looks good. Can't hide it.
Do you know Dr. Aziz Olai, who's in that building?
No.
Do you know Miss Parsi, who's in that building?
No.
Do you know Brianne Soraya, who's in that building?
No.
Who do you know in that building?
Well, at the time, I went to see Dr. Finke. I had an appointment with him that day. So that's who I went to see that day. Do I personally know him? No.
Purpose right now, just laying out the foundation kind of what setting the stage really. So now we're starting to get into the meat of, okay, what happened on that day.
When you went to see him, were you seeing him as a friend or as a patient?
As a patient.
And when you went to see him, it was a Saturday, correct?
Yes.
And you filled out an intake form and you signed some other documents that he would be your treating doctor, correct?
No, for that day, yes.
Yeah.
I don't live in LA. So.
I understand. You came all the way from Atlanta, Georgia, correct?
Jersey and Atlanta.
I understand. So when you went to see Dr. Finke on February 24th of 2018, when you went to see him as a patient, correct?
Yes.
And you got medical treatment from him, whether it was for 1 minute or an hour or longer, correct? How much time did you spend?
You need to answer yes or no.
Oh, yes. Sorry.
Thank you. How long did you spend with the doctor that day?
I'll say about 25 to 30 minutes. Around that time.
Yeah,
not
she
that much.
was not there long.
And when you were there on that date with Dr. Finke, did he examine you?
Yes, he examined my baby for a little bit.
And what baby was that? What number?
Number 1.
Oh, that was the first child you ever had?
That's my first child, yes.
And you were 25 years old at the time?
Yes.
You're aware that plaintiff was the same age as you at the time?
No.
Besides examination...
Now, I'm not fully caught up on my Cardi B lore. I know she has at least a baby named Culture, right? Is this the baby we're talking about here? Is this baby number 1 Culture? And if not, if y'all can please educate me on the Cardi B lore, I would appreciate it.
And what did Dr. Finke do for you? Objection?
We're not here for her medical care.
Yeah, we don't. Yeah, none of that. None of what she was there for is relevant, especially when you think about the very thing that caused an issue in the first place was she felt like she was being recorded and being exposed for some intimate medical details that she took issue with. And now you've got the attorney who's trying to ask her questions about that, the nature of it and the specifics. It's like, no. Good objection. Keep that out. Yeah, no purpose here. All we need to know about is this interaction she had with Emani Ellis, security guard.
Did you keep Dr. Finke's? Oh, sorry. Who referred you to Dr. Finke?
I asked somebody to find me like a very upscale private doctor. So I was like, I need to go to the doctor's like tomorrow. Like I feel so weird. And they were like, we're gonna find somebody. And that's just how it goes.
When you were outside in the hallway before you entered Dr. Finke's office, did you see this individual, Emani Ellis, in the hallway?
She was waiting for, she was right in front. As soon as the door of the elevator opened, she was waiting, I guess, for the elevator. She was going inside the elevator.
And you were coming outside of the elevator?
Yes.
Do you know approximately what time it was when you...
I never thought about Cardi B before this testimony, but now I think she's fancy and a stand-up comedian. Solid gold. Kids, culture, Cephas, and Blossom. Order of oldest to youngest. Cephas, boy. So I was right. Aha. I knew not only she had a kid named Culture, but this is the one we're talking about. Yeah. But yeah, no, the personality is really shining through, which is endearing. It's actually helpful for the jury as far as, showing this likable side. Certainly compared to the plaintiff, who kind of came off as a bit grouchy. Did not present very well at all. And also too with the plaintiff, look at the comparison in the body language. The plaintiff the whole time was going like this, swaying in the chair, just kind of fidgety. Cardi's been super calm, sitting still, just stating things matter-of-factly as they're happening. So yeah, sorry, boy's name I think Waveset Cephas. Wow. What a name. What a name.
When this occurred?
Right in front. As soon as the door of the elevator opened, she was...
All right, let's hear it.
Did you see this individual, Emani Ellis, in the hallway?
She was waiting for... she was right in front. As soon as the door of the elevator opened, she was waiting, I guess, for the elevator. She was going inside the elevator.
And you were coming outside of the elevator?
Yes.
Do you know approximately what time it was when this occurred?
About, I guess, like in the afternoon, 1 o'clock, around there. Yeah, 1 something.
So they passed each other in the elevator. Cardi was in the elevator, doors open, boom, there's Emani standing right there. Cardi's exiting the elevator. Amani's getting into the elevator, and I guess that's when the comment was made about oh, that looks like Cardi B, and then Cardi's like, stop recording me, and then Emani gets out of the elevator. That's the big factor, one of the biggest arguably the biggest factor I'm going to point to as to why she was an active participant. Emani Ellis was. She wasn't just this innocent victim, because she made it sound like she was just brutally assaulted for no reason out of nowhere. But it's like, no, from what it sounds like, and I have not heard any evidence to contradict it, especially because Emani Ellis, the plaintiff, admitted to exiting out of the elevator. In her words, she said to clarify, but I think we all know what is meant when you say, oh, you think something slick was said and you want to go clarify? Oh, yeah, we know what that means. You're getting up in their face and be like, yeah, say that to my face.
Have you ever seen Dr. Finke either before or after February 24th of 2018?
No.
When you went to Dr. Finke's office, your security guard drove you there?
Yes.
And his name is Karan Newton?
He was my security guard. Yes.
Did you have more than one?
It depends, but he was just my main one, yes, at the time.
Did he go up with you to the medical place?
No, I didn't want him to know that I was going to an OBGYN.
You didn't want your security guard to know that?
No.
Why?
First, I didn't want people to know that I was pregnant. Second, I was a little like, I don't want a guy that I work with to know I'm going to a vagina doctor.
Bro.
Did you trust your security guard?
In certain ways, yes. In certain ways, no. I don't know. Sometimes you just really don't trust everybody in your business. You don't want everybody in your business.
Yeah.
Do you remember what floor you were on when you exited the elevator?
The 5th floor.
And it's good. And look, we talk about consistency, right? I brought up consistency earlier as a big part of how the plaintiff's story from start to finish really has a lot of inconsistencies in it. But so far, everything Cardi said is completely consistent. It's that she took exception to what she felt like was a security guard who was infringing on her privacy and recording her, and she didn't want people in her business like that. And now here she is being asked about her security guard, and she's giving the same answer as to why she doesn't let him in on everything is because she doesn't want this specific thing, her being her first pregnancy. She didn't want that leaking out to the public. And so it's like it's a completely consistent motivation throughout all of this, everything so far. I've yet to see one inconsistency from Cardi B here. So, LOL, I feel you, Cardi. Yeah, yep. She's got a point. She's got a point.
At any time did your security guard come into the building after learning about there being some kind of incident in the building?
He was waiting for me, like, not necessarily like inside. He was like waiting for me like by the exit, like by the door. Around there, yeah.
Do you remember the building?
Yes.
Do you remember?
Well, I kind of remember, but I do know that he was waiting for me by the door.
And you're talking about the lobby area where you take the stairs up?
Mm-hmm.
So he was inside the building or right outside?
I don't really recall, but he was like, maybe it was in the inside, it was in the outside, but he wasn't like in, like deep in. He was like waiting for me by the door. And the door, he had it open for me to come out.
See, lesson learned. Security guards are not the top of the world's food chain. If you see celebrity, run. Yeah. No, I would agree with that. Oh, yeah.
All right. So would you consider that your security guard was with you at the time, whether it was upstairs, downstairs? In your mind, would you agree that your security guard was with you at the building? Is that fair? Was your security guard with you in the lobby of the building at 8920 Wilshire Boulevard on February 24, 2018?
In the lobby, yes, when I was exiting.
He was in the lobby with you?
In the lobby. I can't say he was with me because we was leaving. He never went upstairs, so.
Do you know if your security guard, Karan Newton, spoke with Miss Ellis at any time that day?
He did not tell me he spoke to her at all.
Do you know if he did?
He told me he didn't. So I'm going to go with his word. No, because I told him like what happened upstairs. He was like, damn, I should have went upstairs. But he never told me that he spoke or seen her, so I wouldn't know.
You came to this courthouse with another fine gentleman security guard, correct?
Yes.
And when you go to different places with your security guard, if an incident occurs where you're threatened or you're injured or anything happens,
yes,
aren't they supposed to come help you?
Why don't we move on?
Yeah, move on.
When the incident occurred, did you call your security guard or send him a text message or do anything to let your security guard who was with you know that something happened where you wanted his help?
Objection. Argumentative as to with.
Yeah, no, she can answer that.
I told him like, yo, you wouldn't even believe what just happened upstairs. And he was like, what happened? And I practically told him like, I'll tell you later, like when I leave. I'm like, wait for me. But I told him like, wait for me downstairs, like by the door. And that's what I told him.
If you were in any danger, would you call your security guard or would you call the police or would you call both or do nothing? Did you feel that you were in danger on February 24, 2018 when you were upstairs on the 5th floor?
For like those 50 seconds, yeah. After I went to my appointment and like the argument just passed me, I didn't even mind it anymore.
So that's what's interesting is that she hadn't even had her appointment yet. She was still going to talk to the doctor. If this was actually such a big blow-up kerfuffle that the plaintiff is making it out to be, I would imagine you'd find yourself in a situation where everyone's got to separate. Everyone's told to leave, but apparently, yeah, the incident happened, and then she just went on and had her doctor's appointment afterwards. So that also speaks to the kind of the nature of what happened here and how crazy it was or really was not. If Cardi B, who supposedly viciously assaulted this girl, was just kind of allowed, and supposedly with witnesses too, people who witnessed it, if she was allowed to basically go on her merry way and go see her doctor and then leave after that. So yeah, just the timing of it is also kind of going towards corroborating Cardi B's side of the story.
Did your attorney show you a photograph of Dr. Finke to refresh your recollection as to who the doctor was that you saw on that date?
Yes.
Okay. And you had a different set of attorneys before, in 2022 and 2023. Did they do the same thing?
No, they didn't.
So, do you know what's discovery?
Yes.
What are form interrogatories?
Objection.
What is special interrogatory?
I do not know.
What are requests for admission? You don't know, right? Is that fair? You don't know?
No.
You do know?
No.
Why is this relevant?
And when your attorney responded to the written discovery on your behalf, did he or she
show you the discovery responses? Did they email you a copy of it?
I mean, I will have to see what you're asking me.
I will show it to you. May I approach, Your Honor? To show her the discovery only? Thank you, Your Honor. Yes. I will show it to you.
I don't know. He's going to have to get somewhere quick with this point, or I feel like the judge is going to shut it down. This is
For
not
identification purposes,
this is not pop quiz day for Cardi's legal knowledge.
set 1 dated September 30th of 2022.
That's right.
That's what it is? Okay. Just going to show you the document. You can take a look at these pages. Did your attorney show you those documents at any time in your life?
I'm not quite sure. I don't think so, no. Well,
Now, presumably, you'd
And
think
I'm going to show you.
the answer would be yes, because these are interrogatories. Discovery is something that you have to comply with. But basically, right, requests for documents, requests for admissions, interrogatories are questions that are asked. Basically, it's both sides trying to figure out the other side's case before going to court, before having a trial. So presumably Cardi would know what these are. Presumably her attorneys met and sat down with her and were like, hey, they've asked you these 10 interrogatories, asking these 10 questions. What are your answers to these questions? We're going to work with you to fashion answers that are legally admissible or good answers under the letter of the law. And then she would get the final approval, because presumably too, she would have had to sign for them to affirm that these are in fact her answers to these statements. So yes, I would think she has seen all this stuff, but when you're talking about a case that's been going on for 7 years, apparently, since 2018, I'm sure there's been lots of things that were shown to her that maybe she doesn't recall right off the top of her head. So I understand why she may feel like, oh, I don't know what these are, but I would put money down that she has been shown these before.
With the court's permission, the responses, which were drafted and served on January 17th of 2023. Can I approach, Your Honor? All right. We'll show you these documents as well, so you can take a look at those documents. Do you ever remember receiving these documents from anyone, whether it was your attorney, the attorney's paralegal, a family member, anybody? Did they ever show you these documents when they responded on your behalf?
this one I saw. This one I saw.
Okay, you saw that one?
Yeah.
Okay. I want to go over it with you. On the one that you're on the right, if you can look at 12.1. You see the question, 12.1? It would be, I believe, on the 6th or 7th page. And it will ask if there are any witnesses to this incident.
Yeah. Well, can you point it to me?
I'm sorry?
Point
Show
it to
it
me.
to you?
Yeah, sure.
Can I approach, Your Honor? All right. It's on page 5, under 12.1.
Mm-hmm.
Did your attorney ask you if there were any witnesses to this incident?
Yes.
All right, we're going to avoid attorney-client conversation.
And all this, Your Honor, this is the discovery issue that the subject.
Not a discovery issue, Your Honor. I'm asking her question about if there's any witnesses, and it's for impeachment purposes. Okay, and if you look at the response, there's a response there in the 50-page document to your left. May I show it to her, Your Honor?
Right.
All right, land the plane, buddy. Where are we going with
By
this?
page in line, I'm not sure
Sure.
what it means by trying
I can show it to you first if you like.
But I just, what do you?
I wanted her to talk about the response.
All right.
Even the judge is like, what are we doing?
May I read the question when I go back to my seat?
It's your direct counsel.
Thank you. So first, I want to ask you if this is your signature on page 47. Is that your signature?
It could be, because if it's like by electronic, that's how I sign. Like,
And the question that I showed you, 12.1, let's say you want to read it or you want me to read it to you?
you can read it.
State the name, address, and telephone number of each individual who witnessed the incident. This is A, so paragraph A. or the events occurring immediately before or after the incident? That's what the question is.
Yes.
As you sit here today, is it your testimony that Dr. Finke is a witness to the incident?
Absolutely.
He is a witness?
Yes, she knows. She was there.
Is Dr. Finke outside speaking with you?
Outside where?
On February 24, 2018.
Outside like...
In the hallway?
Yes.
He came out of his office?
Yes.
And your response in 12.1, this is what you responded with your attorney's assistance. I won't hold you 100% at fault for it. Question, I withdraw. I apologize. The response is, responding party incorporates by reference the preliminary statement and general objections set forth above, subject to and without waiving the foregoing objections. Responding party responds as follows. Responding party may be contacted through defendant's counsel. Emani Ellis may be contacted through plaintiff's counsel. And then it says, unknown staff / employees at Cedars-Sinai Medical Center, including at least 2 such persons who intervened during the incident. Discovery is continued. Were you at Cedars-Sinai Hospital or Cedars-Sinai Medical Center when this incident occurred?
No.
Okay.
But to my knowledge, Dr. Finke works also for Cedars-Sinai, but we wasn't for Cedars-Sinai.
Is there any reason why your attorney or your prior attorney? Yes, sir. I'm not.
I don't know. Like, if we're identifying, oh, you said you were at Cedars-Sinai, but actually you were at this other place, weren't you? It's like, okay, even if that is true, that this is an inconsistency. Like, for what? Like, what? If we're talking about inconsistencies that matter, we're talking about ones that, oh, this is inconsistent, and this actually is pointing towards something like a big deal in the case, like a material fact. Like, if you're being inconsistent about whether or not there was an injury to your face, then yeah, that's kind of a big deal. But an inconsistency over the name of the place that you were at a place that she's never been before, never gone back to, never spoken to anyone since then for something that happened 7 years ago, and you're going to try and claim your big victory, your big inconsistency, and impeach her credibility based on, she called it Cedars-Sinai Hospital instead of what it's actually called. It's like, if that's your big win, that's your big slam dunk home run, gotcha moment. Like, it's not a good case. You don't have a good case.
At the time when you saw Dr. Finke, you knew his name at that time, correct?
I didn't know his name. And for a while, when I was getting asked by lawyers like his name and like the receptionist's name, I didn't know it because I saw him one time. So I kind of like just forgot about him.
But when your attorney asked you for the name for purposes of trial, then you did remember the name.
I didn't remember the name. I told him there was 2 witnesses. The receptionist and the doctor. I told him it was a doctor. My doctor came out at the time, the guy that checked me, and the receptionist. She knows. She was there. He was there.
Who knows?
The plaintiff. She knows.
How do you know she knows?
Because that's what separated. Got in between us while we was verbally arguing.
Who got in between?
The female receptionist, she came out first, and she started like telling her, like, "You're security, what are you doing?" And then that's when the doctor came out. He was like, "Go to my office." And that's when I just walked away, and that was the last of it.
Well,
and 12.1 question.
So with that in mind, I'm pretty sure the receptionist does testify on day 3, and I think the doctor does too. But we'll have to wait and see. But those are both going to be great witnesses as far as getting to the root of what actually happened here. Because, right, we don't have a dog in this fight. We're just watching this just to maybe learn a thing or two and also just be entertained. So we really don't have a dog in whether or not Cardi B wins or loses this. But the biggest dog we have in this fight is just for justice, to make sure that the right thing is done, that justice is served and delivered. And in this case, my reading on it so far is like justice absolutely requires that Cardi B not be held liable for this situation. But my opinion may change. It may be changed by the testimony of the receptionist and of the doctor.
12.1 subparagraph D. State the name, address, and telephone number of each individual who you or anyone acting on your behalf claim has knowledge of the incident. You just testified that Karan Newton was downstairs in the lobby on the date of the incident. You also testified that you told him different things about the incident. What is the reason, this is the question, what is the reason you did not disclose Karan Newton's name in discovery?
Because he wasn't upstairs.
It was mischaracterized as the testimony. It's compound. It's irrelevant to the merits of the case.
Yep.
In written discovery, were you asked to provide the name of your security guard?
Your Honor.
Yeah, why don't we, I don't know what you're trying to impeach her on, because she hasn't testified anything. You're saying it's impeachment, but you're not impeaching anything.
Yeah.
Did you respond to special interrogatory set 1 through your attorney? Your Honor?
All right, the court's going to sustain its own 352 objection. Why don't you move on?
Yeah, move on. For anyone just getting in here, the main theme of this is, I'm calling it, we call it as lawyers, the objection buzzsaw. That defense has this buzzsaw going of objections, and the plaintiff's lawyer just keeps walking into it over and over and over again. You'd think he would get smart and stop doing it.
Do you consider Karan Newton to be a witness in this case? Okay?
No.
Sustained. Counsel, I need you to move on. This case isn't about discovery. Move on to what it is about.
Yep.
Is Tierra Malcolm a witness to this case?
Counsel, please.
Do you know of who the witnesses are?
All right, we're going to take a break, folks. Why don't we take a break? We'll resume at 3:55. In the meantime, please do not discuss the case with anyone, including other jurors.
I'm sensing a judge crash out. The judge explicitly told him to move on. He did not move on. So he told him, literally, let's hear that again, actually.
Move on to what it is about. Move on.
Karan Newton to be a witness in this case? Okay?
No.
Sustained. Counsel, I need you to move on.
All right, so he says move on. Is objection sustained? Counsel, move on.
This case isn't about discovery. Move on to what it is about.
We know what this case is about.
Is Tierra Malcolm a witness to this case? Okay?
Counsel, please.
Counsel, please. Okay, there's your second warning. Move on.
Do you know of who the witnesses are?
All right, we're going to take a break, folks. Why don't we...
3 strikes and you're out. We're taking a break. Yeah. Let's see. Thank goodness Cardi B is so dang funny, making this whole trial worth watching. I cannot get enough of her making faces and wisecracks. Even just this moment here, she's like confused.
Do you know
like,
who the witnesses are?
All right, we're going to take a break, folks. Why don't we take a 10-minute break? We'll resume at 3:55.
She's like, what do I do? Yeah, bro, too zealous, lol. Yeah, it's not even just zealous. It's just dumb. He's just being dumb. Like, the last person in the courtroom you want to piss off. Well, the last people you want to piss off are the jury. That's the most important, of course. But the second most important to not piss off is the judge. And plaintiff's lawyer has just been, it's just been horrible.
Anyone, including other jurors, don't form any opinions or do any research.
All right, so jury's getting excused. We'll see if he addresses counsel with the jury out of the room. Or okay, yeah, here we go.
Counsel, let's define what we mean as impeachment. Impeachment is she says something, and you've got evidence that she said something else. Right. She said, I didn't know anybody's name. I got sent there. I was seen for a short amount of time. I didn't remember what their names were. Right. And then you're saying, here's this document that says you don't know what their names were.
Okay, so maybe I'm going about it the wrong way. That's why
you absolutely are. You're not listening to the court's direction when I'm asking you to move on.
I'm sorry, I'm not doing it intentionally.
It seems like you are.
I really am. I understand the court's issues, but I want to explain if I may.
Go ahead.
So I was going to ask her if she believes that Karan Newton is a witness in this.
He wasn't there. He was in the lobby.
Right, but 12.1 subsection D talks about witnesses that have knowledge about this case.
What knowledge does he have? He was in the lobby.
I was going to ask her. She spoke to him about it. That's what D is all about.
Okay, so he was a hearsay witness, but she told him something.
Well, he's a witness.
Okay.
Also, especially...
So here's the other issue. You didn't depose her. If you wanted to ask these questions, you could have taken her deposition.
I understand the issue. There is a special interrogatory number 15, which is on point, which asks...
And this is such a good feeling when you're on the defense, well, really on either side. When you're sitting there and you're looking at the judge who's staring laser beams at your opposing counsel and just grilling him. You're just sitting back. You're sitting pretty. It's a good feeling because judge definitely not a happy camper. Well, yeah, it's just you're not giving him anything to be happy about. You're ignoring the court's directions. You're claiming it's unintentional, but no, I agree with the judge. It totally seems intentional. I don't know how much clearer you can be as a judge than saying, counsel, this case is not about discovery. Move on. And then he asks the same exact question about a witness, and you say, counsel, please. And then he asks a third question about witnesses, and then you have to excuse the jury on the court's own motion to have this tete-a-tete. You're sitting pretty. You're looking, watching the meltdown happen, and it's great. You just sit back because old adage as well: never get in the way of your enemy when they're making a mistake. And he's just making mistake after mistake, and now he's got he made his bed. He's got to lie in it now. In front of the judge, and he's just sitting back enjoying the show.
The disclosure of the security guard. Okay. She didn't disclose his name, but she knows his name.
Okay. So what are we going to do with that?
We're going to have the jury know that she didn't give the name of her security guard.
And so in order to be admissible, it has to be relevant. So in order to be relevant, it has to be probative. So it's got to be more likely to prove or disprove a material fact in the case. None of this has anything to do with the material fact.
Let me explain.
Yep.
Her testimony, Your Honor, is that Karan Newton doesn't know anything about this case.
She doesn't say that. She hasn't said that. She said he was in the lobby.
Even better. Plaintiff has testified
testified that she has spoken with Karan Newton.
Okay.
It's in the medical records.
Okay.
He's a witness in some form or
So
fashion.
the appropriate means for you to do that is one, to file a motion to compel, or number two,
Motion to compel, or you call this guy Karan Newton as a witness.
to seek evidentiary sanctions, which would have been handled pre-trial. But we're not going to have this witness testifying in trial in front of a jury about discovery issues.
That's fine. The issue is, if it asked her to provide the name of the security guard and she didn't disclose it, why is it not fair? These are under penalty.
Then you file a motion to compel.
Yeah, this is all issues to be resolved pre-trial. Motions to compel, motion for sanctions. If there's a discovery violation, you hash that out pre-trial. Discovery is just you're getting your facts of the case, so that way when the witnesses are testifying, you can ask them questions about some of the information you learned in discovery. But yeah, if there's a discovery issue, you don't litigate that in the middle of a trial, especially not in front of a jury. Oh yeah, this is. I just have no. Where did they find this guy? The bargain bin at Walmart?
A motion for evidentiary sanctions. You did the.
She testified in her discovery that she was alone. Today she testified she was with Karan Newton. I want to ask her about that.
You already did.
I didn't show her the discovery. She's on point on that issue, Your Honor.
You're going to impeach her with the document saying that she was alone when she was alone in the elevator and the incident happened. That's your impeachment?
My impeachment is she did not reveal that she was with the security guard in the lobby and do anything to provide this information when the other side...
Again, it's a discovery issue, so we're not going to go there.
Well, Your Honor, the other side was able to impeach plaintiff.
With what?
With this discovery. They went into it at
When she offered inconsistent statements in discovery.
Yep.
That's what's happening here, too.
No, she hasn't said anything inconsistent.
No, that's the big difference here. He's trying to say, well, the defense, they've been allowed to impeach through discovery. Well, yes, if you have a pretrial statement through a deposition that is inconsistent with what's being said at trial, then yes, you can hold up the discovery deposition as your, oh look, there's an inconsistency there. What the plaintiff's lawyer trying to do here is say, well, she hasn't said anything inconsistent necessarily, but she kind of did, because in her discovery question about did you have any witnesses there, she did not list that her bodyguard was there, but now here she is today saying he was there, and the judge is saying kind of, he was down in the lobby, he wasn't with her, he didn't witness anything materially, so he's really not relevant to what's happening here. And so you trying to question her about a discovery interrogatory where she did not list him as a witness, like that's apples and oranges. It's two completely different things, but he's trying to equate them because he wants to go down this path. And he's already been shut down like 4 separate times on this, just in this little back and forth, but he continues to try and explain it. Yeah. Yes, one part is the competence, and the other is that he seems to be walking the fence between insensitive and offensive. One part of it. Who's walking the fence between insensitive and offensive? We're talking about the plaintiff's lawyer or the judge? But yeah, this is just not the place to hash out this issue. The judge has already made his stance clear, but he continues to try and bash his head against the wall. We've already got the objection buzzsaw coming from the defense. Now you're walking into the judge's buzzsaw of just trying to do something the judge is clearly not wanting you to do.
She said she didn't know the person's name.
She knew Karan.
discovery, she said she didn't know the person's name.
She knew Karan Newton's information. We asked for the name of the security guard. She made it appear.
I'm going to ask you to move on. We're not going to get into further discovery issues.
May I just raise one point? I don't want the court to overlook. I want to point out this questioning started with a direct contemptuous violation of the order on the motion to eliminate, excluding any mention of gang affiliation, and that's the first question he asked.
Yeah, that's it. So that's what I thought the judge was going to have a crash out based on that, but lawyer, it gets worse. Oh boy. Okay, we'll see. Because yeah, when the judge issues a ruling, that's like golden, a golden order. When the judge issues a ruling, like that is just cannot violate it. And the judge issued a ruling in this case saying there will not be any reference to any alleged gang affiliations that Cardi B has. And then the plaintiff's lawyer asked her directly as one of his first questions, are you affiliated with any gang? Yeah, so defense is bringing this up now. Now, normally, as a defense lawyer, like I said, never get in the way of your enemy when they're making a mistake. So he was sitting back pretty for that point. But now he is reminding the court that not only are y'all having this back and forth where he's clearly not getting the point about what you've already ordered, Your Honor, and saying that, look, we're going to move on. This discovery stuff should have been handled earlier. But also, he led off this entire line of questioning with a direct contemptuous violation of the pretrial order. So either he's attempting to move for a mistrial, or he's attempting to cause so much damage to the trial process that the judge has no choice but to declare a mistrial. But you play that game with the judge, he'll declare a mistrial with prejudice, or he'll dismiss the case with prejudice. So you cannot refile, and especially if statute of limitations is already run, you would be barred from that anyway. But yeah, like this judge, he's pretty chill. Yeah, he's super chill. He's actually, I think, far too chill for what the situation calls for. So I'm very curious to see what his response is now to the defense lawyer bringing up expressly the violation of the order. Let's go back.
With a direct contemptuous violation of the order on the motion to eliminate, excluding any mention of gang affiliation, and that's the first question he asked.
Yeah, I don't expect that there's going to be anything further than that. I mean, you knew it was wrong when you said it.
No, I didn't.
You didn't know that there was a specific motion to eliminate excluding?
The motion to eliminate, Your Honor, is prior bad acts.
Nope. You might want to look at your trial binder to see specifically what it says. All right. All right.
I think. Okay, here's my new theory on it, of why the judge is as chill as he is. Just such a chill guy. I think it's because he realizes this case is going so poorly for the plaintiff that if he felt like it was a closer call, he'd be getting a lot more worked up, because now these types of things that the plaintiff is trying to do might actually sway the outcome of the trial, and that's a big deal. If an unjust outcome is effectuated based on something improper that was done by the plaintiff and the judge let it happen, that's a big deal. But I think the judge, my reading I'm getting from this is that the judge kind of realizes that, yeah, I think this case is basically falling apart. It's in shambles for the plaintiff. So, yes, is he doing stuff that's improper? Yes, but that's honestly making his case look worse than it is making it look good or better. So I think he's kind of letting some stuff slide that otherwise he would not be letting slide, especially the direct violation of the order that he gave.
Resume 5 minutes.
All right. So they're taking a little break, and then we're home stretch. We're almost there on day 2. Here we go. Y'all hanging in there? Y'all still alive? Hey, if anyone's here that hasn't hit the like button yet, go ahead, hit it now. We're at 14 total, it looks like. If we can get to 15...
All right, welcome back.
Well, nothing special is going to happen, but I will be happy, and my smile will grow.
All right, welcome back, everyone.
And y'all should value that, because I have a very nice smile, you see.
In the record in the Ellis matter, counsel and parties are present, as are the members of our jury and our alternate. Ms. Almagar is on the stand. Ma'am, you're reminded you're still under oath? Yes. All right. And counsel, you want to resume your question?
Yes, sir. Thank you.
Okay, here we go.
Aside from Karan Newton, is there anybody else who drove with you to the building on February 24th of 2018?
No.
So now I want to take you a little bit through the incident, bring you back in time. Do you agree that an incident occurred on February 24th, 2018?
It was a verbal incident. Verbal.
But it was an incident, correct?
I personally feel like if there's no physical touch, there is no incident. There was a verbal altercation. If you think that that's an incident, a verbal altercation, then it's an incident for you. But we both have different opinions. It's a verbal altercation. She didn't hit me, I didn't hit her. There was no
Yeah, if I'm the plaintiff's lawyer, I'm rolling with this. He might try and stick her, based on what we've seen so far and how he's just kind of a poor lawyer, he might try and stick her on the, well, no, you need to agree with me that it was an incident. And she's just going to keep saying, no, it was an altercation. At this point, I'm just saying, okay, fine, call it what you want. Call it an incident, call it an altercation. Something happened that day.
touch. So to me, it wasn't no incident.
Was there spitting?
Absolutely not.
Did you spit on Miss Ellis?
No.
Did you call her the N-word?
No.
What is your background? Are you Hispanic, white, something else?
My background?
Yes.
Well,
Irrelevance. Would you consider yourself African American?
I consider myself Afro-Caribbean.
Now, you need to go to a second to okay.
Relevance, yeah.
Assisting.
Have you ever used the N-word with Miss Emani Ellis?
No.
Did you try to take a swing at her?
No.
When you say there was a verbal altercation?
Yes.
Do you know what the word altercation means?
Like a conflict.
Like a fight, right?
It was like a verbal fight, but it didn't get physical at all.
When I'm talking to you now, are we having a verbal altercation?
We having, I'll say, a debate.
And we're debating about whether you assaulted and battered Miss Emani Ellis, correct?
It's no, I guess so, but I didn't touch her. She didn't touch me, so.
What proof do you have that you didn't touch her?
Objection.
Objection, yeah.
Also,
sorry, do you have any videos of the incident?
No.
Did you try to get videos of the incident?
I asked if there was videos, like I told my lawyers to check if there was videos, but there's no cameras, I guess, there was no cameras.
And when did you ask that? What year?
That's still just so weird to me. How are there no videos, no security cameras of a doctor's office? Like, yeah, that is just weird, man.
I feel like when I got sued, I was like, oh, I know I didn't touch her. Like, it's like, look for the cameras, because they'll tell you, I ain't touch her.
When you went to the building of 8920 Wilshire Boulevard, and you saw Emani Ellis there on the 5th floor, was she wearing her uniform as a security guard?
Yes. Okay.
You remember?
Again, you might want to just take a breath so your attorney can object.
Are you aware that my office is across the street?
No.
Okay. 8920 Wilshire Boulevard. You remember that number? You agree that that's the correct number? The address.
I remember that I went there, but I don't really remember the address and stuff like that. I don't.
If I show you the building with the number on it, would that help refresh your recollection?
Sure.
I don't have to really waste time if you don't want me to. When you were sitting here throughout the trial, you saw the 25 pages I showed, correct?
Yes.
Was that the correct building?
Yes.
Oh, and you remember entering the building, going up some stairs, taking the lobby elevator, and going to the 5th floor, correct?
Yes.
And when you exited, you saw Emani Ellis right there in front of you?
Yes. No. When I exited, the elevator.
Okay.
Not the building, the elevator.
Correct.
Yes.
On the 5th floor? Mm-hmm. And there was 3 elevators there?
I do not remember that.
At least two different elevator bays?
I don't remember that. I just remember me getting out the elevator. She was coming in. I was coming out. I could hear her. She was talking on the phone. And she said, oh my God, yo, Cardi B's here. So I kind of speed walk, but I feel her behind me. Then I hear her talking like, oh my God, Cardi B is here. So I turn around and she had her phone. She didn't have it here no more. Now she has it here. And I asked her, yo, why are you recording me? And she clearly looked like a security. She looked like a security guard. She's uniformed down. And I'm like, why are you recording me? Are you security? And she's like, oh my bad. But then I'm walking and I feel her still following me. So like as I'm walking, speed walking, trying to look for the office, I turn around again and I'm like, why are you following me? She's like, because I can. I was like, no, you can't. Why are you following me for? Like, ain't you supposed to be security? And she's like, because I can. It was like, no, you can't. And she's like getting closer and closer. Like now she's like in front of me where I can't even like really maneuver. And I'm like, ain't you supposed to be security? Like you grouped out, you're recording me, now you're following me. Like back up. And she's like, I can do what I want. It's like, no, you can. Like you can't do what you want. And that's when we started arguing.
So this is, I want to let her get that whole statement out because this is going to be really important if we're talking about what are the other witnesses going to say here in regards to the location. When they come out and they see these girls arguing, are they talking about this was like they're arguing right in front of the elevator, or are they arguing down the hall, basically right in front of the doctor's office? Because remember, there was like a hallway there. So this is going to be super important when we hear the other witnesses' testimony as to where this argument happened. Because Emani, her testimony, which granted, even that, just that 2-minute like retelling of what happened was so much clearer and more concise of a statement of the facts of what happened here than Emani Ellis's whole testimony. I felt like was so all over the place and so unclear about exactly what happened that, yeah, it's just, that's why I just don't like. I don't like this about the plaintiff's case at all. That's why I'm really leaning towards Cardi in this case, because she is giving the vibe right now. She's got nothing to hide. She hasn't said a single thing that's inconsistent so far. Everything's adding up as far as her take on the case. Maybe more will come out later that shows her being inconsistent regarding specifically, like we have a location established of where the altercation took place. So we'll learn more about that with new witnesses. But yeah, it's just she's just coming off very sincere, very credible about the situation. Yeah. But Dank Security, is this a setup or something? Who does this on their job, allegedly? That's what I don't know, man. Her word versus mine at this point. Yeah, and in civil cases, he said, she said, it's a lot easier to win on that because the burden of proof is lower. It's just a preponderance of the evidence is more likely than not. But I think here, my take on it all is still that Cardi was there. This girl recognized her. The security guard recognizes her and says that because this is what she admitted. Remember on her testimony, she admitted, she said out loud, "Oh my gosh, that's Cardi B," or something to that effect. Cardi B hears that and is like, "Why are you talking to me? Why are you talking about me?" And she's got her phone out and she looks like she's recording. Was she actually recording? I wouldn't be surprised if she was not recording. But maybe she was. But even if she was not, I can see why Cardi might have thought she was. And then from there, From there, it just became as simple as the girlies were fighting, not physically fighting. I don't think there's anything physical, but definitely like up in each other's grills, yelling at each other, just getting loud, getting boisterous, and but I'm sorry, you don't get $24 million worth of damages based on someone yelling in your face, and that's probably where the spit allegation comes from too. Is if they're up close to each other yelling, then yeah, there's probably some incidental spit that's flying back and forth, but. Yeah, I don't think the plaintiff has much of a case at all. I think my vote as a juror right now is that she's not liable. Not liable.
I was like, you can't do what you want. Like, what are you talking about? Like, it's like you invading my privacy, and now we're like chest to chest practically. So I keep telling her like, you need to back up. And I'm thinking to myself like, this girl's big. She's big. She got big black boots on, and I'm like, damn. How am I gonna do it now? She's literally right in my face, like on my chest, and we're arguing. And I keep telling her to back up, but she's not backing up. And we're arguing, cursing at each other. I did call her the B word. I did call her a bitch. Like, bitch, get out of my face. I did say, bitch, get the fuck out of my face. You're in my face. You're screaming in my face. We're like literally we're literally screaming at each other. And she kept telling me like, you're gonna leave my building. I'm like, I'm not leaving. Like, how you harassing me? I'm not leaving. Like, how you telling me to leave? I came to see a doctor. You following me. You're recording me. I'm just trying to check my cat. You're recording me. And we're arguing. That's when the receptionist came out. She started wilding out like, this bitch hit me. And I'm like, I did not hit her. I'm looking at her like, girl, I can't even hit you if I want to. You're bigger than me and you're pregnant. And she just started wilding out like, this bitch hit me. Then the doctor came out and he's like, go to my office. And after that, I just walk away. And that's just that.
Are you aware in the city of Everett?
Yeah, and if they're chest to chest like that also kind of corroborates the account of the receptionist had to physically get between them, that they were that close together. But yeah, just the way she's speaking to me like she's just recalling what happened. She's not taking these pauses to try and like choose her words carefully, and that's why the plaintiff's lawyer, that's why he's sitting and letting her kind of ramble, because he's counting on her to trip up and say something bad that he can pounce on. Cardi B wins over the whole courtroom. It's adorable. Check my cat. Yeah. No, she's doing a great job. But the plaintiff's lawyer, he's kind of banking on her saying something stupid, her making a misstep, her saying something inconsistent, so he can jump on it and impeach her and make it sound like she's lying. But yeah, there's none of these pauses of like, let me search for my words to make sure I say what I rehearsed and what I practiced saying. It's like, no, she's totally, to me, feeling like she's speaking from the heart, as far as recalling what actually happened. And maybe this is, years of being in the spotlight. She knows how to just come across well like that, based on media training. But no, I think a completely credible testimony, from what I can feel, from what I'm just feeling from the body language, from just the matter of factness of it. Yeah, just compare it once again, the plaintiff who's kind of rocking back and forth like this, not really, and you could feel like she was kind of going back to her rehearsed statements of just what she practiced with her lawyer, for what it sounds like. Jury can watch body language and pick up on any signs of deception, truth. Yeah, and that's what they say, right? Like 80% of communication is nonverbal. So yeah, the body language is super important here. And Cardi B she's doing a great job on all that.
If a security guard tells you...
That's just that.
Are you aware in the city of Beverly Hills, if a security guard tells you to leave the building, which they are security of, you would be required to do that? Do you agree with that?
Objection.
Security
Yep.
Did Miss Emani Ellis tell you that you're causing a disturbance in the building?
No. She was causing a disturbance. She's recording me and following me.
Let's talk about that. Are people allowed to record you if they want to in a public place, which will be the building that you were at?
Objection calls for legal conclusion. Mischaracterizes. Sorry.
Do you know if it's okay for someone to videotape you?
Objection calls for legal conclusion.
When she videotaped you, or maybe she didn't, what proof do you have that she was videotaping you?
She had her phone went from here to right here, and she said like, "Yo, Cardi B," like I seen her. I turned around and I seen it. I seen it with my own eyes.
Did you ever see?
She's seen it, guys.
The actual video recording of you on her phone? Yes or no?
No.
Could it be possible that she was recording you? She was simply holding her phone in front of you. Is that possible?
Objection.
Yes or no?
Calls for speculation.
What proof do you have that you were being recorded by Emani Ellis on February 24, 2018, aside from what you just said?
Objection.
Do you have any other proof?
Objection has to be answered.
Is it true that you usually wear your nails longer than what they are today?
Sometimes, most of the times, yes, and some of the times, no.
Most of the time, 90% of the time?
Lately, as in so far, I'll say about, in the past year, I'll say about 70.
70% of the time. And when...
So yeah, I don't know, videoing at a medical facility feels wrong, like HIPAA wrong. Yeah, no, I think absolutely right. I think it's wrong on two fronts. You got the HIPAA angle, which is, just medical privacy is a very real thing and needs to be upheld. And so yeah, that totally applies. But also just a security guard training of like, why are you going around recording people? Yeah, terrorism in my mind. Same 100%. Yeah, like as a security guard, especially in a town like Hollywood where you're going to have some high profile clientele coming through the building, like... Rule number one is going to be like, you ain't paparazzi, don't be recording them. Yeah, like respect their privacy, especially in a facility like this. We're talking about an OBGYN clinic where, this type of news, this is big news, like big celebrity news when pregnancies happen. So yeah, I think the security guard was wrong on two fronts here.
When you wear them long, would you agree that they're about 3 inches long?
No, not all the time, no.
2 inches or more?
So
it really depends.
Why don't we focus? She said in the last year. I don't know how long she has her nails in the last year is relevant to anything.
And when you had them in 2018, you also wore them long at that time too, correct?
I wear them long, but it really depends on the inches.
How long were your nails on February 24, 2018 when you were at the building speaking or arguing or whatever you were doing with Emani Ellis?
They were 1 inch. They were square, coffin squared, and they had flat rhinestones.
Are rhinestones sharp?
No, not if they're flat, and they weren't 3D. They were flat.
With the
I'd be digging into this because I'm a little skeptical on how are you so certain on the exact type of nails you had on that day. I would want to do a little, like, did you take pictures of them? Yeah, do a little bit more digging on that because that was a very clear, definite answer. Right, your security guard, I'm sure confidentiality is part of the agreement. Sounds like there was no reasonable separation between emotion and logic. Some female-ish LBVS? Let's be very serious, maybe? I don't know. Yeah, no, I think it all comes down to the age-old conclusion. The girlies were fighting. But not physically fighting here. They were just in each other's face, up in each other's grill.
Nails you have on right now, do you think that these nails are sharper or the ones that you had on the day of the incident?
I believe that they were not sharp. That they were square. And sometimes, like, when it's acrylic and it's square, it's like a texture. And I always tell this to my nail tech, make sure that like when you shape them, don't make them sharp on the side or don't make them that sharp. Because I don't want to...
You don't want to hurt it?
I don't want to hurt myself. I don't want to hurt nobody. I just, you know what I'm saying?
And in the past, when you had them sharp, you did hurt yourself, correct?
I never really hurt myself, but like just in case, I just be like, don't make them too pointy because I just don't want them to be uncomfortable. Not pointy, but it's like a certain type of sharp that you just don't want.
And
like,
if
yeah,
you wanted to scrap,
like these answers are just so earnest. Like they're just so matter of fact of what she tells her nail tech. Like, yeah, she's just every answer she's giving, I think, just bolsters her credibility even more.
Or cut Miss Emani Ellis' face.
Mm-hmm.
You could have done it with both of your hands, either one or both.
Objection calls for speculation.
Overruled.
I'm not saying you did that right now. I'm asking a different question. Did you understand my question?
I mean, how would I fight? How would I fight somebody? I am mostly left-handed, so if I was to like do anything mostly, I'll do it mostly with the left hand. I'm really like.
You're good at fighting with your left hand, aren't you?
Objection is characterized as a testimony.
Are you good at fighting with your left hand?
Objection lacks foundation.
Objection relevant.
Do you have any experience fighting?
Well, that's a good answer too for Cardi B. Like hit on that. It's like I am left-handed, and if I were to do anything, I would use my left hand. That's a really good fact for her as well. I wear square nails are sharp enough, even if her nail tech shaped them well. As long as Cardi wears hers, the chance of poking, scratching are high. Yeah, and my wife, she definitely has some longer nails as well, so I have a little bit of experience with that. But yeah, like they can definitely do damage pretty much no matter what, no matter how they're cut. So yeah.
With any like martial arts experience or other type of experience to defend yourself should something occur in your life.
Objection relevance.
Not really, no.
So any type of fighting that you would be able to do, it would just be freestyle from your own knowledge of fighting, correct?
Objection argumentative.
if you wanted to fight with someone, would you use your left hand, your right hand, or both?
Objection. Ask and answer.
I'd actually let her answer that. I would have withheld my objection on that and let her reiterate that. Yeah, if I were to fight somebody, I'd be using my left hand. Like, yeah, let her get that out again.
Enter a building, such as this building or any building. Oftentimes, you will see that there's a security guard or a police officer or a sheriff guarding the building. Correct? You saw that today here in the courthouse, didn't you?
Yes.
Yes.
Nope.
I guess it's not. And on the day of the incident, the security guard, police officer, or person securing that building, in your mind, when you saw Emani Ellis was in fact Emani.
Turner, are you a stunt double for Keanu Reeves? Objection. Keanu Reeves, do not take his name in vain.
Ellis. In your mind, when you got off the elevator, Emani Ellis was in your mind. Your state of mind was that she was a security guard. Correct? Objection.
No, that's a good question.
I think she's answering.
Yes. Okay. And was there any doubt in your mind that she was a security guard?
There was no doubt in my mind that she was a security guard. She had the security guard outfit on. That's why I was so confused that she was so aggressive and she's supposed to protect me, the patient.
I understand. If Emani Ellis had in fact told you to leave the building, would you have listened because she was a security guard?
Objection. This is a complete hypothetical, irrelevant life foundation.
Did Miss Emani Ellis tell you to leave the building at any point during your verbal or physical altercation on February 24th, 2018?
She told me, you're going to leave my building. You're going to leave my building.
Are you aware that Emani Ellis was hired by the owner of that building and had the right to tell you to leave?
Objection. Post legal conclusion.
Yeah.
When Emani Ellis told you to leave the building, did you follow her commands?
Objection. Relevance. Elected foundation.
You can answer.
No, she wasn't acting like a security guard.
But she was a security guard.
Objection.
Do security guards try to attack patients?
The objection sustained, we're not going to argue with each other.
Did you believe in your mind that Emani Ellis was a police officer?
No.
If you thought she was a police officer, would you have handled the situation the same way?
Objection.
Sustained. Let's just focus on what happened.
Now, when Emani Ellis spoke with you, when you exited the elevator, she spoke with you directly outside the elevator, the area directly outside the elevators, correct?
I don't believe she got inside the elevator. I don't believe she did.
That's my question. Did whatever happen between the two of you, did it happen inside the elevator at the point of entry?
But also, Cardi B didn't see that because she was walking away. She just said she felt her kind of following her. But so yeah, even her saying, I don't believe she got in the elevator, she wouldn't know that necessarily. But I'm just going off, I'd go off what Emani Ellis, what she's testified to, that she got into the elevator and then she herself stopped the door from closing and got back out of the elevator to quote unquote clarify whatever comment Cardi B had just made, whatever slick comment. So yeah, because that's another really good fact for the defense here, because it makes Emani Ellis here an active participant in this altercation. So you can't, here's the thing, in self-defense, not saying this is a self-defense case, but when we're talking about the principles of self-defense, one of the key principles of self-defense is called the initial aggressor principle, which basically says you cannot claim self-defense if you are the initial aggressor, if you're the person who created the situation in the first place. And so that's really relevant here, because if the plaintiff, Emani Ellis, if she was the initial aggressor in the sense that she got out of the elevator and she went and followed Cardi B into an altercation, or followed her, thus creating the altercation, I'm arguing that she is the initial aggressor all day long. So now she can't now claim self-defense based, or that she was now the victim or she got attacked when you're the one who created the situation, or at the very least, you're an active participant. And she totally was, based on her own testimony. So yeah, I would let that fact stand for what it is, though. As far as she got in the elevator and then got out and instigated the situation, yeah. Security guard commands are irrelevant. I read that the entire building was closed for Cardi B's privacy by the doctor. Huh. We'll have to see. I think the doctor does end up testifying on day 3, so we'll have to see what the doctor says about that. But yeah, no, the commands are irrelevant to the extent that they were not really within the scope of her employment here. Yeah.
Or outside the elevator?
Outside the elevator and down the hallway.
And when Miss Ellis was asked the same question, do you remember her saying that it happened outside of the elevator as well? Do you agree with her testimony?
It wasn't in front of the elevator anymore, because I was walking and she was following me. So it wasn't in front of the elevator. It was outside the elevator because I already got off the elevator. I don't think she ever went inside the elevator, because I felt her, as soon as I'm walking, I felt her walking right behind me. And then she said something. She said, "Oh my God, Cardi B." That's when I turned around And she got the camera right here, like she recorded me. And I'm like, yo, why you recording me? And she practically did admit that she recorded me because she said, oh, my bad. So.
And when she said, oh, wow, it's Cardi B, or whatever you just said right now, when she said that, was that offensive to you?
It wasn't offensive. I just kept like power walking so I could like avoid more contact. But she just kept following me.
Power walking.
And isn't it true that sometimes when you're walking around, different people will say, oh, wow, it's Cardi B?
Yeah.
Because they get excited.
Yeah.
And you had experienced that many times before you had that experience with Emani Ellis, correct?
Yes.
And the reason you didn't like it.
But this is not a helpful fact for you, Mr. Plaintiff's lawyer, because you're saying you're building out a situation here of this is something that normally happens, right? Yeah. Well, and guess what doesn't normally happen? An altercation where you get into an argument based on it. So what made this situation different than all the other hundreds, thousands of times where people in public are like, oh my gosh, it's Cardi B? You're begging the question of what was different about the situation, which now gives credibility to Cardi's side of things, and stating that what was different here was she was following me and she was recording me. So yeah, he thinks he's getting her with this of like, basically you should have just accepted or understood the situation, but he's just opening himself up completely for the defense to come in on their examination and just blow a hole wide open in that and make it seem like, yeah, there had to have been something different here that explains why this turned into the big blow up that it ended up turning up into.
From her is because she was a security guard and you felt it was unprofessional for her to say that to you.
When she first said it, I didn't tell her nothing. I kept walking.
Why couldn't she say it? Why?
I never said she couldn't.
Okay, and she said it to you.
She said it to me and I kept walking.
What if she was not a security guard and she was just a random human? And said, oh, wow,
Objection,
would
relevance?
you have taken offense to that?
No,
You can answer.
I didn't even feel offended when she first said it. I felt offended when she kept following me. She recorded me, and you're supposed to be a security. You're not supposed to be recording patients going to any doctor, any.
But again,
that's what offended me. When she first said, oh my God, it's Cardi B, I just kept power walking and didn't say nothing. I said something the second time she said it, and I turned around and I saw that she was recording me. And I'm like, yo, why are you recording me? Ain't you supposed to be security? And she said, oh my bad. Then she kept following me, and now I'm getting annoyed. Like, you're the security guard of the building.
No question pending.
All right, counsel, I think that might be a good time to end because we've got some things that we need to deal with outside the presence of the jury. Yes, sir. Ladies and gentlemen, we're going to resume right back at 9:30 again. Thank you for your patience today and your attention. We will see you tomorrow at 9:30. In the meantime, please do not discuss the case with anyone, including other jurors, not form any opinions or do any research.
All right, that's it for the testimony. We got a little bit more. It sounds like the judge wants to address with the lawyers. So we're going to...
Outside the presence of the jury, you can step down, ma'am. All right, so let's address the issues of Tiara Malcolm and David Finke as witnesses.
May I argue that after counsel does?
Yeah, so let me just make sure that...
So those two names, Tiara Malcolm and David Finke, are the two witnesses that were listed that Cardi B has now testified to and said there were two witnesses. It was the receptionist and the doctor. Pretty sure that's the two of them. So I don't know what they are arguing about right now.
We squarely get everything on the record in terms of what defendant's position is. And so defendant's position, if you want to summarize what you knew and when you knew it.
Thank you, Your Honor. Excuse me. As Ms. Almazar testified, she did not know the name of the receptionist. She did not know the name of the doctor that she visited that one day. In the January 17, 2023 discovery responses of defendant, she responded in a verified response that the potential witnesses included her, plaintiff, and unknown staff employees of the medical center building who intervened during the incident. There was no motion to compel that was filed against that. At that point in time, neither she nor her counsel knew the identity of the two individuals. There's actually another response where, I don't see it here, but go ahead, my copy of I'm not sure where it went to. Yes, it disappeared. Now I got it. Okay, so in Exhibit 1 to the motion, the supplemental motion that we filed, excuse me. She identified at page 10 Emani Ellis and unknown staff employees at Cedars-Sinai Medical Center, including at least two such persons who intervened during the incident. She described them, identified them as people who intervened, specific people, two people who intervened in the incident. And
so it sounds like the plaintiff is making a stink about these two witnesses being called, saying that they weren't sufficiently identified or they weren't relayed through discovery about who they were. But defense is saying, actually, we did relay who they were. We didn't know who they were, like their identity or their phone number or address, because that's what the interrogatory said. It's like, please list any witnesses as well as their addresses and phone numbers. And at the time that they received that, Cardi didn't know that. She just it was just doctors that these two people that were there that we don't know who they are. And so that's basically the defense's side right now is like, yeah, when that answer was given, that was a truthful answer because we didn't know who they were.
She at that point did not know their names. It was years after that she never had gone there again. Plaintiff's counsel did not move to compel. It did not file or serve a response to supplement discovery. Exhibit 2 is a comparable discovery response in January 7, 2023 that also referred similarly to the two by what they had done. At least 2 such persons who intervened during the incident. It was not until last year, last year we learned of...
Did you bring all your glasses today?
All right.
We added...
It was a good joke, but it wasn't that funny. You laughed for a little too long there, buddy.
Well, it's not until 2024 that we actually identified Dr. Finke, which was Moore's hard work. It wasn't easy. And we put Finke on the 2024 witness list, which is Exhibit 5 to the memorandum that we filed.
Okay, why don't you move on to Ms. Malcolm?
Okay, and Ms. Malcolm, she was the receptionist. She no longer worked at that by the time that the litigation had started at that medical center. And Malcolm's identity was only discovered on July 28, 2025, following further investigation by defendant's counsel. So then we talked about adding her to the exhibit list, the witness list, and she was added to our witness list. I think Counsel's looking at me like I don't know what I'm talking about, but I believe that she was put on our witness list. Yes. In July that we filed. There have been times when the court has referred to the defendant's witness list, which omitted her, even though they knew of her. Plaintiff's August 9. Oh, I'm sorry. They actually had intended to call these 2 people as well. They did not identify them by name, even though plaintiff worked there and knew these people. She knew who Dr. Finke was. He intervened. She knew who the receptionist was. She worked there. Plaintiff worked there as well. Their August 9, 2022 discovery response identified as witnesses, quote, employees of doctor's office located near the scene. Then also, plaintiff testified in her deposition, which is Exhibit 4 to the memorandum we filed, quote, she is going to be bringing forward at the time of trial people from the doctor's office. So these are people that she knew about. She didn't identify. We didn't know about it. We found it out on our own, and we promptly disclosed it. Again...
Well, and I guess that's the question is, what is promptly disclosed? You learned about it on the 28th. Did you call plaintiff's counsel and say, hey, we found her?
July 28, 2025 was when Malcolm's identity was discovered, and that's when we added the I think it was July 30th, when we filed, I could be wrong, filed...
I believe it was the following week.
The following week. And my colleague will put that out.
May I respond?
I just want to make sure that I understand the defense position. I don't see anything. I see the next witness list after that is being 820.
That's the one that I filed.
That's the one he filed. He admitted her.
Oh. I did not write her name there because I did not know about it.
Well, that's an issue.
And so how did you communicate Ms. Malcolm's name to plaintiff's counsel?
May I?
Yes.
Your Honor, we were providing drafts for this latest round of the trial filings, and as soon as we found out, we put it on the witness list, and on one of those drafts before they were filed.
And I'm asking, when did that happen?
I'm not sure. I know it was before August 20th.
Okay.
Go
ahead. Well, actually, let me first start. So, Ms. Ellis, you understand you're still under oath, yes?
Yes.
Okay. I have a declaration from Tiara Malcolm, and she states that you telephoned her approximately 2 months after the incident, and that you asked her for her assistance in pursuing claims, and she said she didn't want to get involved. And she said, quote, she told you, "You've got to be kidding me." Did that conversation happen?
Never.
Did you do anything to investigate your claims after the incident?
No.
Ooh, okay, we're gonna setting up the drama for day 3 when Tiara Malcolm comes and testifies, and presumably is gonna get asked directly about, hey, did the plaintiff ever reach out to you and ask for your help in pursuing the claim? And then she's gonna say, yes, she did actually, about 2 months after it, which lines up with the time she was filing her workers' comp claim. So that all happened about the same time. She was like, oh, let me put my case together. So completely makes sense that she would reach out to the receptionist. But now she's completely denying. She is outright denying that she ever reached out, tried to make contact. So that's going to be quite spicy come day 3 of testimony.
Okay. All right, go ahead. Mr. John Fawcett.
With respect to Malcolm, the first time I learned of it, I was given a partial document which only has about 50 pages. I was given it yesterday for the first time in the middle of...
It was on your joint witness list on May 10th of 2024.
What was it?
His name.
I'm talking about the Malcolm, not the name of the...
I'm sorry. Okay, go ahead.
Yes, Your Honor.
Okay.
So what I want the court to know is I've been intimately involved with this case. My office is located across the street, 9025 Wilshire Boulevard. As an officer of the court, I declare under penalty of perjury. I never walked inside Dr. Finke's office one time. I never gave him my business card. All that's written there is not me. It's not true. It is false. It is a mistake or false, not my problem. I'm just telling you this as an officer of the court. I will not damage my reputation with you for this small issue. I just want it to be clear.
Okay.
I never did it.
I think there's a perfectly reasonable explanation for this, and it might have been workers' comp counsel.
I don't think so. I don't know what it was, but it wasn't me.
Did she have an attorney in the workers' comp case?
I understand that she did, but not for this. They're not going to go after this doctor.
No, I understand that, but just to get witnesses to what happened.
I don't think, Your Honor, that that's what the purpose was. So,
okay.
Is there a need for me to argue more?
No, well, as to Finke, he was on the witness list in 2024.
May I finish? I'm sorry.
Sure. So why don't you address why you didn't want to do any of it? You knew who it was.
Okay, so I'll address it. Your Honor, I did spend a lot of time doing the opposition, and I tried to do the same thing with the witness, Miss Belcalis Marlinis Almanzar. Cardi B, she herself testified that she was able to get the doctor's name in a matter of a few days, or whatever it is.
So let's just focus on the fact that in May 10, 2024, you knew who this doctor was.
I did not know.
You knew he was on the witness list.
I don't remember being on the witness list. It could have been, but at that time, I believe you, Your Honor. So
it's hard to say that you're being ambushed or it's a trial by ambush or you're being hit with surprise witnesses when the witness that you're talking about was on the witness list, meaning the list that was filed with the court of here is the list of witnesses that we may call back in May of 2024. Talking about 15 months ago, a year and 3 months ago. Yeah, I don't know what he's exactly trying to argue here. Some sort of, surprise witness. But, and he's talking about, I will not damage my reputation with you anymore. It's like, yeah, because it's been pretty thoroughly dragged through the mud through this trial. Yikes, not looking good for plaintiff. Yeah, not looking good at all.
What I want to say to the court is, at that time, we knew we were not going to trial. It wasn't real yet. What was real was coming to trial now, in August. And in discovery, it was never produced. So if it was...
But you never sent supplemental rocks.
I understand. Okay. The point is, when they were responded to, the defendant could have easily gotten the name of Dr. Finke. She testified today under oath that it was her doctor. The same way plaintiff has to go and get the doctor's information in form rocks, so does the defendant. This goes against the Code of Civil Procedure. It's unfair, it's prejudicial, it's damaging. I wasn't able to depose this person. I get it. I didn't depose the defendant because she was out of state. But I did depose Dr. Rosenberg, and if there were witnesses to this case, I would have deposed them. Why not? So, first of all, Your Honor, with respect to Dr. Finke, my position is that he should not be allowed to testify for several reasons. Really, he didn't really see anything. He didn't. And it's really not that exciting.
How do you know that?
I mean, sounds like he did. Sounds like he was the one who went out and saw them in each other's faces and told Cardi B, come into the office, and basically dismissed the plaintiff, aka your client. So, and to validate witness name, he could have walked across the street from the office and asked the doctor himself. And yeah, that's part of the issue. Is apparently there's an allegation from the defense that he did go over and was trying to basically solicit information from the doctor's office and see what witnesses were there. And he's expressly denying that, saying, like, as an officer of the court under penalty of perjury, I never set foot in that office. And sounds like somebody did. So if it came out that it was like a PI that he had hired or one of his legal assistants that went over for him, and that way he just made this big declaration of, under penalty of perjury, I did not step foot in that office. Like Bill Clinton, right? I did not have sexual relations with that woman. And it's like, oh, you're playing fast and loose with the facts over there. But, yeah.
Because I know that. And we'll see that. If the court wants to allow him to testify, I'm open to that thought process because he didn't see anything. I really wouldn't care about him. But this random person, Tiara Malcolm, is a problem. Why? Because I wasn't able to take her deposition.
This random person? You mean the person who broke up the altercation between the girlies? What do you mean random person?
Cross-examine her. She was never put on any witness list. Even my own that I did on August 20th, when I filed it, wasn't there. The two individuals that I thought were the witnesses are Dr. Aziz Olai and Ms. Parsi. Those two people are on the witness list. This whole idea came about because counsel said, well, we shouldn't have Aziz Olai, we shouldn't have Parsi. And then I said, well, then I'm going to jump on the bandwagon too, and you shouldn't have yours. And that's why we're here today, Your Honor.
Okay, so let me refresh my recollection. I don't remember if we had a court reporter at the time. But at the time of our final status conference, there were discussions about this receptionist. I think there were discussions about you were actively engaged in trying to identify her, and you would inform counsel if and when you did. That conversation happened, correct?
Nobody informed me nothing. All I was given...
No, I'm saying at the time of the final status conference, that was a conversation that was had.
I don't remember it that way. I'm not that smart like the court is. I don't remember it that way. All I can say is it's inappropriate to be given a document in the middle of the trial with this court. The way that it is, it's super fast. The court doesn't want me to spend a lot of time asking people questions and actively doing a deposition. So I would submit that...
He doesn't want you asking stupid questions, asking objectionable questions. Yeah, he's going to shut down your lines of questioning when they fall outside the rules of evidence. You're not allowed to ask these types of questions that you're trying to ask. So, sorry, you can try and spin it into some sympathy play of like, well, this court wants me to move fast, but it's like, no, this court wants you to follow the rules. Plain and simple.
Just say for the record, I let people try their cases. I'm not going to let you waste the jury's time. Of course.
Exactly.
So my request is Tierra Malcolm is out because no one at any point called me, did anything to give me this information till yesterday when their attorney, Lisa Moore, who's not the main attorney, there's another lawyer here, he could have signed the declaration. I don't know why he did it. Why is she doing it? Everything's been done by Peter Anderson and Eric Lamb with all of his other attorneys that he has helped.
Well, I think she was the one with boots on the ground according to her declaration. But
yeah.
So let's. So we find out about her on the 28th, and I see the witness list on the 20th. So I guess my concern is the gap of period of time. Or actually, can you confirm, did we have that conversation that you were actively trying to find her?
That's my recollection, that she definitely came up. I don't recall if we had just found her or we were still actively trying to find her. Unfortunately, we don't have the back and forth. And for example, Mr. Lamb's... sorry. I think that was the name. If Your Honor likes, we can check to see when we actually sent the draft with her name to witness list with her name to counsel. He definitely did not just find out about her yesterday.
I'm sorry.
If I may. And so we can do that. We just can't do it here because we've got a lot of trial documents and not many discovery documents or drafts of discovery documents. But we can't submit that. I can tell you, Your Honor, that once we found her, and this is a woman, by the way, who's integral to the case that plaintiff has known about since day one, and counsel says his office was across the street, but he never bothered to walk across the street to find out her name.
I get why they want the receptionist thrown out. She stepped in between the ladies yelling. Exactly. The receptionist is going to have the best angle, best testimony of probably anybody in this case outside of the parties, of Cardi B and the plaintiff, which they're both, obviously, they're biased in the sense that they both are interested in the outcome of which way it goes. Receptionist has no interest. She has no interest either way of how the case itself is going to go. Her only interest is going to be to recall and testify truthfully. So... yeah, she's going to be a really important witness. So I think it kind of says a lot about her testimony and what it's going to reveal based on the two sides and which side is really wanting her to get in and which side is really wanting her to stay out. The defense is like, yeah, bring her in. Let's hear what she has to say. And the plaintiff is like, no, keep her out. So I think that says a lot about how the impact she's going to have on this case and the truth of what actually happened in this case.
Anyway, to make a long story short, we can provide that information. We can check if you like, but we did promptly disclose. I believe it was in a draft joint witness list that we had submitted. We submitted several as soon as we found her within a week.
May I reply, Your Honor? This case was set to be tried in 2024. It was continued over and over and over, and discovery was closed. This court did not reopen discovery. So this issue has been sleeping for at least a year, and it's unfair and prejudicial to the plaintiff to allow this random witness to show up at the eve of, not even the eve, in the middle of trial.
I think, let's be fair, you both identified people at the medical center. You both knew that these were people, I mean, your client testified that there was people that came out. So she knew that there were people that came out.
No, the two individuals that I have, these are people that know about the incident. These are not the two.
Plus, the plaintiff actually has better knowledge about it because she works there and she knows the people who work there, or she worked there. And so she would know by name a lot of these people. And in fact, from what it sounds like, she reached out to her just 2 months later, this witness, to try and get her to be a cooperative witness for her workers' comp case. And the receptionist basically laughed her out of the room at that point. So the plaintiff here was in a far better position to actually have knowledge and know the identities of the people that were involved in breaking up this altercation, way more than Cardi B. So I don't know where she's coming from, trying to argue that she just had no knowledge whatsoever, and this is completely unfair and a surprise that she's being called as a witness to testify. Like, I can understand being upset that you weren't allowed to depose them. I understand that's certainly frustrating, but you had the opportunity to depose in the sense that you could have initiated that. You didn't have to wait for the other side to put her on a witness list and call her to be like, oh, I didn't know that she was going to be involved in this. Like, you could have absolutely, on your own accord. In fact, why not? Why not get her side of the story and see if that's something you want to use for trial?
Two individuals that they're talking about. There was nobody at the scene till after the fact. So whoever these people are, they're not going to really say anything fair. And for them to drop it on me in the middle of the trial is unfair. If they want to bring Dr. Finke and he wants to say, I came out and I heard there was an altercation, I'm not too concerned about him. I'm more concerned about Tierra Malcolm. I have no idea who she is, what she's going to say, and that one has never been given to me. In this case, discovery's been closed for over a year. Why should she be allowed to testify? Doesn't make sense to me.
Your Honor, just very briefly.
Sure.
We've been asking, and counsel hasn't told us who this Farzi, I'm not even going to try. no offense, I just don't know how to pronounce his last name. And the woman, and we've been asking how they're relevant, given that Farsi, for lack of to avoid trying to name his last name, he's on floor 3. And he doesn't come in on Saturdays. He wasn't there. And the other person they identified as the receptionist at the building office, which is closed on Saturdays. The suggestion that the two people everyone's been talking about throughout this case who came out of the doctor's office for some reason weren't the doctor and the receptionist is just absurd.
Your Honor, he's testifying things he doesn't know. How does he know if my doctor and my his assistant were there on Saturday? How does he know that? If he can prove me that, I'll withdraw all my objections. He can't. He's just making up stories.
Well, absolutely. So I guess the question is, let's just talk about reasonable diligence. And so, defense counsel knew that the receptionist of the Women's Care of Beverly Hills was at least identified as a category of a person to be a trial witness, correct?
I believe so.
Okay. Did you do anything to try and figure out who that was?
There was nothing to do. It's a 6-year-old issue. I didn't know somebody could even pop up. Why would they? How could I get her on how?
Not going to cut it.
All right. And to what extent, if any, is it possible to get her deposed between now and Tuesday?
Well, Your Honor, it sounds like plaintiff is going to be resting tomorrow. We expect her to testify tomorrow. She also, she's out of town. Yeah, our plan is for her to testify tomorrow. And if it helps, maybe without the jury, she can give an offer of proof or something. Yeah. But we're talking about a 30-second incident. Yeah, did it? And by the way, he didn't take Dr. McKinnon's deposition. He didn't take, that proceeded without him because he didn't bother to show up. He didn't take the defendant's deposition. The idea that at this late point he gets to take a deposition of someone who he has known about and his client has known about since she worked there, I just don't see the fairness in that.
All right, let me do this. I know that Dr. Finke can testify and take it under submission. I know a little bit further into the Malcolm issue. I will tell you, I'm leaning, since the person was identified apparently for years, I don't think that it's an unfair surprise that she was finally identified. So that's where I'm leaning, but I'm not going to make that decision right now. So I'll vote tomorrow morning on the issue of the receptions.
And how about that position?
Well, I'll vote tomorrow.
Thank you, Your Honor.
All right.
9:30 tomorrow?
So I think there was a discussion at the final status conference regarding who was demanding jury, and I thought the defendant was demanding jury.
I assume plaintiff, we checked, plaintiff had demanded a jury.
I believe both sides.
I thought both sides.
Oh, okay. So I didn't realize that. We weren't counsel at the time.
No, I think it was the rest of the final status conference in terms of paying the jury fees.
Oh, I don't recall that at all. I'm sorry.
Is that an issue?
No, we'll split them.
Okay, all right. Fine.
My apologies.
Yes, exhibits for today.
Oh, exhibits for today. See, keep me on track. Are there any exhibits that were moving as evidence?
I believe there was one that Dr. Morgan's records and bills.
We already talked about it's 9 out of 28.
Okay. So defense counsel is going to look at, I'm sorry, was exhibit
9. This was 15 pages.
No, mine was in CV.
No, you're right. I apologize. Number 4, it's 15 pages.
I think we're just getting into some old exhibit set. Just want to make sure for the formality is met, the procedure is met, that the exhibits actually get entered into evidence.
Any objections?
If you can do with this just for a moment, Your Honor.
And also, he's going to give his ruling in the morning of day 3, as to whether or not he's going to allow these two witnesses to testify. Plaintiff feels like it's an unfair surprise. They shouldn't be allowed to testify. Defense is saying, of course, no, we've known about them for years. And the judge has taken it under advisement and said he'd give his ruling beginning of day 3, which we'll be covering tomorrow. Tomorrow, Monday, Labor Day, we'll be covering day 3, getting all caught up. Because, yeah, that's the last day of testimony.
He combined as a single exhibit multiple different pages and then referred to, like, exhibit 4, pages 1 to 3, then exhibit 4, some other thing.
Your Honor,
so it basically confused the
It's not confusing. I'm left-handed. I do perfection work. This is in perfect order. I think the court's left-handed too and would relate. This is in nice, perfect order. You have the medical records and then the bills. It's 15 pages. There's nothing more than that.
Oh, okay.
So pages...
Your Honor, I don't want to take up your time. Can we submit in the morning, for example, pages, exhibit 4007 has no relationship to the preceding exhibits.
All right. That's it. There's just more procedure, more formalities. Well, actually, let's see.
Admitted into evidence.
You're saying I get some rest, 9:30. I'm so tired.
I'm going to write that down.
Jury instructions were good?
Well, we've got the competing jury instructions.
Okay. Why don't you work on those?
Cool. Yeah, okay, we're all set with that. But cool. Alrighty. Well, yeah. Good job, everybody. My troopers out here. Let's see, how are we doing? So 4 hours and 42 minutes on this stream. Yeah, we stuck it out. We hung in there. That was good. I'm surprised. I really thought going into this, like, yeah, based on what I've heard so far, I could believe Cardi B did what she's accused of doing. Thanks, I missed this whole day. Now I'm all caught up. Hope you all have a great rest of the day. Thank you, Macrograms. Yeah, now, well, I know you're caught up now, but hopefully we still see you tomorrow for the big epic finale. I mean, day 3. I don't have a time yet, but I will be tweeting out when exactly that'll be starting. Also, if you're not subscribed to the YouTube, then subscribe and hit the notification bell, because that will announce when I go live. But yeah, that or being on Twitter, on X, that'll get you the notifications to stay caught up. But yeah, no, this is I was surprised. I really thought there was going to be stronger evidence from the plaintiff that Cardi B did what she is accused of doing. But really, the plaintiff's case is falling apart in real time. And I think the slow motion collapse will continue tomorrow with the final day of testimony. But part I caught was awesome. Thank you. Have a good rest of your weekend at Macrams and Gen Z Tournament. Thank you, Tara Isms. Yeah, it was I don't know how much you caught. I think it was right. Yeah, it was right when Cardi B came in and started testifying. So, yeah, and that's the best part of this whole trial for sure. That's the reason I wanted to cover it myself, was her testimony looked really fun. And also, they said this trial was expected to take 2 weeks. And the fact that it got done in 3 days of testimony, awesome. Love to see it. Means I can cover it truly from start to finish and not miss a beat. So, yeah, so anyway. Okay, well, it should be the afternoon. That'll be my guess. Probably around the same time, like maybe 1 or 2 o'clock Eastern, when we're going to get spun up on the final day of testimony. So I guess just y'all anticipate for that. But if anything changes, then I will let y'all know. But for then, I'm going to go get something to eat because I'm hungry. So appreciate y'all for being here once again. Really means a lot. And I look forward to seeing you all on the stream tomorrow. So adios, muchachos.